Good morning. This school board operational meeting of the School Board of Broward County, Florida is now called to order. All please rise for the Pledge of Allegiance to the flag of the United States of America. This morning we have Ms. Tanya Frost, principal, and the students of Bayview Bunch Summer Camp who will lead us in the Pledge of Allegiance to the flag of the United States of America.
Good morning, everyone. Good morning. Welcome to Bayview Bunch Summer Camp. These are my new friends, and we're happy to lead you in the Pledge of Allegiance. Join me in the Pledge of Allegiance, guys. Put your hands up your head. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you all for having us. Have a wonderful morning.
Thank you all. That was wonderful. Have a great day. So, you know, school's out for summer, but we do have some kids in Bayview Bunch Camp, and I thought that would be a great way to start our Tuesday morning. In order for the meeting to operate within an appropriate professional environment, at this time it is respectfully requested that all cell phones and other electronic devices be either turned off or put into the silence mode. Ms. Good has requested a moment of silence for a student from Coconut Palm Elementary School. Mrs. Good?
Yes, thank you, Madam Chair. Regrettably, we had a young 6-year-old student from Coconut Palm killed over a drive-by shooting, and I just want to extend our deepest sympathy to his family and that of the Coconut Palm family. So if we can just have a moment, please. Thank you, Madam Chair.
Thank you. Mrs. Rich Levinson has requested a moment of silence for a student who graduated from Nova High School. Mrs. Levinson?
Yes, I'd like to request a moment of silence for Camila Vasquez. She was a Nova High School graduate. She just had graduated, who passed away in her sleep the night after her graduation. She always had a smile on her face and had the ability to light up a room wherever she went. She had aspirations of becoming a nurse and will be dearly missed by all who knew her. Thank you.
Thank you, Ms. Levinson. And on behalf of Ms. Rupert, I would like to request a moment of silence for 2 students from Liberty Elementary School who were the unfortunate victims of drowning. So if we could please have a moment of silence for those 2 students. Thank you. May the chair have a motion and a second to approve the minutes for the following meetings: May 21st, 2009, special expulsions. Moved by Ms. Good, second by Mrs. Alhadeff. Is there any discussion? All in favor of approving the minutes as listed, say aye.
Aye.
Those opposed say no. The minutes are approved. Mr. Runcie, are there any changes to the agenda?
Yes, Madam Chair, we have the following proposed changes to the agenda. For speakers, Sheila Latham, Goldie Fenster, and Tim Anderson are all withdrawn. Board items, G2, personal recommendations for instructional separation of employment or discipline for the 2018-2019 school year revised. G3, personal recommendations for non-instructional appointments and leaves for the 2018-2019 and 2019-2020 school years. Second revision. CC3, proposed new job description for manager, District Security Operations Center position revised. CC4, proposed new job description for the Protective Research Analyst position revised. CC5, proposed new job description for the Trainer for Safety, Security, and Emergency Preparedness position revised. CC6, proposed new job description for the Data Analyst, Safety, Security, and Emergency Preparedness. CC7, proposed new job description for the Specialist Enterprise Risk Management Communications position, revised. CC11, the School Board of Broward County, Florida, 2019-2020 organizational chart descriptions for the Division of the Chief Portfolio Services Officer, revised. EE23, recommendation to approve agreements, school resource officer program for extended school year 2018-2019 revised. EE27, recommendation to approve Second Amendment and renewal with Broward County Naturescape Program revised. And II1, School Board of Broward County, Florida, 2019-2020 organizational chart is revised. Madam Chair, we have no further proposed changes to the agenda.
Thank you, Mr. Runcie. And before I announce whether or not I accept the changes, I just want to check with Mr. Moquin and Dr. Neesmith. So all of these changes, with the exception of, I think, the two that were distributed on 6-7, as indicated on the yellow sheet, all of these were Scrivener errors within the items, correct?
Good morning, Ms. Chair. Yes, that is correct.
Okay, so I just wanted my colleagues to know that I asked that they not bring any substantive changes at the dais, but because they did call me and said there were some Scrivener errors in some of the items, I felt it was incumbent upon us to go ahead and change them as soon as they knew that those errors occurred. So I don't want you to think that you've just been given a pile of brand new things to read. And I just wanted to make that comment before I say the changes to the agenda proposed by the superintendent are accepted by the chair after being determined that good cause has been established for said changes. May the chair have a motion and a second to close the agenda? Second. Moved by Ms. Good, second by Mrs. Olive. All in favor of closing the agenda say aye. Aye. Those opposed say no. And let me just check really quickly. Ms. Korn, are you on the line?
Yes, thank you.
Thank you. The school board will consider agenda items in the following order. The school board will first identify any consent items, single letter items on the agenda that will be pulled for separate discussion. All remaining consent items that were not pulled for separate discussion will then be approved by consent. The school board will next consider G3, followed by any other G items that were pulled from the agenda for discussion. After the G items are considered, the school board will proceed in accordance with the agenda's lettering system. The school board will consider any consent items, single letter items, pulled for discussion for a given letter, and then consider any open items, double letter items, for the same letter. The meeting agenda has been modified to correspond to this order. The next item of business is the consent agenda. This is the time that board members advise the chair of those items they wish to address. Subsequent to this, the chair will ask if any members of the public would like to have an item pulled, which has not already been pulled by a board member. All of those items not pulled for separate consideration will then be approved under the consent agenda. For the following consent items, are there any board members that would like to discuss? G3 is automatically pulled. Are there any other G items a board member would like to discuss? Mrs. Alhadeff?
G5.
G5. Ms. Rich Levinson?
G4 for comment.
G4. Ms. Bartleman?
Which is the one that renews all of the, because I have my papers all over, which renews all of the positions, the annuals? It's not on this agenda yet? Okay, all right.
Any other G items? Anyone from the public? Oh, I'm supposed to do that at the end. Any E items? Any, yes, single letter E items. Oh, you know what? I need to look at my own agenda. Ms. Bartleman, did you have one that you needed to pull? No. Okay, so I will let you know, Ms. Rupert, through her administrative assistant, indicated that she would like to pull E4 and E6. And I have a question on E1 and E2. Anyone else for an E item? F items? I have, Ms. Rupert has indicated she would like to pull F2. Anyone else for an F item? Okay, I items? Ms. Levinson?
I1.
Ms. Bartleman? I5 for Ms. Bartleman, I1 for Ms. Levinson. I have a comment on I5. Yes, I have Ms. Bartleman for I5 and myself for I5 and Ms. Levinson for I1. Yes. I-5 for Dr. Osgood. Any other I items for my colleagues? Okay. J items?
Ms. Brinkworth?
Yes.
Can we lump J1, J2, J3, J4, J5, and J6 together?
So you would like to speak to all of those items?
Yes.
Okay. Not 7 and 8, though?
No.
Okay. Anyone else for J items? K items? L items? Yep. Just for everyone out there, it's quite an extensive agenda, so I'm giving everyone plenty of time to look through the pages. Okay, is there anyone from the audience who would like to speak to an item that has not already been pulled for separate discussion? Please come to the microphone and say what item it is. State your name.
Yes, good morning. My name is Dagoberto Magana, I3.
I-3?
3.
I-3. Thank you. Any additional audience member who would like to pull an item for separate discussion? You can have a seat, sir, and when we get to your item, you'll be able to speak on it. Thank you. Okay, let me make sure that I have. At this time, may the chair have a motion and a second to pass the consent items that have not been pulled for discussion?
So move. Second.
Moved by Dr. Osgood, seconded by Mrs. Alhadeff. All in favor of approving the consent agenda?
Aye.
Aye.
Those opposed say no. Thank you. At this time, will board members please identify the open items that you will be asking questions of staff? This will better manage staff's time by letting them know which open items we intend to address. GG items. Those are special order at 10:45 this morning. CC items.
CC one?
Brinkworth?
Yes, Ms. Korn, I have you down for CC 1, 2, and 3. Is that correct?
Yes, thank you.
Thank you. Yes, Mrs. Alhadeff?
CC one?
CC 1. Mrs. Levinson?
CC1. And are we gonna, the job descriptions that go with the org chart, I'd just like to request that we do those at the same time.
So your request is that we pull all of the job descriptions with the org chart?
Well, I'd like to do II1 first, because it's contingent upon whether all the positions are passed before we do the CC items that pertain to the org chart.
Okay.
So we'd be talking about CC3 through CC12.
Okay. Yes, Ms. Murray. CC1 for Ms. Murray. Yes, Dr. Osgood, CC1 also. Ms. Bartleman, did you have your hand up? Okay. So, Ms. Levinson, if you could, did you say what the number was? I wrote it down.
Yes.
3 through 12, correct?
CC3 through CC12, just to hold until after
Right.
II1.
Any DD items? DD3 for Ms. Bartleman. Yes, Ms. Good? DD3 for Ms. Good. Oh, I had CC items, I apologize.
I have DD as well.
I have CC2. CC 11, sorry. Yes, 2 and 11. And I'm sorry, for DD, I have DD3 for Ms. Bartleman, Ms. Rupert, and Ms. Good. Yes, Mrs. Aladev?
DD3?
DD3? Yes, Ms. Levinson?
DD 1, 2, 3, and 4.
Okay. Anyone else for DD items? EE items? Okay, Ms. Good?
EE 23 and 27.
Ms. Levinson?
I have EE1, EE6, EE7, EE8, EE10, EE12, EE14, and EE15.
Okay, Mrs. Aladev?
EE6, EE7, EE11, EE18, EE20.
Ms. Murray or Dr. Osgood, do you have any EE items? Ms. Bartleman?
EE10, EE17.
Can you do recap?
I will. Let me,
Ms. Brinkworth, EE 23.
EE 23 for Dr. Osgood. And I have EE 7. EE 15.
Ms. Brinkworth, can you
Yeah.
include me for EE10?
EE 10 for Ms. Corn. I did not have that one. I will mark it down. Thank you. I had that one. No, I mean for Ms. Corn. Okay, so I'm going to review really quickly. EE1, I have Mrs. Levinson. EE2, I have Ms. Rupert. EE6, Levinson and Alhadeff. EE7, Bartleman, Levinson, Alhadeff. EE8, Levinson. No one for EE9. EE10, Bartleman, Corn, Levinson. EE11, Rupert, Alhadeff. EE12, Levinson. EE13, Rupert. EE14, Levinson. EE15, Brinkworth, Levinson. EE17, Bartleman. EE18, Alhadeff. No one for EE19, EE20, Rupert and Alhadeff. No one for 20 and 21, 23, Good and Osgood. No one for 24, 25, or 26. It's good for number 27, and no one for EE 28 and 29. Anyone for the FF items? There's only one of them. I have, Ms. Rupert has indicated she wants to address that item.
Which one?
FF1. II1. Ms. Levinson. Ms. Alhadeff.
II1?
Yes. Anyone else want II1?
Yes.
Ms. Bartleman, I will have a comment on II1 as well. Yes. Dr. Osgood, sorry, I turned the page too soon.
Oh, myself also, I'm sorry.
And Ms. Good?
My apologies.
That's okay. And then the JJ items. Okay. Ms. Bartleman, 1.
Microphone, Ms. Bartleman.
7, 10. I'm going through now, hold on. 11. And I guess 12, because they're the same. That's fine.
So Ms. Bartleman, 1, 7, 10, 11, 12.
Yep.
Anyone else?
On the JJs?
On the JJs.
Yes. Hold on one second. JJ 12, did have a question, Madam Chair.
Yes?
So some of the questions are related to safety. So I just wanted to get guidance from yourself or from our attorney as to when can we have those kinds of conversations? I know that there's an issue regarding specifics regarding what is being done at any particular school, so I just wanted to get guidance.
Thank you, Ms. Good. And I did ask Ms. Myrick and the superintendent and Mr. Moquin with regard to this particular item and any conversation that might happen, and ask that if there are questions from my colleagues with regard to specifics, that we do need to have a closed door for that. So, Ms. Myrick, I don't know if you want to give any further.
No, that's it. So if you have general questions, that's fine, but if there's specific regarding individual schools or whatever, then we would have to have a closed door.
So,
Yes, Ms. Murray?
Yeah, you're moving too fast. J2.
Okay, just one second. Let's finish. I'm sorry, I thought you had a comment about this. When I discussed it with the facilities team, what I thought might be a good idea is that we have general conversation about the items in the public first, and then have the closed door conversation. My concern was that we would inadvertently say something that we were discussing in the closed door in the public if we had the closed door first. So that was my only concern. Yes,
Well,
that's good.
I guess for me, I need to have the closed door conversation first to
Okay.
determine how
Okay.
I will ultimately vote on any particular item, but I just think the clarification needs to occur first for me personally.
Okay.
And that's not the only item, there may be others. So I don't know if maybe before we take the JJs, we can have
Yes.
I'll review them. I'll review them.
Okay. The
Again.
JJs in their entirety, or JJ 10, 11, 12?
12. 10, 11, and 12.
that would be my suggestion.
Okay, so we're looking for JJ 10, 11, 12 to have a closed door, to have the conversation about security prior to those items. Okay, and so now let's go back to who's wanting to speak on the JJs. I have Ms. Bartleman for JJ 1, 7, 10, 11, 12. Anyone else for the JJ items? Ms. Murray? JJ 6, I apologize.
And I missed,
Use your microphone, please, Ms. Murray.
I missed one on J. J2.
J2 for Ms. Murray.
So do you have me down for 12? I would ask that you include me on 10 and 11 as well.
Okay. Ms. Good. Ms. Good is asking to be indicated for speaking on JJ 10, 11, and 12. And I have several JJs myself. Does anyone else have JJs before I indicate which ones are mine? JJ 2. Oh, thank you for that. Hold on one second. JJ, for me, JJ 2, JJ 10, 11, and 12. Anyone else for the JJ items? I didn't have a chance to check all of those on mine that had passed on consent, and Dr. Neesmith just came and reminded me that J2 passed on consent. So,
Okay.
No, somebody pulled it. Ms. Aladaff.
oh, I'm sorry. It did not. Okay. Thank you. Dr. Neesmith whispered in my ear that it passed on consent, and I haven't checked them yet, so, thank you. All right. No, it did not pass on consent.
It was a test,
It was a
if
test.
we were paying attention.
Yes. Oh, and I also had a question on JJ 7, and I apologize.
JJ?
JJ 7, yes. Anyone else for the JJ items? Okay, and LL, we're almost there, I promise. LL items? Yes, Ms. Good?
LL3?
LL3 for Ms. Good. Anyone else for the LL items? Yes, Ms. Murray?
LL1.
LL1 for Ms. Murray. Anyone else? Okay. May the chair have a motion and a second to consider G3?
Move. Second?
Moved by Ms. Good, second by Ms. Rupert. Audience input on G3.
Oh, I missed this one.
Good morning.
Morning.
My name is Lisa Maxwell.
I'm the Executive Director for the Broward Principals and Assistants Association. And I've been working with the superintendent and the staff. There was some additional language that was added to the item for some of the individuals that talked about a 6-month re-review of salary. That is really not what we've done or do. These are annual contracts, and I would hope on behalf of the employees that their salary would be understood and set when you approve it for the year, and that they don't have to worry about in 6 months somebody re-reviewing and perhaps reducing their pay. So I'm asking for consideration today for that language to be stricken from any of the individuals that it is associated with. And then my second question, just for clarification, is to make sure, for the record, that because these reassignments are happening now, and they're actually being reassigned in 2018-19, that for purposes of 2019-2020, they are going to be eligible for the raise. You haven't passed the raise yet, so you will today, but I want to be sure that they are entitled to that raise, and that upon its passage, they would then automatically move to the newly approved schedule and the newly approved ACEL raise package that you're about to approve today. So those two items, I would just ask for some clarification on today, and voting to eliminate the 6-month issue. Thank you.
Thank you. Any additional comments from the audience on G3? Okay, I have my colleagues, Ms. Levinson? Is this just a question? Because I have some of my colleagues that indicated before that they wanted to speak as well.
You're on G3?
Mm-hmm.
Yeah, I mean, I can go after whoever else. I need to speak on G3.
Okay, okay. I'm sorry, they indicated that they wanted to speak. I have Ms. Korn on the line.
Yes, thank you. If we could, I actually spoke to Mr. Chisholm over the last couple of days and was wondering if maybe he could share with the board an intention that staff has, how this has been handled in the past, and what we're looking to do over this next 6 months in the event we proceed the way it's been brought forward. Is Mr. Chisholm able to share some comments?
Good morning, Eric Chisholm, Director of Talent Acquisition and Operations, Non-Instructional. Happy Tuesday. So I have Rose Hall here, our Compensations Director. Thank you, Ms. Korn, for the question. And when Ms. Korn and I spoke, we spoke a lot about how we've executed this process previously as it relates to the salary handbook. This is very unique with the number of principals that we have at this point. We've most times had more of demotions, specific demotions that have come to the board, and that was very clear. It would say 6 months. Basically, the handbook would speak to the 6 months because it was a demotion. But in these cases, these are reassignments. So Ms. Hall is going to give us some information on specifically what we would traditionally do with the employees and how we need some guidance, additional guidance around the plan document the way it's laid out.
Thank you. Rose Hall, Director of Compensation and HR Support Services. The plan document that governs how we compensate principals assigned to the pay for performance schedule is entitled ACCEL, and that plan establishes base rates based on school quartiles or the size of the student population. When a principal or assistant principal moves from one school to the next, their base salary is driven by the plan document that establishes pay based on the quartile. This plan was put in place in 2014 before I arrived. I've been in works with Ms. Maxwell as well as Dr. Wanza to look at how this plan is designed. I believe that it needs to be restructured, and we are actually in the process of doing that. But as it stands now, when a principal or assistant principal assigned to the pay for performance schedule changes schools, depending on that change, their base salary will be adjusted based on the size of the student, the size of the school, or the quartile assigned.
Ms. Korn, do you have additional questions? Does that answer your question?
Well, I guess what I was speaking to, so thank you, staff, is that the work that's being done is intended to be accomplished in this next 6 months, which would then be able to move us to a place where I think it's been 7 years now we've been working with basically this static document, and it hasn't been updated, and it's put us in this position. The reality is that this, at least from what staff has shared, this has been occurring each time we've made these reappointments. But it's never been brought forward in this way to the board. It's always just been handled by staff once the reappointments occur. But as it's being brought forward in this manner, or the way at least it's being presented, we obviously need to have it addressed. And Mr. Chisholm, when I spoke with him, shared that they intend that this is going to be done within the next 6 months. I completely understand the concern going forward where a principal would be taking a new position and would not be aware of what their salary is going to be. And so they're basically taking a position without any knowledge of what their salary will be after 6 months. For those who are grandfathered, that actually is not the case. It's only up for principals who are in this pay for performance that are kind of in this quandary. So with that said, I have asked if we pass this item, that Mr. Chisholm and Rose, that they basically come back to us prior to the 6 months so that we're apprised of what these changes to Excel are and how they're going to affect our principals going forward.
And just to Ms. Korn, either Dr. Wanza or Ms. Marte, I think, may be coming up. That is the agreement. We've been in conversation with Ms. Maxwell, Ms. Marte has, and Dr. Wanza as well. So the commitment, I know Rose has already started a great level of that work because it has been a unique challenge. So we are looking forward to resolving it.
Perfect. And then to the other comment that was shared, I am under the assumption that when the raises occur for the rest of the staff, that these reappointments, or these appointments actually, will be applicable to that raise. Is that true, Ms. Marte? Is that what you anticipated?
Through the chair, yes. How did you know I sat in the seat, Mrs. Korn?
Called your name.
Oh.
I could feel you from there.
Madam Chair, if I may, I'm hopeful that the way to make the item less ambiguous for all parties involved while we work through the process of making the intent of the handbook clearer for both BPAA and the administration, because there is ambiguity, which is why we're having this conversation in the first place. If the board would allow us to strike the language around it, a cell, take it out of the item, and pass the item with the names and the transfers and the reassignments. And yes, to clarify, they are absolutely eligible for the 2%. And then we would report back to the board within the next 6 months when we all sit down and get clarity around what was the intent of the item. Because as we went through this the last several days and questions were raised, quite frankly, we couldn't come to consensus. So that will correct the item and make sure that staff is treated appropriately and that we can get people in their seats for July 1 as they need to be to get ready to start next school year. So just strike
Thank you, Ms. Marte. So I would like to make those two motions individually, independent of each other, but I'm happy to wait for my colleagues to speak if that's what they prefer.
Thank you, Ms. Korn. I do have several of our colleagues that are looking to speak on this item. So I think we should allow them to speak first, and then we'll provide the opportunity for you to make the motion if you'd like.
Thank you.
Thank you. Ms. Rupert? Ms. Levinson?
Yes, thank you for that. I had similar concerns that I had also mentioned to staff. I feel I need to comment on one of the swapping of the principals that is happening here, and make it very clear that I've been advised by our attorneys that you must have good cause for rejecting a superintendent's transfer recommendations. And although I personally don't agree, I feel there are very strong reasons why it shouldn't be. I am not able, as a school board member, to vote against it. And I'm going to cite the case that was given to me, McAllister versus the School Board of Bay County, 971 Southern 2nd, 1020, First District Court of Appeals, 2008. Thank you.
Thank you, Ms. Levinson. Ms. Good?
Yes, thank you, Madam Chair, and thank you, Ms. Korn, for your comments. I think that based on the documentation that was shared with us, and there are some major changes with salaries as it pertains to some of the principals. So I would ask that, and you made a comment that that salary, according to what you currently have in place, is based on adjusted population from one school to the other. I don't know that I'm following that based on the principles that are being changed. I'm just going to make the comment. So
No one's salary changes for 6 months. So through the chair, Ms. Good, so what we're asking is, all of the candidates in front of you, their salary is held for 6 months. That's standard in the handbook, what happens. What we're asking is that we continue that practice, so everybody here in front of you, their salary would be the salary they have today plus the 2% raise going forward for the first 6 months. And in that time, we sit down with BPAA, iron out the ambiguity around a cell, and the question you're asking is related to that, and report back to the board prior to the expiration of that 6 months so the board can see what the outcome was and take another vote as to their acceptance of that outcome and a long-term plan to clear up this ambiguity.
And so what happens if, at the end of the 6 months, the principals that may have chosen to go to a different school made that decision based on what they felt they were going to be accepting as a salary? So I tell you, I have a concern as far as, I'm always about process and about consistency. And so I just want to make sure that, A, we do have a formulated process in place, however it's worked out with the respective unions or bargaining groups, and that it be written and that conversation be held with this board so that we have a clear understanding of when principals choose to go to a different school, how that salary is going to be adjusted. And I think those kinds of conversations have to happen sooner than later. So, and maybe we haven't seen it to this level because of the number of applicants, but I think it's important that I'm being very careful in my words.
Mm-hmm.
I think it's very important that that conversation take place. I also need to say that as a board, we need to have a greater conversation about when principals move from one school to another, the ability of that individual to, I'm just going to use this word, simple, take certain, or recruit, maybe is a better word, recruit staff from their current school to go with them to their new school. And I really don't know if there is an opportunity to have conversations about limitations, even if it's allowed to occur. But I will tell you that the opportunity for a principal to recruit from their existing school and take a great number of individuals to their new school impacts their existing school. And it's an impact that has great consequences. I want every principal to be successful no matter where they go. But at the same time, I don't want it to be at the expense of the school that they're leaving. We have to be cognizant of the fact that we want all our schools to be successful, and I support that opportunity. And I just want to make sure that it's all schools. And so I needed to make that statement. Thank you.
Thank you, Ms. Good. Dr. Osgood, I see you, Ms. Murray.
So when I'm looking at this, and we have had a practice in the past, correct? We've done, moved principals around,
Yes,
I know,
ma'am.
since I've been here.
Yes.
So if we're going to change something and do something different, I don't think the dais is a place to figure it out. I think we figure it out in a workshop so we can properly communicate to people what their salaries are gonna be. I am not at all for going back and forth with people's money like that. Because if they have their kids and their families, they're basing their budgets and their livelihood on the money that they are expecting to receive. I've never heard of this 6-month ordeal. If we have principals in certain schools, I know I had principals in schools in my district that were low-performing schools, and those principals had contracts and certain contractual arrangements for them being in those schools. I expect for us to honor those contracts. If they move to other schools, then we need to do what we have done in the process with that. We can't just change things midstream without thinking through it thoroughly, because at the end of the day, I don't want to fracture any member of our team in their ability to make decisions for their family in a yearly perspective based on the money that they earn. And I'll just say, I know that government works in a certain way, and if I'm looking to move from middle school to high school or whatever, you know, I'm not a proponent of that I can only make 2% or whatever. Because sometimes the change in my workload or my responsibility warrants more than that. But I know that we have those policies and those systems in place, and sometimes I think it hurts us and it kills morale with people wanting to take an opportunity to move to the next level or to try to enhance themselves as a professional, because we're so restricted in the amount of income that we will allow them to earn. So when I looked at this item, I really didn't understand the 6-month ordeal. I thought it was something, you know, maybe somebody knew or something was typing and they just added this language. But I think that whatever we agree to someone with for their job is what we need to honor. And if we're working out a policy, we need to work that policy out and then come back at that point and use that policy going forward. I think it's very unfair to put something in place for people midstream like this and say in 6 months we're going to come back and do something. So now I'm leading a school for 6 months, and I'm stressed out about what my salary is going to be. My focus is not going to be 100% on leading that school, because I don't know if 6 months my salary is going to be cut or changed in some way that could be a deficit to me and my family. So I just don't think it's a good business practice. I don't think it's fair for team members to operate in that way. I think, as Ms. Good said, we need to have a better conversation about expectations. When it comes to staff, you know, some of us work better with certain people, but we certainly don't want to leave a school at a major disadvantage because half of the staff leave. But I think those are things that we need to come together as a board and set a policy, or at least speak to our expectations so that staff can then go implement. Sometimes I think we have these things backwards, where staff, you're doing the best you can and you're trying to get things done and make decisions in a way that you feel it should align, but you have to allow the board to give input and to lead, because the board may have a totally different perspective, as you're hearing us state today, and we didn't have an opportunity to discuss this. And I'm certainly not going to ever be in favor of not being fair to someone when it comes to their money and their compensation. And I think to have something on here for 6 months puts us in that situation. So I heard Ms. Cohen say she's prepared to make a motion, and I'm prepared to second that motion, because I just don't think it's right to have this in this way.
Madam Chair?
Yes, Ms. Marte.
Point of clarification. Through the chair, Dr. Osgood, I just want to, if I wasn't clear, I apologize. It has been the practice of this district that when a principal transitions to a new school, their salary is held at the current rate for 6 months. Unless they're getting an increase, then it goes up. So if a principal's taking another assignment, at a school, that 6 months hold is the tradition as a transitional salary.
Through the chair. So if a principal goes from a elementary school to a middle school, we pay them the same salary?
No, no.
We do not.
Oh, okay, don't make me pass out.
No.
We do not.
Okay. That's the point I'm making. If a principal is advancing, I can go for that if they're going from one elementary school to another, then I get that.
Yes.
But if we're going from one level, from elementary to middle to high,
You
I
understand.
expect for that, okay.
Thank you.
You understand.
Dr. Wanza, did you have a comment?
Well,
Dr.
I'm
Wanza?
Valerie Wanza, Chief School Performance and Accountability Officer. Good morning. I just wanted to make a clarification. Principals who are on the grandfathered salary schedule, this does not come into play. This is specific to principals and assistant principals who are on Excel. That's why you don't see that language on every single school administrator's name. So this is specifically to the principals who either were on the grandfather schedule and elected to move to Excel, and then on that 2014 date, all principals appointed as new administrators beginning that day automatically went on Excel. So I wholeheartedly agree that we need to have a comprehensive conversation about compensation, because it is two different.
Through the chair?
Yes.
And what would be helpful for me as a board member is when these things come up, that we put on there if it's on the grandfather, if this principal's on the grandfather schedule, if they're on Excel. But no matter what schedule they're on, I want them to be treated fairly when it comes to their money.
Thank you. Mrs. Aladeff?
Thank you. Mr. Runcie, could you please give clarification on your recommendation of reassignment of Ty Thompson?
Yes, Ms. Aladeff. As you know, we've assigned a new principal to Stoneman Douglas, which is on his agenda. Mr. Thompson is being reassigned, essentially to perform some other duties, working under the Office of School Performance Accountability, and specifically an assignment within Leslie Brown's shop, working with the athletics department on some projects. That's something we have done and do regularly with principals in the system. I think there are a couple other similar type of assignments on the agenda today. So that's where we are. I think the second part of your question is probably related to the status of the investigations that we're doing. Now those investigations are continuing. They're on track, as we'd indicated, to complete them by the end of the school year. I got an update from our legal counsel, Ms. Myrick, last week on this. After the conclusion of the review, it will then go to our Professional Standards Committee. That committee will review the information presented in front of them, make a recommendation to my office, and then I will review that and present that to the board.
Thank you.
Thank you, Ms. Aladeff. Ms. Murray?
Yeah, I'm just going to go back to the principal assignment. This becomes a very complex issue, because in talking with some of the principals that moved around, some have asked for this change. And change is always good. You usually grow from change. And then there's others that have been being moved for various reasons. But I want to go back to some of the history in the system. At one time, there was a policy, and it probably was in the 60s and 70s, where a principal could not stay at a school more than 10 years. And the only person, if they moved, the only person they could take with them was their secretary. But, I've seen that change, but the situation within the system has changed. The superintendent, and this goes to the previous superintendents, have negotiated with principals to change schools simply because they showed an ability to be able to move a school that was either performing poorly and could do that task. And In many cases, they took a lot of staff with them because to be successful, they needed a team to be able to move that school at a rapid pace. So, like I said, it's become very complex. But as Ms. Mate said, that we need to look this over. We really need to, because like I said, principals have the right to ask for a transfer and try something different. It's called growth. The superintendent has the ability to negotiate with principals to move schools because their ability has been identified to be able to help a school that meets their qualifications. So again, it all comes to the policy. And it seems like we've skirted a lot of things to be able to resolve something. And when we think we're fixing one situation, we've created a new situation. Every change you make, there's always going to be a new situation. But again, it all boils down to policy. And again, you know, I've never heard anything where a principal's salary has been frozen. I mean, anytime anybody moves, you figure it's for the best interest of the system. If we're moving principals because of poor performance or moving them for whatever reason, then that's a problem for the superintendent that I question, because if we have someone that we're moving or changing because people are dissatisfied with their performance, then, you know, I don't necessarily believe that we should flip-flop on anybody or changing their position and giving them to somebody else to go through the same pain. So it really, it takes a lot of, and again, that boils down to evaluations and performance. So, you know, unfortunately, we have a lot of principals that are being moved for various reasons. I know that some have moved because they want to change. And others are being moved because that's the recommendation of staff. So it's created quite a headache for the community. It's created a headache for us because we all have certain loyalties to our principals. And if it's tied to growth, then amen, I'll vote for that. But if we're just moving people around because of issues that exist, then, you know, I really have to put the pressure on the superintendent that we do not do this. So, one, I'd like to see the policies, because we have Title I schools, we have TIP schools, we have all sorts of situations that we're moving people around for the betterment of our children, and I'll always support that. But if we're moving people around just to move them around, then that's an issue for me, and I think it really needs to be locked down in policy. How we do it, how we do it, what the salary scale is. I don't think anybody's salary, you know, we give perks for principals to go to certain schools. If they give up that school, then they realize that they give up the perk, the extra monies. So there's all sorts of different situations going on here, and I think it's getting complex, and we get the sympathy of the community, and people don't have all the facts, and it really makes it, like I said, reflects upon our ability to manage and vote upon these things. So I think, again, you really have to develop a policy, a complex policy, because we have become very complex in how we operate. So again, in fairness to everyone, and to make sure that the information that's given us as we vote for these changes, that we're doing the best, serving the best interests of our children, not personalities. Thank you.
Thank you, Ms. Murray. Ms. Bartleman?
Yes, so two things. Number one, after speaking with Ms. Maxwell, it's my understanding that we haven't done a change like this in 7 years. So for me, I will support letting them keep their salaries for the year while we discuss this, and then we will look at it next year, because it's unfair to change someone's salary 6 months in because they don't know what we're going to decide in 6 months. So is that what Donna's motion is? To my understanding, we're going to keep them for a year? Keep the salaries for a year. They want to do it for 6 months. I want to do it for the school year.
No, that's not what was asked. What was asked is that there be a conversation with the board prior to 6 months to review the existing salary handbook that governs how these salaries are adjusted and have been adjusted over the years when we've made these changes. And those changes are made based on the level that the individual is going to, in terms of whether they're moving from high school to middle school or vice versa, or to elementary school. And number two, whether they're on the grandfathered schedule or whether they're on the Excel. Those are the two driving factors around it. So we will come back to the board within 6 months for the board to provide us guidance on how he would like us to proceed relative to that, and then that's how we'll move. That's what is on the floor at the moment.
Okay, well, for me, I'm not going to support that because as a person who has bills to pay and car payments and financial decisions to make, telling me 6 months into the year that I'm not going to
So-
the salary, I want salary protection for, you don't have to say, I'm not going to change
No,
my
so what I'm-
mind, so
what
that's
I'm-
where I'm at. They deserve a year while we discuss this. If I'll
that's
make a
fine.
motion. If it's not supported, that's fine.
Yeah.
But for me,
striking
you don't know what's going to happen in 6 months. And
Ms. Barham
they
and
need to
I-
make decisions. So, Judy, did you want to say something?
Well, let me just say this, that, yeah, the individuals who, and some of these have requested these moves, they do that with the clear understanding, if they're moving or changing levels, that there'd be some adjustment, at some point, right? So,
I think, but Ms. Maxwell has already used her time, but in 7 years, they have been held harmless for, so well, unfortunately, she's not allowed to come back up and talk to represent her employees. So for me, I'll just say that I'm going to support a year while we make this decision as opposed to 6 months. And then next year, we can make the changes based on the discussions at the board level so they know what their life is going to look like for a year. And that's what I think we should do for them. And number two, as far as principals moving and taking staff with them, staff are governed by a BTU contract and ESP contract, and with those contracts, they're allowed to put in transfers. So I don't see how you prohibit somebody from moving to a school, a teacher who wants to go with a principal, if there's an open position and they put in for that transfer.
Ms. Bartleman?
So,
That's not before us today, and I
Okay.
think that the question and the request was to have a conversation
Okay.
about what we can do. So I think Mr. Runcie, Mr. Moquin will look to have a workshop with regard to that conversation.
Okay, and I guess
Then
for-
those comments would be appropriate at that time.
okay, but I guess my question is a workshop necessary if there's contract language that allows people to move? Like, why are we workshopping something that's governed by the Broward Teachers Union contract unless we're going to do it in negotiations?
Not all employees are under contract.
Ms. Marte, if you could repeat your comment.
sorry.
Oh, you were talking about
Through
meet
the
and
chair, not
confers?
all of our employees are members of collective bargaining units.
I think it's a larger conversation, and it comes with the conversation about moving of principals and salaries and all of those things. I think it's a comprehensive conversation that we need to have, and
Okay,
that would be
fine.
a conversation for that time.
Okay, so I don't know how to do this. Donna's going to make her motion, and I
Well, I
guess
still
I'll
have-
have my motion for the year, and I don't think it's going to pass, but I feel very strongly, so I'm going to make it, and that'll be fine.
Okay, I have a couple comments, and then I have some comments some colleagues that have second comments. So the first thing I want to say is, I thank Ms. Levinson for making the comment that she made earlier. You know, we received a lot of feedback from the community about some of the changes that are on the agenda today. As a school board, we are not permitted to reject those changes without good cause. And while we might not agree with some of the changes, it is not within our purview to decide which principal goes to which school. We can certainly state our position as far as personally how we feel to the superintendent and staff, but beyond that, if the recommendation comes from the superintendent, then we are required by law to vote it up unless we have good cause to not do so. I would say that it is difficult for a community who has had great success with a principal, who the principal has become part of the community and woven into the fabric of the everyday lives of those people who attend that school and the community around that school. And so the only comment, and I made this comment to the superintendent yesterday in our one-on-one meeting, and I wanted to share it with my colleagues here today, is I am not in favor of moving principals for the sake of moving principals. I think that there needs to be a true reason for moving a principal. And so I've already expressed that comment to the superintendent, and I'm saying it here publicly so that everyone can hear me say it on the record. And I know some of my colleagues have expressed similar comments here today. So having a larger conversation is definitely warranted. I have a question with regard to, it's just because I got the answer from the superintendent yesterday in our one-on-one, and it's not about the principals. With regard to, on the interview panel for one of today's appointees was someone from outside of the organization that sat on the interview panel, and I just wanted to get some type of information about how often we do that and what is the reasoning behind why we do that.
So, through the chair, we do it periodically, although lately it's become more of a practice. Actually, there are two candidates in front of you today where we had outside people involved in the interview. In the case of the individual being recommended for, bear with me, the treasury position, I asked the treasurer to have a representative from PFM, who are our consultants around that body of work, sit in on the panels and help with the questions. In the case of the Chief of Human Resources, Mr. Runcie asked that we work with outside expertise and had the woman who leads NBC Human Resources International Skype in and sit in on the panel and actually sit in on the final interviews where she actually led the questions. As part of her prep for that interview, she requested all the resumes of qualified candidates and reviewed all of them, as well as the 10 individuals who went through the first interview panel and the questions that were asked at that point.
Thank you.
Ms. Marte, just a point of clarification. She actually did not review all of the resumes. She 100% reviewed all of the finals, but she had an opportunity to see all of those candidates that applied for it because she was only a part of the final process. So I just wanted to clarify that she was very integrally involved, but did not review every candidate that was actually interviewed, just our finals.
Okay, and how many were the final?
3.
Thank you. I'm now going to go back to Ms. Good, followed by Ms. Levinson.
Can you add me, Ms. Brinkworth, please?
Yes.
So, again, a great conversation today, and I look forward to having further dialogue with regard to compensation and involving everyone, because I think it's important that we all understand the process and how it's applied consistently. I just wanted to get clarification, since one of my colleagues made some points. With regard to the individuals that are listed in the backup, that their salary will remain for 6 months and then the handbook will apply, of those individuals, have they all accepted their salary change?
All employees were notified of the changes. The reappointment is a recommendation that comes before the board, and at the point that it makes it to my office to place it on the agenda, I'm not sure of the specific conversations as it relates to the move, but they're fully made aware that the move is moving forward, and prior to the board meeting, they're notified of the changes that will be moving forward, so they receive notification.
So of the ones that you noted a reference regarding 6 months, it appears to be either individuals that are going from same type of elementary, or individual going from a high school to a middle, or from one type of school to a center school. Is that the case?
That is correct.
And since I've been on this board, I know that when principals have changed from, for example, a high school to a middle school, and there's been a major reduction as far as number of students, that salary changed, has it not?
That is correct.
I mean, this isn't the first I'm hearing it. My comments were not related to that. My comments were related to something very different, and it was it was related to increases in pay and how that was established. But to say that these employees are somehow going to be impacted mid-year, we have sat here time and time again approving G items where individuals have changed schools and their salary and compensation has changed, and that the handbook, I thought, spoke to the fact that the salary would be held for a 6-month period of time and then it would change.
It does.
So this is not new. So I'm trying to understand the concern. Is it that I mean, Mr. Runcie, I need guidance from you as to where you think this is coming from, because I'm a little perplexed on how the information is being shared here publicly. I certainly do not want anyone, so I want to make sure that of those that are here, whether your salary is going up or remaining the same, and then will be reanalyzed within a 6 month because of the nature of the switch that you are going to, that these employees have accepted these changes and are willing to relocate to their new locations. I guess that's what I want to hear. Can someone just tell me that everyone in this G3 whose salary is either increasing or remaining the same for 6 months, and then after that 6 months will be revisited, those employees have accepted these changes as far as the change of locations?
So, Ms. Good, Valerie Wands, the Chief School Performance and Accountability Officer. So when we have conferences and conversations around reassignments or transfers of principals, compensation isn't necessarily discussed in my office because that's outside of my purview.
Okay.
But what we have come to the realization over the last, I would say about 18 months, because this did come up last summer when we started to do some assistant principal reassignments, and the conversation came up then that when individuals are either stepping forward or they're asking for reassignments either for growth or for organizational growth and development, that we need to look at not adversely impacting individuals for that regard. So the conversation started about 18 months ago, and so, but you are correct, there have been instances where principals, assistant principals, and anyone else have been on the G3 item for various reasons, and there were adjustments in salary as associated with that individual item or what was going on at that time. But one of the things that we have all agreed on is that the Excel plan that the board approved back in 2014 to have the organization meet what was then statutory requirements around performance pay, it is now time for that to be revisited because it is 5 years old, not certain if those same statutory requirements are still even relevant today. So we are at the place that we need to have the conversation to then bring back to the board. And so our commitment was within that time, we would at least, these individuals for a variety of reasons are being reappointed to different locations, so to hold them harmless. And then we then come to the board, but it was certainly never an intent to negatively impact anyone for reassignments that are being made either by personal request or to look at greater organizational need.
Thank you for clarifying it. So of some of those principals that are noted here as having their salary remain for 6 months, there are some that are not part of the Excel, or are they?
That is correct.
So I just don't want us to lump everything into one pot here. There are some principals that are not part of that, but their salary is being held for 6 months, and then it'll be adjusted, right? Okay, I just needed to get that clarification. Thank you, Madam Chair.
Thank you. Ms. Levinson?
I actually think Dr. Wanza said exactly what I was going to say. We discussed this at length 5 years ago. This 6 months is nothing new. It's 5 years old. So I'm a little perplexed about all the questions about that.
So can I say something? The last time we did a mass change of this magnitude was probably 6, 7 years ago, before we actually had these changes. So there may be some confusion about that, because that was a different time, and there have been changes made to the salary handbook since then. So I think we did 20 or 25, 6 or 7 years ago, but that was a different context.
Right, and what I had said previously was I had mentioned it to staff as well, and I totally support taking another look at this. But the 6 months is something that the board has passed and agreed to. So you can't vote against your own policy or handbook, so.
It's also applied when principals have moved from principalship to some other administrative positions within a district. We've had that 6 month piece in place, so it's, again, not.
Right, it's been in our handbook. Now, if we want to take a look at that and revisit what we're doing, I totally support having that
That's what
discussion.
I was asked to do.
So, and then my second item I wanted to bring up about principals in district administration, and I know one was mentioned, but there's another one on here as well. I'm not aware of any positions we've agreed to in district administration with these kinds of salaries. So I'd like a list of who's in these positions, and go from there. I mean, these are principals that, you know, one is a different case entirely that's being dealt with right now, but the other is a principal who's now coming to be in district administration.
So, Valerie, once again, so Mrs. Levinson, we have had principals on task assignment, and there have been a couple of board items in previous school years with principals on task assignment. They were in an assignment for a brief period of time, and then when that project or process is over, then we do look at what are the school-based positions available and where their skill sets would best match the school, and they transition back into. There will be another one who's going to come up on the reappointments. It will only be for about 3 months, and I can talk to you about that offline. But we have periodically from time to time. It's not something that we do every year, all year, but there are instances where we have had principals on task assignment. That's really the title that we have historically used, is principal on task assignment. I just worded it principal district administration, and if that was my error, then I certainly accept that.
And we've had discussion about that, so I'd like the board to get a list of what administrators are on task assignment within the district right now and what that dollar amount amounts to, because their positions should be in schools. That adds up to a lot of money that could be taking place in the district right now.
So we will certainly provide that list after today's meeting. Yes, ma'am.
Okay, thank you. And, you know, when we do look at Excel, I just wanted to mention, we also need to be cognizant not just of the changes that are being made, but what the level is that someone may be starting, because there's some in here that's very disproportionate.
Yes.
That's very concerning to me, that needs to be looked at on the other end
We agree.
of not getting enough.
We agree.
Okay, thank you.
Thank you. Dr. Osgood?
Thank you, Ms. Levinson. And the fact that we're having this discussion in this way today is a good thing. What we did 5 or 6 years ago was done then, and we may remember all of it, and we may not. But I think what is important is that we clarify and we give information and we educate the public today so that we send a message to our team members that it is not our intent to do them any harm with their salaries. And when we look at the different ways, whether they're on the grandfather schedule or the XL schedule, for me, that's significant to have listed here. It's also significant to list if somebody requested to be moved. All of these are not changes that are just being done because somebody decided they just want to move principals around. There's thought that's gone into it, and some principals have requested to be moved to different schools. I have a couple in my district. One I talked to, the other one I didn't, but they requested to be moved. And I think it's within their right to do that. As a leader, as you continue to grow and develop, sometimes you need a change for your own personal development or whatever your reason is. And I think that we should make opportunities for our team members that request to be moved and it not be done in a punitive way, that we, if we can, we honor their requests. But I am, again, concerned when we talk about salaries. If I'm a principal and I'm moving to, I'm going to another school, I need to know what my salary is going to be one way or the other, so I can agree or disagree to it. I don't think it's appropriate, whether we've done it like this in the past or not, to say in 6 months we're going to do something, because I'm not on probation. If I'm on probation, that's a different conversation. Well, you know, if you're in a job and you're on probation, you got a certain period of time, you're either going to perform or you're not going to perform. But I don't think it's the intent here to harm anybody in any type of way. And I think that's what we need to focus on, and that should be our expression. How we get to the outcome, I think we're still working through that, and we're still working it out. My comments was around not changing somebody's salary midstream without them being aware of it and without them knowing going into it. Because if you tell me in 6 months my salary could be reduced, I may choose to stay where I am or ask for something different if I know that going in. And that's the point that I was trying to make. But I think everybody has discussed their thought and opinion, and I don't think it's anybody's have an evil intent to hurt somebody in some kind of way. I am concerned. I see some numbers on here, and I'm trying to figure out how this person is moving from this span and getting paid this amount, and some people are moving to a responsibility that's even greater, and their increase is not to the margin as other people. In one case, I can strongly argue, but today is not the place and the time for it. But I would like to have those conversations and have us talk to those things in a sincere way. And if we're going to, as a board, reevaluate in 6 months, I think we have to do it on both sides. You know, we have to look to see, because I know we had some things in place before that limited people's, where they got promotion, and because it was a certain percent, they could only get a certain amount of increase, but their work responsibility increased twice as much. So employment and salary is always an ongoing conversation. And I think whatever we did 5 years ago, we need to maybe look at, through the chair, revisiting, those things to see if they fit the time where we are now, or to see if we need to make some adjustments one way or the other. And as I've been listening today, I think everybody's input was very valid, but I don't want the takeaway to be that anybody's doing anything intentionally to harm anybody. We value our principals. We know that they are a very important part of our team. As we figure out how this is going to go, I don't want anybody to be harmed in any kind of way with their salaries and with their monies, but I also want us to be fair. I want it to be a clear explanation if one person is moving from one setting to another and they're getting, let's say, a 6% increase, and another person is moving from one setting to another with just as much an increase in responsibilities and maybe even more, and they're getting a 3% increase. I would like to see something that tell me why that's that way. I think for me, that's what's missing. There may be legitimate reasons at these things, but I can't determine what that is from what I have here.
Thank you, Dr. Osgood. Next, I have Ms. Korn.
Thank you. So I wanted to comment on two things. One of them is a specific recommendation that's being made, and so this question is to Mr. Runcie. We have a recommendation of a principal that is actually moving from one elementary to another, and the principal specifically had board action regarding their actions as a principal at their existing location. My question is, what process did we go through with the receiving school where they are being moved to for that principal to be assigned to the new school? Was it something the district did? Was the community involved? How was the decision made?
So, Valerie Wands, the Chief School Performance and Accountability Officer. So there, Ms. Korn, so there was not a quote-unquote principal vacancy to actually run an ad and do a full community process. So these schools were all, for the most part, treated the same, if you will, that once the reassignments were being recommended, we actually did conversation with both the leaving community and the receiving community, but no, we did not run an ad and go through a selection process.
Okay, so I have to tell you that, Mr. Runcie, one of your recommendations is one that I would assume you are not surprised has gotten quite a bit of pushback, considering the actions that principal has been accountable to the board for in the past. Are you aware of what I'm speaking about?
Yes, I am. Mm-hmm.
So help me understand why if we've taken significant action of a principal regarding their activities with a student, why your recommendation would be to remain at that.
Why the recommendation would be to what? What did she say?
Ms. Corn?
Val, did you understand
So
what she said?
I didn't understand, but I can address what I believe may be the question. So it is correct that one of the principals named back in March was brought before for the board for recommended disciplinary action, corrective action. The principal certainly has met the requirements of the recommended action that the board approved. Quite as an administration, if we were of the opinion that the actions at that time required or basically would have looked for a different response, then we would have recommended it then. As we reviewed the totality of all that has transpired, she has certainly completed the requirements of the disciplinary action that has been taken. The individual certainly still receives professional development, coaching support. However, as we looked at what we still were to contemplate, it was our professional recommendation that basically in order for the school and the individual to move forward, that a change in location would be best for all parties.
So I guess what I would ask, because I think this is a unique situation, it's not one that we face often with our principals, is that there is a concerted effort on the district's part in working with the school and making sure that everyone is on board and understands, basically what has occurred and that they are receiving what the district feels is a strong principal recommendation. This is not just a move, I guess is what I'm saying. There's a difference when you don't involve the community and they are receiving a principal that they feel they have concerns with. And so for that reason, I'm asking Mr. Renzi that, through Dr. Wanza and Cadre, that whatever support is necessary to make sure that that community is supportive and this ends up being the good and smooth transition that occurs.
We are certainly committed to that, Ms. Corn. Valerie Wanza.
Thank you.
You're welcome.
To the Excel and grandfather, I will tell you that in my extensive conversations with Mr. Chisholm, I was reminded of some of the things that have occurred over the past several years, actually over the past about 7 years, since Excel was brought to the district. The reality is that even if you're on the grandfathered schedule, you still have, if your salary is going to go down because you've gone, let's say, from a high school to a middle school or a middle school to an elementary school, the 6-month protection exists, but your salary still goes down. So I know one of my colleagues referred to not having their salary move at all. I don't understand that comment, to be honest with you, because even in the grandfathered schedule, the salary is stated to go down up to 10%. So if we protected all of these individuals to the exact same amount that they're making now, they actually would be in a position that's stronger than even someone who knows what their salary would be. So I absolutely understand not wanting to move forward in a way where there's a lot of ambiguity.
Ms. Corn, unfortunately, there's a lot of feedback in the connection. And we can no longer hear you.
So I think she was talking about the 6-month adjustment. Prior to the changes in the handbook a few years ago, there was no time period for adjustment. They were just done automatically. So that was something that was put in to deal with the transitions. So I'm not sure if that's what she's referring to. So.
Okay, I have Ms. Bartleman. I know I can hear that she's still on the line, but we can't hear her. Ms. Bartleman, you had a comment?
Yeah, I had a comment about the 6 months, and I was trying to get a copy of the employee handbook. And it's the 6 months, do you have that language? Does it speak to involuntary or voluntary?
Give us a second.
And can I get a copy?
Sure.
And I'm sorry, I've asked Ms. Myrick to get me one while people were talking, but she hasn't been able to find it.
Okay.
Not a surprise, it's on the website.
Does someone have a
Okay.
copy readily available?
Yeah, we're reading it.
Okay.
Would you like me to read it?
I can take that, that's fine.
Ms. Korn?
Would you like me to read it?
Hold on one second. Ms. Korn, are you on the line? Unfortunately, Ms. Korn, if you're on the line, we can't hear you at this moment. Ms. Hall?
So on page 12 of the Employment and Salary Administration Handbook, it reads, I'm sorry, 18. No, actually, page
It's
19.
page 19. I have
On
it.
page 19, there's a section that speaks to demotions, and it says that when an employee, it's broken down into three, it categorizes demotions into three groupings. There's the demotions due to reorganization, demotions due to disciplinary and performance, and then voluntary demotions.
Okay, can I just stop you right there? Because it's my understanding that these are not demotions.
Okay.
They're not demotions.
No,
And that's the only place in the handbook where it references the 6 months, is under demotions, and these aren't demotions. It's on page 19.
Okay, so Ms. Hall, can you read to me in the policy where it indicates about the 6 months and the salaries when it's not a demotion?
You're going to go actually to the Excel plan.
Okay.
Plan document.
Okay,
If someone could get us copies of this, it would probably be helpful.
can I ask a question?
And I don't know if at this point,
If this is the, if
thank
this
you,
is-
Ms. Korn.
If this is the meet and confer handbook and guidelines that's agreed upon by the meet and confer, now you're saying you're going to go to Excel for something else? I just,
I can explain. So principals and assistant principals are categorized as meet and confer employees. Principals fall into one of two categories. We have principals that are assigned to the grandfather schedule, and then we have principals that are assigned to the pay for performance schedule. Principals assigned to the pay for performance schedule, their compensation is governed under the Excel plan document that was put in place in 2014.
okay, I guess this is my frustration. I have watched the body language of the audience of the person who's in charge of the meet and confers. I have watched the arguing between that person and Eric Chisholm and flipping pages, and it frustrates me because they're not a union. So if they were a union, they could file a grievance, they could do whatever they needed to do to have due process. They're not entitled to any due process. So if we vote on this today, and then Ms. Maxwell brings us information that is different, and this is a done deal, that's not fair. And we have no procedure for Ms. Maxwell to come up, and maybe the will of the chair, possibly, and represent her group, because she is saying that our staff is wrong on this information. And so I have to make a decision now with someone who can't come before the board and represent their people, and they don't have, this is a meet and confer, they don't have the same rights as BTU. So this is very frustrating for me. So I don't know if we can take a break, because I personally want to go down and talk to Ms. Maxwell, because I want to see, is this correct or is it not correct before I make a decision? Or if through the chair, if you allow her to speak. This is an issue involving people's salaries, their livelihood. Not one person on this board wants to hurt any of these people or take away their money. That has been stated time and time again by every board member. But how are we fair to this group of people if we're not even letting them tell us that our staff is presenting information that may be incorrect?
Okay, Ms. Bertelman, Ms. Marte would like to make a comment.
So through the chair, I'm hopeful what I proposed earlier, and I spoke to Ms. Maxwell twice yesterday myself, personally, addresses the concern that Board Member Bartleman has, in that the 6 months current salary with whatever applicable raises that you may perhaps later approve for the rest of the meet and confer groups would apply, and then through a board workshop, as was suggested by Dr. Osgood, prior to the expiration of the salary being held the way it is, we come back. We have met with BPAA as many times as we need to iron out what is fair to all, so everybody's shaking their head in the same direction, and come back to the board prior to that 6 months, and that's what I was hoping that the amendment would be to the item. Strike the Excel language on the item, have a workshop prior to the 6 months, everyone's salary stays where it is, plus the 2% for the meet and confer, and we don't have a situation where some of the concerns Ms. Bartleman has would come to fruition without the board being informed and everybody being in accord.
Thank you, Ms. Marte. And if a motion is made, Ms. Bartleman, the item will be amended and there will be an additional opportunity for the public to have input.
Oh, perfect.
Yes, Dr. Osgood.
I am on the line, Ms. Prince.
Thank you, Ms.
It's
Quinn.
not just Ms. Bottomer that has the concern. When you said that earlier, to me, that was the best way to go, because although we
Yes.
have had a certain practice, we have not used the language in this way before, and that's when maybe an hour ago, maybe hour
Yes,
and a
ma'am.
half ago. So that's where I made my
That's-
comments at, and that's what my position was. So I didn't understand when then the conversation started to be about the year or whatever, because you cured it
Yes,
in
ma'am.
what you said, and it gives them fair opportunity to discuss and get the input.
Yes.
I don't want to make an irrational decision or a wrong decision today without even giving the due diligence of a full discussion. I think that's a dishonor to our team members to just make a decision today and not have it discussed, not have it communicated, talked back and forth. I know I have a couple of principals that are leaving District 5 and a couple that are, some that are coming too, that I love dearly. So I would even like the opportunity to talk to each one of them to see how these decisions are gonna impact them. I have talked to some of them, but other ones I haven't, and I feel a responsibility to at least have had a conversation to them. So your comments to me an hour and a half ago or whatever cured
Yes, they
my
did, ma'am.
concern.
And the notion of a workshop is
'Cause it would take the
respectfully
language
a good
out
one.
today.
Yes, it would. And that is what I was asked to do by Ms. Maxwell yesterday. Get the language out, let's get back and let's talk. And that was what I attempted to do. And the workshop would be an appropriate time to have whatever length of conversation the board wanted to make sure that all concerns were met. So thank you, Dr. Osgood.
Yeah, and I have not had the privilege of talking to Ms. Maxwell. I'm making my comments based on what I really believe is fair and from the place of people that have been a part of our team. And I think our intent is to make sure that we're doing what's gonna help our team members move forward within the guidelines of policy in a way that it's nothing punitive toward them. And I do have a question, just for my own point of understanding. If I'm moving from a high school to a middle school, we said that there are no demotions. So we're saying that because it was a request, not because it's an action that we're taking. Is that why we're saying that? Because I know I've had in the past, where I've had principals in my district that were not working in, let's say, a middle school setting, and they were moved to an elementary school setting, and they have worked very well. So I just need to understand that so that when I see it, I understand what's happening.
So Valerie Wanza, Chief School Performance and Accountability Officer. So as an organization, and it's in policy 4002.14, we have a position called principal. The compensation is what gets differentiated based on the location, but the position is still principal. So when a principal is demoted, then they are out of the role of principal altogether. They are either an assistant principal, a teacher, or another, but we have one position called school principal. The level that they are assigned to is what dictates the compensation.
Okay, thank you.
You're welcome.
Is that the extent of your questions, Dr. Osgood?
Yes.
Thank you. Ms. Korn?
Yes. I'd like to make a motion to strike all of the comments related to the 6 months,
Excel.
Excel.
Yes, ma'am.
And I'd also like to add a comment that staff will present to the board a workshop prior to the 6 months that will address the Excel guidelines.
Yes.
Second.
It has been moved by Ms. Corn and seconded by Dr. Osgood to strike the reference to 6 months and Excel and add that the board will revisit within the 6-month timeframe the policy and the handbook. Is that correct?
Yes.
Okay. Any public input on the motion?
I had a boss who said, you probably ought not to stand up when it's a good thing. So first of all, I support the motion and thank you. But just for clarification, and I appreciate, the struggle here today, and Dr. Osgood, thank you for your remarks. To the best of my knowledge, we have never appointed a principal or an assistant principal and said, we're pay protecting you for 6 months, but we're not sure what is going to happen in 6 months. Your pay may go up, it may go down. We've never done that. There's only one instance in the employee handbook, it's on page 19, where 6 months is even mentioned, and it has to do with involuntary demotions. When we involuntarily demote someone, then we pay protect them for 6 months. That's where the 6 months comes into play. When a principal laterals or moves, and just to be clear, and maybe this is part of the confusion, a principal who goes from a high school to a middle school is not demoted. Okay. That is not a demotion. That is, in this district, a principal is a principal. Now, on our grandfather schedule, there is a deviation on the C schedule, for example, which is elementary, and the D schedule, which is middle school. There's several $1,000s difference because of the time associated, and high school as well. High school is a little higher. So if you do go from middle to elementary, you're within that 5 to 10% is where they place you. That's what we do. On the ACEL side of the equation, if someone moves, and there may have been some salaries adjusted, but people know from the get-go, you're reappointed and you're given your salary, there's no 6 months, we're gonna come back to you and reevaluate this. Trust me on this, I would have heard it. I don't believe it's ever happened in this district. So I think we need to be clear. Rose is right. There's a lot of issues with ACEL that we need to fix. We didn't experience them in the first however many years, because the first 3 years of the program we said we're going to hold everybody harmless. That's what we did. And then we just kept holding people harmless. Because again, who wants to move if you know you're going to a school, you're going to take a $4,000, $5,000, $6,000, $10,000 pay cut? No one would ever voluntarily do that. So we have to fix this, and I appreciate the board's time, and it will take a workshop to do it. But for today, let's hold these people harmless like we've done others, and not tell them or have them think, as Dr. Osgood so aptly put, that they could come back in 6 months and not know what's going to happen to their family. It's just not fair. So thank you for your time, and thank you, Mrs. Corn, on the phone for your motion and for your second, and I hope you'll support the motion. Thank you.
Thank you. Any additional comments from the public? I have Ms. Good on the motion.
Yes, and on the comment. So I support the motion. I just, we're talking about a principal's a principal, but then earlier, quite a while ago, comments were made that principal's salary changed based on population of schools. So I think there's a lot of information that's contradicting. And so I'm all about moving forward today, but I have to tell you that there's a lot of conflict here today. And I'm personally conflicted by some of the comments that were made today. I'm all about being supportive and allowing opportunities for growth and change. I think it makes our district better. And I'm excited about some of the opportunities on the agenda today. But to the bigger conversation at hand, there's been comments that have contradicted.
Thank you, Ms. Good. Any additional comments on the motion? I do. Yes, Ms. Bartleman.
I'm I'm going to support the motion because Ms. Maxwell's asking for that, but again, I think it's unprecedented for us to say in 6 months you don't know if you're making more or less, and I think they should get their annual contract, and then, in my opinion, we should then, at the end of their next annual renew, adjust the salary and give them the year. Because to switch their salary mid-year, which potentially is about to happen, I know we're gonna give it time, and we're holding, other principals have been held harmless the complete year. They've been held harmless up until this point, and now we're gonna pick this appointment.
Well, we get to have that conversation at the workshop. We get to decide as a board.
But we can decide, but we don't have a crystal ball, and nor do those principals who have to make decisions about their salary. And we could come back and this board could say, okay, we're gonna reduce the salaries in 6 months.
I think that that's not the sentiment that I've heard from my colleagues
but they're-
whatsoever.
I understand that.
Ms. Bartleman, I understand your concern, but I think
Okay.
that you've heard from my colleagues that that is not the intent of this board. We want to have the conversation so that we can fix the issue.
So if that's not the intent, why wouldn't we just give them their year's salary and hold them harmless like we've done?
Because we want to fix the policy.
But you can fix the policy and still hold them harmless like we've held other people harmless in the past.
We are by giving them the 6 months through this motion.
Okay, but that is my point. Then if it is the will of the board that we're going to keep their salaries, then, which you just said, then, or you think that's the will of the board, then why wouldn't we just hold them harmless for the year right now and let them have stability in their lives and then make the decision through a workshop, which needs to be made anyway? Because by you saying this, there is still a risk that in 6 months my salary can change. No one on this board can guarantee that for these people. Up until this point, we have not honored the program. We have held everybody harmless. Hold these people harmless until we fix it. That's my point. Don't give them 6 months in their head of, well, what happens? Because unless we all put on record now we're not changing their salaries in 6 months, that would make them feel better, number one. Or number two, hold them harmless for a year while we fix it. And then let's fix it the right way. I agree, it needs to be fixed. But when you tell someone in 6 months there is potential for their salary to be changed, and you can say it again that that's not what you're hearing from the board, well, if that's the case, then as a board, we should hold them harmless for the year.
Thank you. Dr. Osgood?
I hear you, Ms. Balderman, but I don't want what I'm saying misrepresented, and I think you're misrepresenting it. I think we owe our teammates here and those that will come after the respect of having a workshop and an in-depth conversation that we address this problem ongoing. I remember when Dr. Wanza got into her position, it was a salary issue that took us years to fix, and I can kind of still have some comments about that too. But I think that the process, as Ms. Good spoke about, needs to be us taking full responsibility and having an in-depth conversation about compensation around our principals overall. Because to make a decision on this now leaves some other things. I have some other questions that are not pertaining to these individuals, but other principals. So I would like an opportunity to have a full discussion so that I can have all of those things at the table, get my questions answered, understand the Excel, the grandfather in a comprehensive way, and then make a decision going forward. But to insinuate, because we're striking the language today to try to move forward today so that we can have our principals start working in their new areas, to say that doing that today is some kind of intent. We don't know what we're going to do. We could do that today and come back and change a policy next month to change it all. But I think we owe our principals the respect of having a serious, in-depth conversation about their compensation overall. I don't think we've had that in a timely manner when it comes to this issue today. And that's my issue. I'm responsible for making those decisions, and I owe my teammates respect enough to take their position and value their work in a way that I discuss it in a comprehensive manner and make a decision in that way. We don't know what those decisions are going to be. We know what our intent is, and that's what we're trying to get to. But striking this language today and making this decision today is not my intent, to do harm to anybody with their salary. And I'm always gonna speak for myself. So that's what I'm doing. I'm expressing my intent. I don't know what anybody else's intent. So when you make your comments or whatever going forward, don't include me in those comments, because that's not my intent, that's not what's in my heart.
Thank you. Any additional comments from my colleagues? Ms. Bartleman, is it something new? Thank you.
I want to be clear. I support the workshop and all of that. The question that I'm asking the board today, which clearly is not being understood, is we have two options here. And both of those options include a comprehensive workshop. Both options. There's no question that that needs to happen. The option is, for me, in my head, only my head, is are you going to have the workshop and guarantee them their salary for the year while we work through it so they don't have to worry about potential adjustments, or are you going to leave it up, and I'm only speaking to the impact on the individuals and what they're thinking. That's all I'm speaking to, is do they have to worry what happens to their salary in 6 months? So for me, holding them harmless, which we have done for 3 years because we knew it was a bad plan, we should be consistent, hold them harmless this year, have the conversation, and they know that next year everything may change, maybe nothing will change, but I'm only talking about the families who have to wait 6 months to see what their final salary will be. And not only is it 6 months, so this has nothing to do with changes or discussions or workshops, that is a given. It's that those people in the audience now have to wait 6 months to see what's going to happen to their salary. How do you plan your life? And because we already have a precedent of holding the salaries harmless in the Excel up into this year, why don't we continue that precedent and give them peace of mind while we figure this all out in a comprehensive way?
Thank you, Ms. Bartleman. So I have a question for staff. Have we applied this at any time that we've done any movement of principals since we've put this policy in place or this Excel in place, or have we held them harmless up until this point?
We have applied this same policy. We've applied this practice.
To principals?
Yes, yes.
And Madam Chair, the majority of the moves that we've seen over the years have been associated with assistant principals. Dr. Wanza made reference to that. That's what we saw a lot of. We had even hybrids of people who had a combination of the two schools that they were working at. And so at the end of the 6 months, we found ourselves trying to identify exactly what their new salary would be. So we do have some cases where we've actually had to make the changes.
Have we applied this to principals being moved?
If we can, I think we should look at exactly the population of changes. I don't remember specifically principals, but what I would share with you is they all are a part of Excel, so we treat them the same. That's the takeaway.
I understand that, but here's the difficulty, and I think my colleague, Ms. Good, pointed out very well. We're getting conflicting information, which is very frustrating as a board member, and to have a lengthy conversation about an item where we should be celebrating the opportunity. We are still at a point, an hour and a half later, where it's not crystal clear. And for us, for me personally, I will tell you that is a problem.
Okay.
So I appreciate that Ms. Maxwell stood before us and said she would ask us to support this motion. But now I'm thinking to myself, if we have not to this point used this for any principal moves that we've done, we've held every principal transition harmless up until this point, and we're doing it today, then why are we doing it today? And then, yes, we still need to have the conversation.
I think with the response you receive is that we want to be able to let you know for certain. I don't like to misinform. So the objective would be to confirm specifically. And I think for Ms. Good, through the chair, there needs to be a point of clarity. When we were talking about the quartiles, we were not speaking to the grandfathered. In the Excel handbook, it speaks to salary changes, if you will, and those are the Excel people. Part of the conversation we've had today, we've made it a marriage and we brought it together. So we're not misinforming you all. I think it's just kind of come together. So there's grandfathered, where there's language that's specific, and there is a salary schedule very specific for that. Then there's Excel, and there's a specific salary schedule that is very specific to that. The dollar amounts look very much different, and that's why you see some principals today, well, one specific principal that is coming over, and you see the salary to be relatively low because the Excel, based on the quartile and numbers that are there, that is the salary that's associated with the Excel plan. It has nothing to do with the grandfather plan.
We currently have a motion before us. Is this to the motion?
To the question, and maybe Dr. Wanza may know, you didn't answer it, you just spoke a whole circle. Have you changed a salary, Dr. Wanza, of a principal in Excel, or have we been holding them harmless under what's happening today?
So I'm gonna
Because Lisa knows.
I'm gonna repeat what I said. When I identify reassignments, compensation is not under OSPA. HR handles compensation, so I can't answer. I'd have to go back and look. The majority of the reassignments that we have done, at least since I've been the chief, they have been for principals who are on the grandfathered schedule.
Okay, so.
They've been on the grandfathered schedule, which is different than the Excel schedule.
So nobody, though, in this room knows or can get the information is if we've held
We
them
can
harmless.
get it. I'm just telling you, sitting right here, I do not have
Okay.
it because compensation is outside.
Because there's a very big difference for me to vote on a motion for 6 months, and if I find out that no Excel principal has had their salary adjusted, that's going to be very frustrating for me.
But the APs have.
I need a point of
Thank
The
you.
principal, though.
Okay.
Ms. Bartleman, Dr. Osgood for a point of
I
clarification.
need a point of clarification. We just took away the language about the 6 months. This motion is to take away that language, right? That was Ms. Corn's motion that I second, to strike this language and to say that we would have the discussion in 6 months.
Yes, that is correct. I think the concern that's being raised is that indication that we're going to have that conversation is still leaving a question mark in that 6-month time frame for those people that are being reappointed today.
Well, I think so if we're going to get through this, maybe what we need to do, and, you know, we can't seem to move, is we need to identify on here who's on Excel, who's on grandfather, and get both of those policies and see what they say.
I think, so as the chair, what I would say is this. We're at a moment where we have a motion on the table. We have the support of the BPAA president. We have been asked to support that motion. I understand the concern. It's the reason why I asked the question. I think all of that information will need to be brought to us at the workshop. I am concerned, I will say now, that if we've held people harmless up until this point and we're doing something different today, I think that even more indicates the need for the conversation. And I want you to understand that for me personally, I don't want to do something different for people today than we've done in the past. So yes, Ms. Good.
And I think in fairness to everyone here, and I think this was an important conversation, but I think we're at the point where I think we need to move forward in the most positive way and ensure that these individuals that are being named here today have positive outcomes, and then we as a board take responsibility to have greater conversation about this and how we deal with it. Ms. Maxwell has already indicated on the record she's in agreement with it. I think, you know, we're not all getting exactly what we want, but I think in the interest of time and those that are here, I appreciate your comments, Madam Chair.
Thank you. Yes, Ms. Bartleman, please, something new.
Yes. After we vote on this, I would like in writing next week, or for the next board meeting, please, whether or not we've applied this Excel to any other principal, because I'm going to vote in favor and be on the prevailing side, so I may be bringing it back.
Thank you. So that was a request to staff, and that information would come to the entire board, please. Thank you. Any additional comment from my colleagues on the motion? All those in favor of the motion indicate by saying aye.
Aye.
All those opposed say no. Now we're back to the, yes.
That was
Can
the
I make a
amendment,
second
correct?
motion?
Yes.
Yes, okay.
Yes. Now we're back to the main item as amended. Any comment
Ms.
from?
Breakworth?
Yes, Ms. Korn.
I had asked to make two motions.
Oh, you'd like to make another motion? Yes?
Yeah, I'd like there to be a statement, just for point of clarification, that the applicable raises for the 2018-2019 school year will be in addition to the salaries that are shown in the agenda item.
Yes.
Okay, yes, staff is indicating yes, so there's a motion.
Second.
Second by Dr. Osgood. The motion is that the 18-19 salaries, if and when they are approved by this board, would be applied to the salaries of these people in their new position. Yes. Ms. Levinson.
I mean, I certainly support that, but that's a given. From the moment that we pass it, that's when salary increases go out to our employees, so it's not necessary.
Yes, Ms. Marte?
So the salary increases for the 18-19 year, these appointments aren't effective till July 1 anyway, so they're getting them in their existing job. So they're a given.
Yes.
Ms. Korn, did you hear that explanation from Ms. Marte?
I absolutely did, and I don't have a problem not making the motion, but when the head of our BPAA is not sure, to me it seemed like there was no harm in putting the motion on the table. But if you don't want, if the board doesn't want to support it, then I can withdraw it.
Okay, so Ms. Maxwell is indicating from the audience that it's on the record and she is fine with it, so would you like to
I'll withdraw the
continue?
motion.
Thank you. Ms. Korn has withdrawn her second motion. So now, back to the item as amended. Is there any public comment? Any additional comment from my colleagues for the item G3 as amended? Seeing none, all those in favor of G3 as amended indicate by saying aye.
Aye.
All those opposed say no.
No.
Let the record reflect. The item passes with one no vote. Now, for the appointments, yes. Oh, boy, that was a really long thing, and I appreciate your patience. So at this time, the chair, actually, are we required for Ms. Rupert to indicate the reason for her no vote
Again? No.
on appointments?
I thought we said we weren't doing.
The question is to Ms. Myrick.
We have stated in the past, yes, that there has to be just cause to not accept the superintendent's recommendation, and have been asked to have that stated on the record, yes.
Ms. Bartleman?
We have only had that happen one time, and I disagree with that. And speaking with the School Board Association, I would understand that if the board as a whole made the decision, it was voted down, but it wasn't, and I disagree with having board members having to do that.
Okay. Yes, Ms. Levinson?
I need clarification on the vote because I've been told that I may not vote against it unless there's good cause, which must be moral or disqualifying. That is certainly not what just happened here.
Correct. So if you vote no, you have to do it for just cause, and you have to put the just cause on the record.
Ms. Rupert, I'll ask you if you have a statement.
Absolutely. I checked with our attorney. I'm within my rights to vote no. The board is authorized to designate positions to be filled and to prescribe qualifications for these positions. It's apparent to me that some of the nominees do not meet the minimum qualification for the job. That is my reason for just cause.
And I believe you need to name the people.
You believe it or you know it?
Well, you're saying, I mean, you're saying just cause because people aren't qualified. Is that all the people aren't qualified? Some of the people? That's the issue, I think.
I said some nominees do not meet. I personally don't want to be naming people. But I did ask you, and I don't.
I did ask, and you're right, you can say no if you're willing to put on the record that there's just cause.
And I did. And she did. So.
Thank you. The chair would like to take a moment to recognize new staff appointments.
Wait, Ms. Brinkworth?
Yes.
I'm sorry, I just don't understand. If this is the path we are now going, to say that just cause means to blanketly say someone in the pool of people does not meet a qualification, that to me is not stating just cause. So we're either going to say you have to give a reason or you don't have to. But if you're going to give a reason, it needs to actually be a reason. It can't just be a blanket statement. So we either need to walk away from requiring a statement to be made, or the statement needs to be to the actual, something you can actually go to court and say, this is why I gave just cause. This is my just cause, it's for this specific reason. And the reason that was given was individuals do not meet the requirements. We need to know what that individual or individuals are. Otherwise, you haven't actually given us any information as a board. And I think all of us would love to be able to be very broad about a statement, but what have you actually shared with the public or gone on the record saying?
I would agree. As I said, I think Ms. Rupert needs to name the people that she does not feel are qualified, and that, we can have that discussion of whether they are or whether they aren't, but if she feels somebody's not qualified, I do believe that that needs to be on the record, because that is the just cause. And when we did it before, the board member was specific about the person that they did not feel met the qualifications for the job. The specific person or persons, I can't remember exactly.
Okay.
And to Ms. Myrick, to your point, I don't think that we as the rest of the board need to then have any conversation about another board member's just cause, whether or not it meets that full requirement, but the just cause has to actually be stated. So I don't want to.
I would agree with that.
Say,
I would agree with that.
I agree with you, but I just think you have to make a full statement as to what the just cause is, if we are going to require just cause to be stated.
Ms. Bartleman, unfortunately, we're not having conversation. It's an opportunity for Ms. Rupert, and I'm at a point where, I'm the chair of the board. There's nothing I can do to compel someone to say something. So,
Okay.
Ms. Rupert, do you have an additional statement?
No, I still have my freedom of free speech. The last time I checked, we still lived in America. So I said what I needed to say, and that's it.
Okay. So obviously, Ms. Myrick, there's nothing else that I can do at this point, is there?
No, I mean, the rule is to, state your just cause on the record and why you're disapproving of an individual's appointment. And if somebody refuses to do that, I don't know how that we make them do that.
Okay, thank you. The chair would like to take a moment to recognize new staff appointments.
Okay, so first I'd like to congratulate and thank you for sitting here so long, everyone. Mindy Borkhardt, she's a senior treasury analysis. Catherine Brooks, senior process analyst. Teresa Hall, principal, district administration. Sandra Lyons, budget analyst 4. Marianne May, task assignment chief facilities officer. Alan Strauss, chief human resources and equity officer. Ty Thompson, principal, district administration. Jill Young, task assignment director, demographics and student assignments.
And I have the great honor and privilege of welcoming the new principal of Seagull High School, Kelvin Lee. And the new principal of Meadowbrook Elementary, David Levine. I don't have that on my list. I must have the old list, sorry. And the new assistant principal, I was wondering why Mr. Howard was back there. The new assistant principal of Whitten Rogers Education Center, Fareed Khan.
Congratulations to Rendell A. Maker, principal of James Hunt Elementary School. Congratulations to Richard Garrick, principal of Tamarack Elementary School. Congratulations to Mark Kaplan, principal of Coral Glades High School. And congratulations to Michelle Kefford, principal of Marjorie Stoneman Douglas High School.
So I have the distinct honor and privilege to introduce Janice Crosby. She will be the new principal at Sunset Lakes Elementary. And also joining District 2 with a great last name, I must say, Miss Catherine Good is going to be the principal at Fairway Elementary.
And first, I'd like to thank Eric Anderson for the incredible job he's done at Tropical Elementary School and welcome him as the principal at Davie Elementary. I'd also like to welcome Olayemi Awafadeju as the principal of Nova High. And welcome the 2018-19 Principal of the Year, Philip Bullock, Principal, Flamingo Elementary. I'd also like to welcome Stephen Caruth as the new principal of Falcon Cove Middle School. And take a personal point of privilege to thank Mark Kaplan for his many years at Falcon Cove Middle and making it one of the best middle schools in the state. Good luck at Coral Glades. And I'd also like to thank Mr. Robert Schneider for his incredible tenure at Davie Elementary and welcome him as the principal of Tropical Elementary.
It is my pleasure to welcome to the District 1 team Ashley Childs, who will be our new licensed practical nurse at Miramar Elementary. And Bonnie Clement, our new principal at Lanier James Education.
It is with great excitement I welcome to the marvelous District 5 the new principal of Peters Elementary School, Susanna Deutsch. I would like to welcome the new principal of Lauderhill Paul Turner, Michelle Ingram. I would also like to acknowledge this move in District 5, this phenomenal move, the new principal of Board H. Anderson High School, who has done a fabulous job at Lauderdale Lakes Middle, Mr. James Griffin. And I'm also excited to welcome to the District 5 team this amazing woman who has done just an incredible job as an intern principal, who is now the principal of Piper High School, Ms. Marie Hardiker.
Good afternoon. I would like to welcome the new principal at Northcrest Elementary, Mark, I hope I say it right, Charpentier. Amy? And Ms. Sabine Phillip as the new principal at Margate Middle. Roberta Ray, principal of Coconut Creek Elementary. Ernest Tolliver, principal at Crystal Lake Middle. And Matthew Whaley, our new principal at Liberty Elementary.
Thank you again for all of your patience. I think some of my colleagues have a few comments before you leave. Yes, Ms. Good.
I'll make them very quick. I just want to thank both Ms. McKnight and Mr. Charpentier, both respectfully. You will be missed in District 2, and I wish you all the best in your new endeavors, especially Fairway will miss Ms. McKnight, and certainly Sunset Lakes will miss Mr. Charpentier. And lastly, although she's not here, I wish Ms. Michelle Kefford
all the best at Marjorie Stoneman Douglas. I think she will be a phenomenal addition at your school, Ms. Aladef. And again, she will be missed by the Flanagan community. I will tell you, received many phone calls, everybody saying how much she will be missed, but also congratulating her on this new opportunity. So I thank the Flanagan community for their compassion and understanding and belief in her. Thank you.
Thank you, Ms. Good. Dr. Osgood?
Certainly, I want to congratulate Mr. Philip Bullock, who is the Principal of the Year, and thank him for the amazing job he did at Walker Elementary School in getting it to where it is. And I wish you much success in your new position. I know you will do great. And thank you for putting a succession plan in place that Walker can continue to move forward. Because of your leadership, you developed the next principal for Walker that we will be able to continue. And finally, to the mayor of Piper, who has gotten another position now, Mr. Angel Gomez, thank you for your success in the many years of being at Piper and our graduation. And I'm gonna ride my horse to the old town road. Yeah, that was our part of our graduation. It was amazing. So we're still singing. But thank you for both of you gentlemen for your amazing work and your leadership.
Thank you. Ms. Levinson?
And I just wanted to thank Janice Crosby for her commitment to Flamingo Elementary and wish you all the best at Sunset Lakes Elementary.
And I would like to say thank you to Matt Whaley for his dedication to Meadowbrook Elementary. If you haven't been there, you should go. It's a sweet little school tucked away in a neighborhood that not many people know about. He does incredible things with students there. And so I wish you all the best in your transition to your new role as principal. And then to Mr. Bonnie Clement, thank you for always taking care of our special students, for having the cleanest campus I have ever visited in my entire life. And that goes through all the way when I was in school, when I was a teacher, and through a board member. And thank you for loving those students and ensuring that they had great success through your care. And I will greatly miss you in District 3.
And Baby Fun Day,
And Baby Fun Day, yes.
the best day of the year.
Thank you all. Thank you all. You are welcome to stay with us for the rest of the day, but you are also welcome to leave if you have your new job that you'd like to get to. If I can orient myself at this moment, Mr. Moquin, the agenda calls for committee reports, but we also had a time certain.
I would take the time certains, get them out of the way, and then do committee reports, and then
Okay.
break for lunch.
All right, am I taking them together, or are they all separate?
Ms. Brickworth, they're together?
They are, okay,
Yeah.
thank you. If those that are exiting could please do so quietly so we can continue with our agenda. We do have a very extensive number of items today to cover. So if you could leave the boardroom quietly, we would appreciate it. Let me make sure I have a quorum seated. Yes, I do. May I have a motion and a second on items GG 1 through 4?
So
Moved by Ms. Good, second by Ms. Rupert. Audience input on items GG 1 through 4.
Good morning, Madam Chair, Madam Vice Chair, board members, Superintendent Runcie. It brings me great pleasure this morning to present to you first the ratified collective bargaining agreement and the salary schedule for the Police Benevolent Association PBA unit. I'd like to thank the management team members for their support and their work in achieving this tentative agreement. As always, we'd like to thank the board members, Mr. Runcie, General Counsel's Office, Mr. Jeff Moquin, Chief of Staff, Ms. Judy Marte, Chief Financial Officer, and the implementation team for your support and guidance throughout the bargaining process. I would also like to thank all of the members of the PBA team, as well as those of COPA, ASMAB, and the BPAA units for helping us to achieve salary schedules. and the PBA contract for members of these units. I do have representation with me today for some of the units. The PBA was not able to be present this morning, but they did ask me to share their appreciation with the board for your support of this item. But present with me today, I do have a representative of COPA, I believe ASMAB, and the BPAA. And at this time, I would like to ask for a few minutes for them to comment on the settling of the 2018-19 contract for PBA and for the salary schedules as being presented this year for 18-19 for COPA, ASMAB, and the BPAA units.
Jack Veazey, Executive Director of COPA. Good morning, Madam Chair, Brinkworth, board members, Mr. Runcie. On behalf of the 346 employees represented by COPA, I'm here to thank you for the 1% salary raise for the entire 2018-2019 school year. At an unprecedented financial time such as this, we understand the irresponsible budgetary decisions made during as many years by the state of Florida. Saying this, I implore you to consider all your employees only second to our wonderful students. Our employees, especially since the crash of 2008, have seen their salaries moving in a negative direction. Inflation rates during the last 12 years total 19.9%, or 1.6% on a yearly average. That data is identified in the table that I presented to you. You can actually go to that website and you'll see that information. Our raises simply have not kept up. We appreciate the challenge impacting your decisions to balance the needs of our students and meeting the financial needs of our employees. There is not an educational program out there or a technology innovation available that supplants the daily work done by our employees both in the classrooms and behind the scenes. This is the first time in my 38-year memory that a group of employees was not equitably compensated as other groups. The impact on the workplace dynamic is potentially disastrous. I implore that the School Board of Broward County use the $17.8 million state funding for 2019-20 to assist these groups, including the 167 current COPA employees that are not benefiting from the referendum's salary supplement being provided to school-based employees as of July 1, 2019. COPA employees go above and beyond what is required of them, and the nature of their work requires confidentiality. I strongly believe that COPA employees truly serve as a backbone for many staff members throughout the district, and their team efforts are far-reaching. It goes without saying that COPA employees provide an invaluable service and are vital to the achievement of the Broward School's mission and vision. For the 2019-20 school year, employees in the COPA Meet and Confer group who are not eligible for the referendum supplement and whose effective start date is on or before June 30, 2019 should receive a 2% equity supplement retroactive to July 1, 2019. In all fairness, if district-based FOPE clericals are entitled to receive the 2% equity supplement, then the district-based COPA employees should also be entitled to receive the 2% equity supplement. It is COPA's position, for the emotional needs of our district, that all employees not receiving the referendum salary supplement must receive the 2% equity supplement. On behalf of our hard-working COPA employees throughout the district, thank you very much.
Thank you.
Good morning. I'm Elaine Safe, President of the BPAA, and on behalf of the over 500 administrators, principals, and assistant principals, we want to thank you for the raise we're about to receive. On a personal note, I also want to thank you. It's been 2 years as president of this organization. I now pass the candle over to Washington Collado, and I want to thank you. I've grown as a leader during this tenure, and I wanted to personally thank you for that.
Thank you.
I just want to echo that. I won't cause any more trouble here today. But I want to thank the board and also just mention that I think it takes a great deal of courage to, as board members who are elected, to go out and support a bond for employee raises. So I really want to commend you for that. The teachers deserve every single dime of that money, and I just think it's tremendous that you were willing to do that. I want to thank you for the raise today, and we look forward to resolving the salaries for the coming year as quickly as possible, and I'm sure you all do too. And also, poor Dorothy Davis, I mean, it's like Hotel California around here, so I want to thank Dorothy and her great team for all the work that she put in helping to resolve and solve the contracts for this year. So thank you very much.
Thank you.
My name is Pete Tingham. I'm the Executive Director of SMAB, the district employees. Again, I'd like to echo what Mr. Vesey and Ms. Maxwell have said about the pay raises. We appreciate that. Also, I'd like to, on a note, just say that the board and Mr. Runcie have always performed very, very well when it comes to raises, and pay equity has been a big issue with them. As was stated previously, we would like to settle the 1920 school year as soon as possible. We appreciate the raise for this year, and also to congratulate Dorothy Davis on becoming Rabbit Redux and returning and doing an excellent job. We enjoy working with her. Thank you.
Thank you.
At this time, we would like to ask for your consideration and support of the PBA collective bargaining agreement and the salary schedules for the COPA, ASMAB, and BPAA units.
Thank you. Any comment from my colleagues on items GG 1 through 4? All those in favor of items GG 1 through 4 indicate by saying aye.
Aye.
Aye. All those opposed say no. Items GG 1 through 4 pass unanimously. Thank you.
Thank you.
At this time, the board will hear committee reports. If you are here representing a committee, please come to the microphone, state your name and the committee you represent. You will have 5 minutes. Dr. Neesmith.
Good afternoon, school board members and Superintendent Runcie. My name is Carolyn Crone, and I'm the Vice Chair of the District Advisory Council. Today, I am presenting our final DAC motions of the school year, and I'm providing you an update on our school website improvement initiative that was presented to you last June. It has been a very productive year for DAC under the leadership of Veronica Newmeyer. Attendance was strong, stakeholders from all the various groups were represented, and numerous motions were passed at our general meetings and presented to you for consideration. We hope that each of you will be appointing a representative to sit on DAC for the next school year, and we would be honored if each of you would consider speaking at one of our meetings. The following motions were presented at our last general meeting on May the 8th, and you have those in front of you. Motion 1. We move that the Audit Department review the School Advisory Council school accountability funds when they audit the school's internal accounts. This passed unanimously. Motion 2. Whereas the school district strategic plan, Goal 3, effective communication, lists the following tactics: enhance communication and engagement with families in the community, improve the user experience with the district website and other district communication tools, provide excellent customer service to all stakeholders, and maximize and grow external partnerships to support students, schools, and programs. We move that all district committees and task forces, along with those committees that are formed to review and make policy recommendations, have their meetings placed on the district calendar, and notify committee members at least 5 days in advance, along with supporting documentation, and to inform and communicate with all stakeholders of scheduled meetings. This also passed unanimously. And now for the school website improvement update. As part of the DAC's purpose of promoting and encouraging parent and community involvement in the schools and assisting the school board on key issues that serve in the best interest of students, 1 year ago this month, we provided you a detailed, categorized list of approximately 70 suggestions in the form of a principal's checklist to improve stakeholder accessibility to vital information on schools' websites. This was a huge undertaking of a DAC subcommittee that was formed to address the lack of information being provided to parents, students, school staff, and community stakeholders on most schools' websites. Since then, we have had many opportunities to share our concerns, our ideas and concerns with Mr. Ed Heinlein, and he has done a fabulous job collaborating with us and providing training to each school's website designee. Unfortunately, the district's IT team can only do so much. Each school must finish the job themselves if they are interested in improving the user experience by providing relevant, organized content that can be accessed quickly and easily by stakeholders. There is no communication tool that is more important than the school's website. It has been 2 years since the new website templates were launched, and currently school websites are far from meeting the needs of our school communities. It should not take over 2 years to accomplish this. And principal autonomy should not be the excuse. Principal autonomy should be used in choosing how to market and highlight their individual schools, not for deciding which vital information should and should not be accessible to parents, students, and staff. If you want to truly increase involvement in our schools and empower parents to be engaged in their children's education, then information needs to be clearly communicated. If you are serious about meeting goal number 3 of the new strategic plan, effective communication, then with all due respect, this directive needs to come from the top if continued progress is going to be made. After many hours of reviewing schools' websites, I can assure you that some progress has been made, but most schools have not implemented over 50% of the recommendations, and outdated information continues to exist. And finally, we have 2 requests today. For the upcoming school year, we are formally requesting an updated list of committees that DAC has a seat on, along with district staff members' contact information that is charged with leading each committee. And my second request is, in April, we submitted proposed revisions to Policy 1.2. Can we please expedite this request so that we know if our DAC and area bylaws can be amended to meet a different membership composition? On behalf of the District Advisory Council, I would like to thank all of you for collaborating with us this year, and we look forward to continually working towards our common goal of helping all students achieve. Thank you.
Thank you. Any additional committee representatives? Yes, Ms. Korn?
I'm sorry, can I just share one comment?
Sure.
I strongly echo the website conversation. It can be a very effective tool, and it is dramatically different from school to school regarding what information is available and updated. I would ask, as we get ready to kick off the next school year through Dr. Wanza and our cadre directors and ultimately through Mr. Runcie, that we have a goal across the district that all principals work with their staff on their websites to make sure they are updated for the 1920 school year. And I don't mean just their main page. I mean, whether it's athletics, their school directory, other clubs that are involved at the school, and links. It's very important, and I 100% echo and concur that this is a tool that we already have in place and we just have to make more effective. Thank you.
Thank you, Ms. Korn. Mr. Runcie?
Yes, Ms. Korn, I agree 100%. I think that's a very under-leveraged communications opportunity for us. I actually wrote down exactly what you said when the comments were being made about that, and that is to work with OSPA this year and have this as a principal accountability item that we have their websites updated and that's a responsibility that they take on this year. I think that's appropriate and necessary, so thank you.
Thank you.
Thank you.
Any additional committee reports? Okay. At this time, I think what we'll do is we will break until 1:05. Give everyone an opportunity to grab something to eat and take care of any business that you need to take care of during that time. And then we will be back. So this meeting will be in recess until 1:05. Thank you. Good afternoon. This school board meeting is now reconvened. Mr. Moquin, I believe G4 is next on our agenda. Thank you. May the chair have a motion and a second on item G4?
So moved. Second.
Moved by Ms. Rupert, second by Mrs. Aladeff. Audience input on item G4. I have Ms. Levinson.
Yes, I just wanted to make a comment on a retirement. Ms. Joyce Siegel, been a teacher for 36 years, retiring from Cypress Bay High School. She's impacted thousands and thousands of students. She's an English teacher there, has taught so many kids how to write creatively, and how to be passionate about their thoughts. So I wish her the best and thank her for the influence she's had on so many of our students.
Thank you, Ms. Levinson. Any additional comment from my colleagues on item G4? All those in favor of item G4 indicate by saying aye.
Aye.
All those opposed say no. Item G4 passes unanimously. Let me just check for the record. Ms. Korn, are you on the line? Ms. Korn? Thank you. May I have a motion and a second on item G5?
So moved.
Moved by Ms. Rupert. I need a second, please.
Second.
Second by Mrs. Aladeff. Audience input on G5. Seeing none, I have Mrs. Aladeff.
So the requested action is to approve the recommended supplemental pay positions of employees for the 2018-19 fiscal year. And then it says individuals listed meet the requirement for the supplemental positions. Then there's no exhibits. So what are we approving?
Excuse me. Through the chair. So all of the G items are put in at the point where the agenda is beginning to be constituted as holders. Historically, if there were no supplements, that item has been left in case there was a last-minute supplement. I actually questioned that because to me, the action, in my mind going forward, and we'll discuss this further. So for the public, there are no supplements. You are approving nothing. I don't know if that's the right way to say that. I think the recommendation going forward from staff will be to have Mr. Runcie withdraw G5 if there are indeed no supplements, but you're not missing anything. We're requesting that you approve no supplements, and thank you, Mrs. Aladeff, for making that clear.
Okay, thank you.
Thank you. Any additional comment from my colleagues? All those in favor of item G5 indicate by saying aye.
Aye.
All those opposed say no. Item G5 passes unanimously. May I have a motion and a second on item CC1?
So moved.
Moved by Ms. Rupert. May I have a second, please?
Second.
Second by Mrs. Aladeff. Audience input on item CC1. I have many of my colleagues listed to speak. Dr. Osgood? Okay, I will come back to you, and Ms. Murray and Mrs. Aladeff.
So on page 4 of policy 5006, it says there was clarifying language in alignment with the Marjorie Stoneman Douglas Commission report recommendations. The change that promise is a mandatory program which is eligible to students of at least 11 years of age enrolled in District 6 through 12 school program. What I wanted to get clarification, I know Barbara Myrick, our general counsel, did an opinion regarding Promise not being a diversionary program. And I wanted to, I'm sure my colleagues watched, the MST Commission actually slammed Broward schools on promise, saying that it was not a diversionary program, and the commission was saying it is a diversionary program. So I wanted to make the motion to change the language in our policy to say that promise is a diversionary program.
Through the chair.
Yes, Ms. Rupert?
Ms. Alhadeff, can you tell us which page?
Page 4, policy 5006.
Of the slides, so that it's going across? Okay.
Yes.
Thank you. Thank you, Ms. Brinkworth.
So, good afternoon, Board, Superintendent. This is Dan Gold, Chief Academic Officer. So just to let everyone know, it is a summary of changes document that the board member is referring to. The question of diversionary or not diversionary is related to but not part of our policy. So I welcome the opportunity for the discussion that the board wishes to have on this. I would just like to distinguish that regardless of any discussion or changes that happen to that. We have brought the policy in and of itself into alignment with relevant statutory language as well as previous board discussion. And the point here is under 5.6, where the change is to have promise accumulate throughout the course of a student's career as opposed to an annual reset. So that is what the board as well as the commission had previously recommended. I was the representative from Broward County Public Schools who spoke to the commission and did hear their input as it refers to it. When it comes to the definition of diversionary, I'll defer to our general counsel who wrote the relevant memos. We as staff are applying promise as an alternative to external expulsion and suspension. The use of diversionary when it refers to criminal activity is outside the scope of us as staff to make a determination of. There was quite a bit of discussion about diversionary definitions as it refers to as statutory criminal charges, which would come from the district attorney's office, and the use of diversionary as a capital D complying with what the district attorney applies, and diversionary as we apply it, or alternatives to external suspension and expulsion. Ms. Myrick, I turn to you for any additional comments that you would like to make.
As I said in the memo, and the purpose of it was looking at what it says statutorily. If I was somebody walking down the street and you asked me if the Promise program was a diversionary program, I would say, yes, it is, because it diverts kids from being arrested. But it is my opinion that it does not meet the statutory definition of diversion. I think those are two different things. So I am fine. I mean, my opinion is if you want to put something in policy, I don't think that, I think that was the opinion of the commission about whether it was a diversionary program or not. At the last meeting of the schoolhouse to jailhouse meeting, there were several members of that committee that agreed that it was not a diversionary program by statute. But I think everybody realizes that it does divert children from being arrested. As was discussed at the meeting at the commission, is that our Promise program is a hybrid because we accept children, or did accept children at least in the Promise program, both as a diversion to an arrest or a criminal, or had maybe committed a delinquency act. But it also has children that, for behavioral issues that are non-criminal in nature. So it is a hybrid. because of that, the issue of the reporting process was discussed, and I'm fine with how you all want to handle what you want in the policy. I think that's it.
You're on the list, Ms. Bartleman. Ms. Saladef, do you still have additional questions or comments?
Okay, so I would like to hear from my colleagues as far as what their thoughts are on that, whether promise we can change that to saying that it is a diversionary program. I want to also talk about page 27, suspensions and expulsions. So it says, note, a student may not be subject to mandatory expulsion proceedings if it is determined that the student immediately reported or delivered the firearm or weapon to a staff member. The term immediately means without delay, as determined by the principal after considering the totality of the circumstances and prior to being reported by another individual. I feel that they should not be given that option, that they would not be mandatorily expelled. So I think that where it says that they may not be subject to a mandatory expulsion, I think they shall be subject to a mandatory expulsion. Page 27. I think this is way too lenient, that if someone is bringing a gun into our school, that there should be zero tolerance for that, and they should not be given a second chance to not be expelled.
So through the chair, what I'd like to do is call on staff to talk about why this asterisk and definition has been found to be relevant in the past. Ms. Deborah Kearns, please introduce.
Good morning, Deborah Kearns, Assistant Director at School Climate and Discipline. So the piece that you're speaking to, it's been in School Board Policy 5006 as long as I'm aware of, and I've served in this capacity now for about 9 years and practiced under this policy for many years as an administrator at the schools. It is meant to be considered for mitigating circumstances, and I assure you, in all the time I've worked with this policy, I've only seen it used on a couple of occasions. It is not to be applied when a child is violating the rule which says you cannot possess, use, or display a weapon at school. There might be a circumstance, for example, perhaps a child finds something and turns it into the school administrator. They then had in their possession a weapon. The student that has the item in their possession would be subject to the violation of the rule. But then through the due process opportunities of School Board Policy 5006 may not then need to have the expulsion imposed upon them. It's a caveat that's there to be used in mitigating circumstances or extenuating circumstances when truly a child, the spirit of the behavior is not the spirit of the policy and the language and the consequence. When I think back over the past 9 years or so working with this policy, there's probably maybe 5 instances where something like that has occurred, and it's never been when a child was in possession of a firearm, and it's usually when there's a special circumstance and they were truly either, as soon as they recognized something, they relinquished it mistakenly, or they were in the process of helping the administration become aware of something.
Okay, I'd like to hear from my colleagues.
Thank you. I have Ms. Levinson.
I had actually meant CC too. Sorry, I gave you the wrong.
Dr. Osgood.
So my comment was on page 5, and it was the direct opposite of Ms. Aladaff. I wanted us to remove the word diversion program. I think if we're going to leave it in, it goes back on what we decided in the workshop. We made a point that it was an alternative program, an alternative to suspension program by definition and statute. And the reason why that's so critical, if we are going to consider changing it now to a diversion program, I'm going to ask you for the privilege of being able to have community discussion about that, because I think that that is a sustainable change to the program, because then it will require all of the children, whether they've committed a crime or not, that go into this program to be put in the Department of Juvenile Justice system, their database, and I am adamantly opposed to that. If we're working to eliminate the schoolhouse to jailhouse pipeline, I think that if we're going to have a program like Promise, we can't do it in a hypocritical way. We have to be consistent. We have to either work to eliminate the school to jailhouse pipeline in a way that we have been doing with the changes that we were required to make. But if we're going to require this to now be a diversion program, by statute, it follows a different set of rules and requirements as it relates to reporting and how kids are handled through that process. That's why we have made the distinction that clearly that it's an alternative program and not a diversion program in the literal sense of the law. So if that is the pleasure of the board to now go back and change it, then I think that we owe a courtesy of conversation to our schoolhouse to jailhouse pipeline, as well as to the community as it relates to that. I am not for having kids put in the criminal justice system for petty misdemeanors. I think the list that the individuals that created the Promise program, contrary to what people believed before I was ever on the board, I think they did a very good job in vetting those things and making an attempt to have Broward not be the leading school district with arresting kids in school. I think that we continue each year to look at the policy, review it, and make modifications to it so that it meets the outcome of not having kids be put into the criminal justice system for petty behavior issues that they have or petty misdemeanors. So when we talk about Promise and kids committing crimes, I think it's very important that we be very specific. It's a list that's stated in here that was 13 that's now been reduced because we've made some adjustments to the list of the Promise eligible infractions. And we have that list here, and it's only those petty misdemeanors that's on the list. It's not felony convictions. If kids are committing felonies, then they go through the criminal justice system. If they have a second infraction, law enforcement is contacted. We've included law enforcement in our threat assessments. So I get aggravated about this because this really impacts children that look like me and children that are in the schools that I represent. So this is a very serious issue for me and for my community and for people that look like me. As you all are aware, you watch the news like I do. You see how black people are beaten up and mishandled and treated by the criminal justice system every day. So I think this board has taken a bold leadership statement and making sure that we have processes in place with our children, regardless of their race or ethnicity, that we try to help keep them in school and out of the criminal justice system until we have brave policymakers on other levels that really get serious about addressing the injustices of the criminal justice system. I find it mind-blowing even today, and I totally agree with Ms. Alladaf's second statement about kids bringing, or people bringing firearms to school, but I have state legislation that want me to arm teachers and put more guns in school. And so this kind of hypocrisy causes great harm for me. So I'm going to ask you for the courtesy today that if it is your desire to now make Promise a diversion program, that we give the community, specifically District 5, an opportunity to have a discussion with you about that and tell you how we strongly and aggressively feel that it will be harmful to our schools and to children that look like me. Because that was never my understanding and intent of Promise. That's why I was so upset when somebody on staff decided to just start putting information into the Department of Juvenile Justice System. Many of the children that go to Promise are there for behavior issues. So when we deal with this program, we have to have all of the facts, because now we bring a whole set of kids into the juvenile justice system that have not committed a crime. So we need to have continue to have as much discussion about promise as we need to have. It's just one attempt after another with the Promise program, in my opinion, to change the core intent of that program, which was to eliminate the schoolhouse to jailhouse pipeline. And the data has showed that we've done that. The data is still showing that we still have a disproportionate number of minority kids that are being sent to Promise. You know, and maybe that's because of the makeup of who's in our various schools. I don't know. But I am strongly opposed of moving forward with that decision without having the schoolhouse to jailhouse pipeline committee involved, as well as the community that I represent. As to the other recommendation that Ms. Allardyce had, I need staff to give me that explanation again, as you talked about the firearm piece, because when I read this, I was hoping that I was interpreting it wrong.
So, through the chair, a couple of points. Dr. Osgood, to your second point, the page 27 reference is the extraordinary circumstance where a student who did not bring a weapon on campus finds one, turns it in, technically was in possession, and by a literal reading of policy would therefore be subject to expulsion. If they carried a bag in and said, hey, I found this on campus, turned it into someone, and that bag should contain a gun, right? So there's extraordinary circumstances. We try and write our policies to take as much into account as possible. This is not a change. This is what has been present previously. As to your other points, I'd just like 2 points of clarification. One, the policy itself does not in any way classify Promise as being or not being a diversion program. The reference on page 5 of the summary of changes refers to when a student is found to have committed 3 or more Promise-eligible offenses. They then would be referred to a community diversion program. So the question that your colleague has raised about whether or not to label the program, currently the policy is silent on that question. And secondly, the page 5, I would recommend actually leaving there because it refers to something outside of the school district.
So I get it now. I misread what's on page 5, but that word diversion keeps coming up, and I clearly misread what's in number 3 on page 5. But I stand strongly behind what I said overall about us making a decision to make this as a diversion program. If that is the will of this board, I'm going to ask that we give the Schoolhouse to Jailhouse Pipeline Committee and the community, particularly District 5, that's who I represent, so I have to be that voice, the opportunity of having a conversation or even a notice that that's going to take place, that they could have been here today to speak and give input to it. I would not like to see us make that change today and not having it noticed in a way that people can come and voice their concerns and their opinion about that. So that's my comment on that. And also, as we are talking about this policy 506, there's been a lot of literature out lately about disciplinary policies and procedures and this whole notion of zero tolerance. And I know that we've done a great job to try to work within the guidelines of the law as it relates to zero tolerance. And it's one of those things we talked about earlier, that laws and stuff was enacted 5 years ago, and now we see that they're not working. And this is also one of those policies that's all the data with zero tolerance is showing how it strongly is now just creating a schoolhouse to jailhouse pipeline and negatively impacting graduation rates. So I wanted to just say that on the record as well. Thank you, Ms. Brinkworth.
Thank you, Dr. Osgood. Ms. Bartleman?
Yeah, I wanted to give you guys the history on the policy change as to the gun, why it's there, because I was here when it happened. So it related to a specific case. There was a ROTC cadet who was Cadet of the Year and won all these scholarships. He slept at his friend's house over the weekend. They went paintball shooting. when he was hurrying up and getting ready to school, I don't know if any of you were here for this one, he accidentally left the paintball in the backpack that he used for the sleepover. He self-reported the gun right away to the administrator, the paintball gun, not the real firearm. But because our policy was zero tolerance, which I agree with, and he was actually an African-American cadet, so because the policy was zero tolerance, the cadet who had just won an award and all of these great things, he had to sit in an expulsion abeyance center for the whole year and miss out on all his coursework and everything when it was a self-report situation and it wasn't even a real gun, it was a paint gun. So you're always going to have those little nuances, and that's why it's really important, because it's not one size fits all. And that was a child's life, and we can never give that child the year of his life that he missed. It impacted him dramatically. And so you have to have, there are going to be situations where things like that happen, and you have to trust that the staff is going to make the decision and ensure the safety of our children. But you have to have flexibility sometimes. It's the same thing with the projectile language. When we expelled the 11-year-old for the Nerf gun. We had no flexibility. We looked ridiculous on national TV, but we had to do it because our policy was zero tolerance. So you have to have some flexibility there. So that's why that was written in policy that way. So, okay. Now I just want to talk, okay, so I don't want to discuss Promise because I think Promise has helped many children and is very successful with those children, and they don't have any recidivism. It makes a difference, and we have eliminated the schoolhouse to jailhouse pipeline. What I want to talk about are the specific requirements in 7026 and 7030 that the grand jury will be looking at school boards across the state to ensure their compliance with the safety bills. I happened to go to the FSBA where they talked about this, and it is our fiduciary duty to make sure as school board members that Mr. Runcie is implementing everything in this bill. If he is not, I think his salary gets taken away, our salary gets taken away, and it will come out like that we're not following the policy. So I would request, and I actually put something in writing and asked Mr. Runcie to confirm in writing with me that we were following everything that's supposed to be set up, because they are convening supposedly now. And I thought it was important, and I'm hoping I didn't copy all of you, but I think it's really important that we have in writing that he is following every letter of the law, because we as board members will be held accountable for that. So the issue here is not a diversion program, Promise, it's none of that. It's the work group that's in 7030 that talks about communication. Right now, on record, we are not communicating. Take out whatever program you want to talk about. This is what was stated at the commission meeting, that we're not communicating, and that's why MSD commission slammed us. I don't follow, it's very clear. You're supposed to have a work group. It's on page 20 and 21 of the bill. You're supposed to have a work group, and you're supposed to come up with reporting, just how you're going to communicate. It's all in there. So take out everything else. Don't make it a promise. Don't make it any of the. What have you done to comply with page 20 and 21 of the bill, which this is the 7031. I'm trying to find the pages in 7026 now. Technically, you have till December of 2019 to get this one in compliance. But I don't know what 7026 language is, if it's the same language that's reflected in 7030. So what I think we as a board members need to ask you to do is, what was the to-do list in 7026? Have you complied with all of that? Take out all of the extraneous information. Have you complied with 7026? And then have you set up what you need to set up for 7030? And I, as a board member, I don't care, you have to do it. There is not a choice. We have to comply with the law. We are under a microscope. We're not complying with it if we're not communicating based on 7026 guidelines. Unacceptable for me as a board member. You need to go through, because I'm going to be held accountable to this, to the public, and so is this board. Are you complying with everything in 7026 and 7030? Are you setting it up? And I want that in writing. And I asked for that in writing via email. And I would like that. And I want a breakdown. And if I have to go through and break down the bill myself, I will. But I think this is important enough that somebody on staff should have gone through and made sure that we have complied with every last letter of the law. And I'm really hoping we did that, because I have faith in many of you, and that needs to get done. So whatever you have to do to figure out that communication component, you have to get it done. There's no, whatever it is, not the bullying kids, just get the work group going and figure out how you're going to comply with the law. You have till December of 2019. But you don't have till December 2019, because you should have been complying with 7026 already.
So through the chair, let me make very clear that this administration, under the leadership of our superintendent, is tracking every statutory requirement extremely closely. We are in full compliance with 7026. We have the documentation in partnership with our Legislative Affairs Department. Each and every chief makes sure that we discuss things. We will provide for you the breakdown of 7026 and the mechanisms by which we became in compliant. As it pertains to 7030.
I asked for that a while ago in writing, and I didn't get anything. So if you've done it, which I'm very excited you have, why didn't I get a response in writing?
So, Ms. Bartman, I'm not sure which correspondence you're referring to whom it went, or when it went, but we will.
It went to the superintendent.
We will look through it. As it pertains to 7030, 7030, as everyone is well aware, just recently passed. We are still awaiting guidance documents from the DOE, in particular, which now has enforcement authority, unlike that which it had under 7026. And we will be in full compliance. We are actively analyzing it and awaiting things. Some of it's pretty clear. Some of it is confusing. We are well ahead on some domains. We are waiting on clarity on others. But we will provide guidance and full documentation on the ways in which we ensure compliance on each and every aspect of the questions you have raised. Your concerns will be assuaged when you see our response.
Music to my ears, because I just want to hear that we're in compliance. And you have stated that on the record. I'll have it in writing. The public hears it. We hear it. There's no question. We're in compliance on every level. I feel very good. And then if you could just follow up with that in writing for me, I'd appreciate that. Thank you.
Thank you.
Thank you, Ms. Bartleman. Ms. Good?
Well, I just, again, I want to thank Mr. Gohl and Mr. Moquin and Dr. Wanza. They recently attended the safety task force for the League of Cities, which, you know, we had lengthy conversations about a lot of different things, and it's quite impressive of the amount of work that our staff has done to ensure compliance with all the requirements. And so I really want to commend you and the superintendent for your efforts. And I appreciate you saying it here on the record. You know, I don't think it's necessary that you have to put it in writing when you've just stated it here. But nevertheless, I just wanted to talk a little bit about a couple of points. And I even spoke to Ms. Myrick a little bit about this. And I think that when people hear the words diversion program, I think it really speaks to what we're doing. I think that, you know, we're diverting students from going to jail to an alternative route to get through our educational system. But I guess that word diversion also has other meanings to the way information is captured and shared. So it's, I think, a two-pronged problem, an issue of how we communicate what it is that we're doing. I don't think that we're trying to avoid communicating or reporting what's required. I think it's really critical, and I think you've said this many times, how we share information with law enforcement. So I think what got lost in translation is when we spoke about the Promise program not meeting the I guess the legal requirements of a diversion program, we were really focused on that reporting issue that was occurring and how students were being wrongly attributed to their offenses and making them, I think, a higher level of infraction than what it really was. So there was great conversation at the task force about it. We tried to clarify some of the points. There was reference made that there are many more students being arrested today, not because of what we're doing, just for the mere fact that more individuals within the community, even our own student population, is reporting situations that are of concern to them, and therefore law enforcement is more involved and threats are taken very seriously. And as such, there's a greater number of individuals, students, that are being impacted by that. But nevertheless, I think what the focus should be, the reporting, aspect of what we want to do. And so, did I miss in here anywhere where we're speaking to our desire to report some of these infractions? I know that we spoke about, because we got focused on not calling it a diversion program, therefore we're not required to do that, but we spoke at length about the desire to report. And so I don't know if that's captured in here.
So Ms. Good, thank you for raising these very important questions. And what was discussed at the Broward League of Cities meeting earlier this week, as well as at the commission meeting, referred to the need for institutions, both those in law enforcement as well as those educational, not just Broward County, but throughout the state of Florida, need better guidance and systems in order to do it. The commission chair himself spoke of the presence of programs such as Promise as hybrid programs that are serving multiple definitions of the word diversionary. And in making those remarks, in addition to the critique that he and several other members of the commission felt that it complied with the law enforcement definition of diversion, he also concurred that Broward County Public Schools was behaving appropriately in the absence of clear guidance from the state. He expressed the expectation, and we provided the commitment to bring clarity to what we will do here in Broward County prior to the commencement of the 2019-20 school year. The superintendent has been clear with myself, Chief Katz, Dr. Wanza, and others that we are to do it, and we have several meetings commencing next week in order to meet that expectation.
And I know we've been working, I know Mr. Runcie, you've been working with the Chiefs Association, so it's a very complex, effort by the district, law enforcement, within the municipalities, obviously, by the Chiefs Association, BSO. So I just want to make sure that the takeaway is that we want to share information accurately.
100% true.
And at the same time, we don't want to penalize a student by entering information into a system that somehow is going to change that information to something that's of more impactful to them, and then somehow it throws them into some civil citation situation. So
it is the appropriate information in the appropriate way, so the appropriate consequence follows.
Right.
And
so what
that
we want is interventions. We want
absolutely.
these children to get proper interventions. So, Mr. Runcie, when we had the workshop, and I think there was conversations about ensuring that somehow we can come up with some kind of reporting mechanism. I don't know where we are with that, if it's possible. Did we find out if it's something that, we as a district can do to accurately depict what's happening within our school system?
Yeah, so, Ms. Good, you're referring to the option that we put on the table to create
Yes.
a separate data repository that we would allow local law enforcement to get access so they get accurate information, not information we post to a state database that gets reclassified
Yes,
into
sir.
something else. So we're continuing to have conversations with law enforcement on that, and we'll have to engage our IT department and figure out what the scope of that looks like, and then come back to the board with a recommendation and possible costs for building such a data repository and how the security and access would work. I mean, there's a lot of particulars to be
Yes.
worked out for that. And so that's an alternative path we're on until we can get some further clarity from the state.
Because we were advised already. Yeah,
And I would say anytime there's any, incident at a school where we certainly need to involve law enforcement, we provide them access to all the information that they need at that point in time. This is a request outside of school hours, outside of the school day, that they're able to get access as well.
And I guess a lot is happening outside of the school environment, so children are being impacted. And so we just need to make sure that when they're within the school system, that we are providing the necessary resources, the right interventions, and certainly in an effort to communicate with all stakeholders, we need to make sure it's done correctly in a way that doesn't penalize our students. So, you know, I guess I speak more to the point that it is a hybrid sort of program, and that for me, the real critical component is that we make sure that we're able to come up with a system of sharing information that helps all of us, and it works both ways, both from law enforcement to the school system and from the school system to law enforcement. And I forgot to thank Chief Katz, because I know that he also has been working with the Chiefs Association, and I think we finally have a good opportunity of sharing of information and collaboration to make sure that ultimately we come up with what's best for all our students. So I thank all of you, and I thank my colleagues for their comments.
Thank you, Ms. Good. Before I go back to some of my colleagues who have additional comments, I just want to say that, oh, I'm sorry, Ms. Corn, I didn't realize you were I'm sorry. I'm sorry.
That's okay. I was listening. I didn't want to interrupt.
Okay.
Can I just make a quick comment?
Actually, I had Ms. Levinson where I had marked off that she wanted to
I'm
speak.
sorry.
Yep.
Perfect.
Ms. Levinson?
Thank you. To comment on the two items that have been brought up, I thank you, Dr. Osgood, for your full, detailed explanation about Promise. I recently read an article in Forbes the other day that talks about school policies on discipline, and that all the recent research is showing that in reaction to school safety, putting in measures into schools, security and more armed personnel, as opposed to looking at supports for our students. And all the research-based evidence shows that that is where we need to be moving. And so when you look at the 10 Promise-eligible incidents now, these are all, as we know, misdemeanors. They are not felonies. And when we look at this whole situation that has been brought up, we are talking about patterns of behavior. And so even in Promise, when you have how many incidents it gets reported to law enforcement? Ms. Appleton, how many incidents?
Already stopped in school climate and discipline. Each of these are potential misdemeanors. However, it is at the discretion of the law enforcement officers if and when they choose to issue a citation or make an arrest. So I don't have their numbers as it stands right now with regards to the Promise infractions on what they've arrested.
No, but we have where you have to go in front of Judge Williams, and you have, I mean, you are...
Oh, our JJSC process? For this school year, oh, I do have that data. Hold on.
Because my point is, it's not something that is not looked at. It is, you know, you are, a large group of people sit around, discuss, and you have to go in front of the judge. And is it the second incident?
On page, if you look on page 5, it's right there on page 5.
With the JJSC, when the Promise eligible infraction occurs, the student is referred to the Promise program.
Right.
If the family and the student do not engage in the Promise program, then there is a referral to the juvenile justice system of care. And I think that's what you're asking about. Is that what you're asking about?
Oh, I think the board member is actually referring to the fact that if a student has 3 Promise-eligible offenses, it is then escalated up. In addition, should a student be assigned a Promise and not appear, they also go in front of the judge.
Automatically.
Automatically.
If they don't.
So even on 1, if they do not comply, excuse me, with the conditions of the program, it is escalated in front of Judge Williams.
Yes.
Okay. And then otherwise, it's on the third offense of these misdemeanors.
At which point they are now no longer eligible with 3 throughout their career.
Okay, so I wanted to point that out because when you go on and you look at, I was just reading another article about it, and it talks about a pattern of disciplinary behavioral problems, substance abuse problems, and our Promise program, that's what it does. When you have demonstrated a pattern of 3 times, you are automatically put
Yes, and
into that.
Promise
So-
is one tool within an array of approaches we take. All misbehavior has consequences.
Right.
Some of it falls under the disciplinary matrix, some of it is felonious and therefore goes well beyond Promise, some of it is non-misdemeanor and therefore does not qualify for Promise.
Right.
Promise is about 3%, if I remember our numbers.
But the point I'm trying to make is you want to get a full picture on a student. That's what we discussed in our workshops, that we are able, with law enforcement, to work together to get a full picture of a student in school, out of school. Not when a student makes a stupid mistake and the suspension and expulsion, we looked at this in the first place because what was happening with suspensions and expulsions is it was perpetuating the behavior problem. They weren't getting the supports. So when we do the Promise program like this, so I guess it's a roundabout way of getting to the diversion program, that I don't see it as the traditional type of diversion program that's being referred to as. You know, it's a way to get our students support, but we as a board want a full picture. Ms. Good was just talking about it too, having a full picture of what's happening on a student. But I don't want to go backwards in all the practices that we've done that are actually, all the research-based evidence now is supporting that what we've been doing is in the best interests of students. And, you know, it says that, you know, 90% of school shootings have been done by current or former students who have been expelled or suspended, and an act of violence is what follows. So, and, you know, unfortunately, we saw that in our district too, about expulsion. So to me, I don't want to go backwards and start doing that more. That is what should happen when we have the pattern that we have here. And to get to Ms. Aladef's second point, I agree with her about zero tolerance with weapons. And so I understand what you all are saying, but there has to be another way to write this. I don't think you put something in there that can be misinterpreted. I think you need to put something in there for the exception that there's discretion. If a weapon is found and we need to make an exception, but to say that they are not immediately expelled, that we have zero tolerance for that, weapons in our schools. That's not a minor misdemeanor, which is what we're talking about with our Promise eligible offenses. We're talking about night and day here. So, you know, I'd like to see it written a different way, and I support writing it a different way because I think it can be totally misinterpreted the way that it's written in there right now. So I don't know if there's a suggestion of how we can, you know, she can maybe make a motion after we hear from everyone, if everyone agrees with that, where there's a way to do that. But I think, you know, we have to have zero tolerance on those things, and we have to continue our research-based practices on minor misdemeanors. I think we can't convolute the two.
Thank you, Ms. Levinson. Ms. Korn?
Hi, okay, sorry about that. On page 5, I'm going to just kind of stick with this conversation, and then I'll change over to page 9. I'm a little confused on page 5, midway through, under F, zero tolerance, third paragraph down. The sentence starts with, however, if a student commits more than one misdemeanor, the threat assessment team must consult with law enforcement to determine if the act should be reported to law enforcement. Then there's a note under it in italics that says a threat assessment team may use alternatives to expulsion or referral to law enforcement agencies unless the use of alternatives will pose a threat to physical safety. They seem to be in conflict with each other. So help me understand which of those prevails.
So let me be very clear that our new policy 2130, as well as our previous procedures to the elevation of those procedures to policy, does require that any threat assessment team that convenes does involve law enforcement. There is no question about that. The threat assessment team also does not deliver discipline. It is part of a overall process, and this was something that in several different venues at Block, at the Marjorie Stoneman Douglas Public Safety Commission meeting, and in other venues, we talk about if an incident happens that it is determined is a threat. You have disciplinary procedures, potential criminal procedures, and threat assessment evaluations going on simultaneously. And those agencies that are involved need to and do share information. The policy you passed requires it and holds accountable both the school principal, the cadre director, the Office of Academics, and the Office of School Safety, Security, and Emergency Preparedness to ensure that happens, establishes an audit expectation with reports to you to ensure that it has happened. So, Ms. Korn, I don't want to leave any ambiguity around whether or not law enforcement is involved. When a threat assessment is conducted, it may involve a threat to self and not a threat to others. So a consequence there is not going to fall within the disciplinary realm. So this could also be improved in terms of its language. The threat assessment team is involved with and shares information with the disciplinary team, but the threat assessment team does not recommend expulsion or referral to law enforcement. Law enforcement is involved.
Okay, so then maybe it would just be helpful to be able to have some type of definition regarding the consulting at the end of that paragraph and the referral in the italics. I know we discussed this at a board workshop, but I have to tell you, as we know that this is going to be examined and potentially at some point could be certainly taken to a court of law, I think we should be extremely specific about what those things refer to and how they are not just different words intending the same thing. So I would prefer us to have some type of definition around that.
So Ms. Korn, thank you for raising this. I have just been made aware by staff that this section is an insert that is drawn directly from statute 1006.13. And so therefore the language may be referring to districts that have procedures other than us. Our policy governs how we do this. We do involve law enforcement, and we do separate out the threat assessment procedures from discipline. The note is pulled from statute.
Okay, so then at the beginning of this paragraph, it says pursuant to Florida statute 106.13. I guess my question would be, does the italics also come within that statute?
Staff is nodding their head yes.
Okay, then we're clear. Perfect. Going down to letter G, under the note number 3, it refers to the fact that there's 3 different items stated. The last one says, additionally, a student who has accrued 3 cumulative incidents from the list shall be referred to a community youth support diversion program. Obviously, if this is a diversion program, we wouldn't be referring to another diversion program. So to Dr. Osgood's point, I agree that if we are going to go the route of this being a diversion program, we need to go back to the community, because that, I think, changes dramatically the impact of how this promise program impacts each of our students. So I agree, if we go that route, it needs to be further vetted. I also agree with the zero tolerance when it comes to a weapon, and that we have to address that language. You can find some way around it other than, I think, the language that we have now. I would agree with Ms. Levinson and Ms. Alladette. I'm not comfortable with it. And I think that should fall under zero tolerance without the exception the way it's stated. My last statement is on page 9. This is under the A2, the use, possession, sale, transmittal of e-cigarettes, vapor devices, and components of e-cigarettes. We talk about a first offense, the secondary level being 1 to 2 days of in-school suspension, and a second offense being a suspension from school for 6 days. We've discussed this at length at the board workshop. I will not support this policy with this in it the way it is. We give so much latitude on so many different student decisions. This decision specifically impacts the student themselves and their own personal choices, and somehow we're giving a harsher response to this than to decisions students make that negatively impact other students. I am perplexed as to how we go to 6 days of suspension for a secondary possession of an e-cigarette or vapor device. I understand what was shared by outside entities. I cannot support that. I'm not going to offer an amendment because I believe maybe one of my colleagues would support it. I do not believe that I had heard from my other colleagues that they agree with me, so I'm not going to belabor the conversation, but for that reason I won't be able to support the policy. Thank you.
Thank you, Ms. Korn. Let me check my, okay, so now I'm going to make my comments and I'm going to go back to my colleagues. I have Dr. Osgood and Ms. Bartleman with follow-up comments. So in reviewing the policy and having conversation with Ms. Myrick about the whether or not Promise is a diversion program and how we talk about it, the reality is that this is about communication. And so this is about communication from us to the agencies that are looking for the information, as well as them providing the information to us. Because in order for us to make good decisions in the best interest of students, we need to have the full picture of what's happening with that student outside of school. Because if they're getting a Promise eligible for drug possession, and they've already had civil citations in the community for drug possession, then the problem might be bigger than what we might think if we didn't know about what had happened in the community. So we need to be able to provide the best interventions to the students that we serve, being fully informed, as well as law enforcement having that same ability to have the information. I don't want to see students receiving civil citations as the law enforcement entities are saying if a disciplinary action that isn't a misdemeanor is being put into a system that then is being flagged as a civil citation for students through the lens of law enforcement. I think that's an unfair characteristic of school behavior then becoming something that it isn't. So communication is really important, and that's what I spoke to Ms. Myrick about. We've got to figure out how to make this happen. However it happens, sit down with the work group and make sure that we are having that flow of information so that we are aware and the outside entities are aware, and we can serve the students in their best interest and the safety of the community at the same time. So with regard to the questions, I guess I'm a little perplexed about staff's ability to answer Ms. Levinson's question, because on page 5 in the chart, the slide of changes, it clearly says, number 1, the Promise program is not intended to limit the discretion of law enforcement. Number 2, any student committing more than one misdemeanor must be referred to the threat assessment team, which includes law enforcement, to determine if the act should be reported to law enforcement. This is all coming straight from statute, right? That one for sure about this, because we were confused about how the threat assessment team could have law enforcement on it, but then they may consult law enforcement. That didn't make sense to us, but that came straight from statute. And then additionally, a student who has accrued 3 cumulative incidents from the list below shall be referred to a community youth support diversion program. So as Ms. Korn just said, it's identifying a community youth diversion program outside of what we're doing, which makes it seem like the law would say what we're doing is not a diversion program. Again, for me, it's about the communication and making sure everyone is aware of what has occurred on both sides. And I think one of the things that we need to do, I recently had a conversation with someone in the community who was not at all aware of the changes that we've made and how Promise is different than it was before. And I think we need to do a better job, Mr. Runcie, of ensuring that everyone is fully informed. I understand that, but I'm telling you,
Okay,
if I'm still
so-
getting questions from people in the community about how promise is, yeah, what is
So-
the answer to that?
It's two. And I'm sorry, through the chair, what you just mentioned that I brought up, it's on the second incident. Is that correct? Because if we're not answering it, we're not getting it out to the
Right.
community the right way.
Which is why I was frustrated when you were answering Ms. Levinson and I was looking at this page. Is law enforcement, according to what it says in this document, law enforcement is consulted on the second.
Yes, so that is to align with the zero tolerance statute, which speaks to what Ms. Korn had mentioned. However, if a student commits more than one, so there was language drafted within promise to ensure that there's a direct alignment with the zero tolerance statute.
I understand. And as a board, we don't want to know that you aligned policy to statute if we're not doing that, right? So on the second, let me ask you, any student committing more than one misdemeanor, are they referred to the threat assessment team?
Yes.
Okay, and does that threat assessment team include law enforcement to determine if the act should be reported to law enforcement for further action?
Yes.
That's the changes from 7 to 26. That's the alignment you were talking about, Ms. Bottom.
So the staff, I don't think they're necessarily asking what's in, you have in statute and a line in it, is what's actually occurring right now in schools. And then my understanding is that when there's a threat assessment, is that correct? Is what you-
Well, that was the question that Ms. Levinson asked, and she didn't get a clear answer. And I was very frustrated, and I know Dr. Osgood was frustrated because she was over there shaking her head. On page 5, where we are delineating the changes, it clearly says, are we currently doing this?
There is consultation with regards to a referral to the threat assessment team for all of our promise infractions that are associated with misdemeanor offenses. In addition to that, the matrix for this school year that is being proposed for the subsequent school years also has, for every misdemeanor as well as felony level infractions, a referral note for there has to be a referral to the threat assessment team for them to review each of those cases so that we can have a comprehensive understanding of the child, which is what the law enforcement officer that's on the threat assessment team can bring to the table, because they may have some of the outside information that the school district does not have for the internal pieces.
Okay, so I'm just going to ask this because I don't want the waters to be muddied whatsoever. We're only talking about promise right now. Promise program, a student commits more than one misdemeanor, they must be referred to the threat assessment team. That is currently happening, yes or no?
Yes, but it does not mean that a threat assessment is inherently conducted. Let me give an example because I think this will illustrate your point. If someone I'm on page 5, summary of changes, number 6, drug paraphernalia. That is a misdemeanor.
Are you in the policy now?
I'm on the summary of changes document, the landscape
Okay.
sheets. If a student has 2 of those, in order to align with zero tolerance and in order to align with both the spirit and the letter of the law, that student would be referred for consideration to the threat assessment team. However, possession of drug paraphernalia is not generally considered a threat to commence a threat assessment in the way that the behavioral threat assessment teams would require. So we have now a triage form that has been created, that has been in practice this year, to capture the referral and the determination that the commencement of a formal threat assessment, which involves law enforcement, psychologists, school administration, people who know, and then a determination is it a medium, high, low-level threat to the community. Under number 6, drug paraphernalia, that process of conducting a threat assessment does not occur, but they were referred to the threat assessment team for consideration.
Okay, and so after the comma, it says, which includes law enforcement to determine if the act should be reported to law enforcement for further action. So at the time, regardless of one of the eligible incidents, regardless of what the incident is, on the second misdemeanor incident, they must be referred to the threat assessment team. That occurs, regardless of what the incident is. And then, doesn't mean a threat assessment happens, it means they're referred to the team. And then that threat assessment team includes law enforcement to determine if the act should be reported to law enforcement for further action, regardless of what the incident is, correct?
Correct.
Okay. And then, if law enforcement, given what they know from the community, does not believe, because I will tell you, drug use, paraphernalia, possession, all of that, if there's something going on in the community that is larger than what is happening within our school, law enforcement person would know that, and then that might predicate something different occurring.
That's why we consult with each other.
Okay, so just to be clear, more than one misdemeanor must be referred to the threat assessment team, which includes law enforcement, to determine if the act should be reported to law enforcement. That is happening now, and that is what we're going to codify in policy.
Yes.
Thank you. On the second one. Yes.
Correct.
Okay. And then additionally, a student who has accrued 3 cumulative incidents from the list below, that's any 3 from the list below, shall be referred to a community youth support diversion program and to the behavior intervention team committee, as appropriate.
Correct. And those.
So are they always referred to community youth support diversion program?
Yes.
Okay. Because where it says as appropriate at the end is where I got a little confused.
That's for the behavior intervention committee.
Okay. All right. So I think that clears up what was still kind of muddy from an earlier question from one of my colleagues. And I just want to reiterate the communication piece. We have to get that worked out. I believe in my conversation with Ms. Myrick, Mr. Katz is working with agencies. Is that correct, Mr. Runcie, to make sure that occurs?
Yes, that's correct. And to your earlier question on communications regarding the changes to the Promise program, we issued communication out to all law enforcement agencies, all municipal elected officials, did a information press release, if you will, on that piece, I believe. So I'll just confer with Ms. Koch. Did we actually do a information release on that as well, the changes we made to the Promise program through the chair?
She doesn't have a microphone over there.
I know we sent it out to law enforcement and to our governmental agencies. I'm not sure if we did any kind of information release.
Thank you, Kathy Koch, Chief Public Information Officer. No, we did not do a general release on that.
All right, but we did send it out to the municipalities and the law enforcement agencies. Okay, so let's, after today's meeting, we can certainly, and I think it would be appropriate, and just highlight what was discussed here today. We'll do an information release out as well. Okay.
Thank you. Yes.
Thank you. And then let me see. I think that was my colleagues covered the other comments that I had with regard to compliance with the safety bills. And that is the extent of my questions. I'll go back to my colleagues, Dr. Osgood, then Ms. Bartleman, then Ms. Good, Ms. Levinson, and Mrs. Alada. And Nora over here has her hand up. I'm sorry, Nora.
So I'm trying to remember we had something where we were given the bill 7026 and what we had to put in place as a result of it. And one of the significant changes, there was 2 things that I remember vividly, that we were not going to reset at 0 every school year with students with Promise, that the infractions would be accumulative, and that now, instead of waiting to involve law enforcement after the second Promise eligible offense, law enforcement would be contacted. It was not based on whether it was a threat or not. That was not the way I understood it. However, when the guidelines came for threat assessment teams that said we had to include law enforcement officers, in my mind, that was another level of accountability to make sure that law enforcement was a part of the discussion. I've been meeting with SROs in various schools in District 5, And the ones in Sunrise spoke very openly about their involvement in threat assessments, told me the pros and the cons. So I know that that process is in place, and we are doing it at this time. So I'm a little disturbed when staff can't give simple answers. When questions are asked, sometimes it's good to just answer the specific question and not give all the other commentary that really doesn't have anything to do with the question. And I'm going to go back to what I said earlier. And I'm saying this as a point of education. I'm proud to be a part of this legislative body that continues to make decisions that are based on justice and fairness to all people. The criminal justice system is not that way. And that's why I'm adamantly opposed of being attached to the criminal justice system in any type of intimate way when it relates to our kids and information in their system. I agree that there needs to be a sharing of information, because if we had known that law enforcement had gone to somebody's house X number of times and they had 20 guns inside, we could have made some different decisions. So I'm for the communication both ways, but I'm also for what's fair and what's right. And I don't really care how people take these comments on the outside when I bring up stuff about black people, because I've been black all my life, and that's my voice, and it's my lived perspective, just like I respect everybody else's lived perspective. I have to give that voice. You don't walk in my shoes, or people that look like me shoes, so you wouldn't understand the experience. Just like I don't walk in your shoes, and I have to listen and learn about your culture and things that impact you and that are harmful and that are not harmful. So when we talk about the criminal justice system and we talk about policies, I would say that the previous school board, when we had the highest arrest rate of locking up kids, I don't think that someone sit around and decide that they were just going to be evil and lock up kids. But the way that the criminal justice system is, because we're not able to have honest and frank conversations, or we still have an extreme measure of denial going on, we won't embrace the fact that there is continued injustice. After the civil rights movement, after the voting rights movement, after the horrific horror of what happened with apartheid, I could just go on and on, Jim Crow laws. So it has been a custom in America to create legislation that do harm to certain groups of people. It is a real reality of the time that we live in. And a lot of the racist perspectives still exist today. And it's something that we have to live within, and we have to make policies and be leaders to do different. So when you see me get alarmed about things like this, it is my role on this board to give you this information so that you have it when you're making your decision. Just like it is your role to share certain information with me that I may not understand because it's not my experience or my culture or my field of expertise. So when we talk about diversion programs and we talk about what the school district has done with Promise, the alternative education program used to be housed at my church many years ago. So I've been involved with this type of thing. It just wasn't called Promise at that time. When Mr. Runcie came and through Ms. Bottomer's work in that committee, they put Promise in place. And we had all of these people on board agreeing that this was the right thing to do with kids. Then we had a shift politically, and now everybody is afraid to stand up and do what's right. I'm not going to be afraid. I'm glad to be a part of this group of ladies that are not afraid. We cannot go backwards. Right now we're going to get data, as Ms. Levison said, that more kids are being arrested because of the different things that are going on around us. I think it's sad that we're now getting legislation imposed upon us from Tallahassee that hinder us in meeting our goals with graduating kids and doing what's right by kids educationally. At the same time, if a kid is incarcerated in any kind of way, we have a requirement to go there and educate them while they're in jail. So that's oxymoronic. And I think what aggravates me even on a greater level today, because I'm still struggling to explain to young people how I'm constantly setting policies or dealing with policies to give them discipline when they fight and they do certain behaviors, and how law enforcement keeps challenging us in this area. But on the other hand, they could beat up one of my kids in a very overt way, very publicly on all kind of videos, and they don't apply the same rules to themselves. So that's what I mean by hypocrisy. And if kids are watching and they're listening, they're seeing how we handle this moment. So I'm always going to speak up very clearly. I don't care what somebody tweet, what they post. I'm going to call it the way it is. I have a Black lived experience because I'm Black. And we have to be the voice of those kids. And we're trying on this board to have programs like Promise and many other programs that we have in place to support and help kids, because our goal is to give them an opportunity to be successful. The criminal justice system used to be about rehabilitation. At some point it changed, and it's continued retribution. And that's the reality of the context that we live in. We can't allow the criminal justice system to take over what we're doing in public education for our kids. Our role is to educate those kids and to help them. If they are harming themselves and others, then sure, we put them in another system to deal with them with that. But Promise program is that's not what the Promise program is. Even when we're talking about kids and crimes and different things, we have to be careful in how we do that. Some kids have behavior issues. When I was younger, I had behavior issues and problems. It don't mean that I need to be locked up in jail or mistreated or looked on disparagingly because I have an issue. So how do you say you're trying to help me, but because I'm struggling, you're treating me in the same way? Now, if I'm bringing a gun to school, that's totally another conversation. But I'm going to be very diligent in making policy and very outspoken. I don't want to be a part of any legislative body. I will speak up and out against it every time when I feel like policies are being put in place to disenfranchise, to be punitive to any group, whether they're Black, white, whatever that group is. I'm consistent in my approach to policy as it relates to them. So as we have this conversation today, I think it's a very needed conversation. I think staff is very confused. What 7026 required when it relates to Promise is one thing. What they require with threat assessments and how that's operate, that's a separate thing. There were some specific things that highlighted and mentioned the Promise program. And they have done a very good job with putting those things in place and reporting to us that they put it in place. And we've made attempts to have conversations in the community about those changes and what those changes mean. But the community, especially the part of the community that look like me, they're very nervous and concerned because they don't want us to go backwards with locking up kids. So we have to keep communicating, and we have to keep making our voices heard and taking a position that's going to help us move these kids forward. Because putting them in the prison pipeline, it hurts us even more. We pay more, and then when they get out of jail, they're on a whole nother level of aggression, and they've learned a lot more criminal activity. So if they're of school age, guess where they go? Back to our school. And now we have problems on a whole nother level. So I wanted to be very clear in my position and why I'm taking this position. I wanted to speak clearly so that when reporters or anybody else is writing and tweeting, I want to make sure that they have all of the facts, that I'm clearly communicating. And I don't care any day about comments being misdirected toward me because I'm speaking up for Black people, that I'm a racist. I love everybody. I love all children. And any child that I feel is being misunderrepresented, I'm going to champion their cause, and I'm going to speak up for it, and I'll pay whatever consequences. Even if I disagree with the law about mishandling and mistreating people, I'll take whatever consequences I have to take for that. I'm not going to go along with it just because the law says that it's that way and it's wrong. If people didn't take that stand, I still wouldn't have a right to vote. If people didn't take that stand, I still wouldn't be allowed to sit at this dais with y'all. There would be something where I would have to sit in the back because of the color of my skin. So we are moving forward on this board, and I would like to continue to see us do that in the way that we have been doing it.
Thank you, Dr. Osgood. Next, I have Ms. Bartleman.
Oh, so I thought, it's about the tobacco thing. I thought we had progressive, and on the second offense, I was happy with the compromise when I read it.
Which page, Ms. Bottom?
It's on page 9. I thought, the reason why I liked it, yes. A horizontal thingamajig. Because it's an in-school suspension. The reason why I like the progression, I like the education component we're doing. What occurs to me after I've been out to some community meetings and with the kids, they are so addicted to the device. And I think what you did, what you took and created that compromised position where when they finally go out of school it's for intervention with a tobacco specialist and a curriculum. And I think that's the most important thing we can do for them because it is highly, highly addictive and we want to help them. And it's in lieu of the bigger suspension. We're saying, no, we want you to come and get help. And we want to have a tobacco program for you. Because honestly, even the in-school suspension, when they go to the bathroom, they still have access to the tobacco. And so I think that this approach is better because it's about the mental health and really helping the child kick the habit and meet with the intervention specialist, which is the goal. So I thought you guys did a great job on the compromise piece. With the other discussion, I agree with the comments about the communication. I don't think that we need to make this about a program that we have in our school that works. Every time we talk about it, that the bill is simply requiring a communication piece. That's all it is. We know what's working in our schools. We know what works for children. We know what our goals are as a board. We just need to comply with the communication, and we can do that without bringing, every time I think it just takes us away from what the issue is. The issue was not, even the MSD Commission said, the issue was not promise. That was not the issue. That is what they said. And we keep talking about that. But we can comply with this law whether we have promise, whether we don't have promise, and we keep intertwining it. And I don't think we need to do that. I think we just comply with the law. We have a program that has one of the lowest recidivism rates that's helping children, that aligns with what this board wants to do, which is to help children and eliminate the schoolhouse to jailhouse pipeline. So I don't think we should get caught up in all of that. I think we should get caught up in the bill and make sure we're complying, because there are districts around the state that don't have programs like we do, and there's some that may have the same program we do by a different name. So I think we just need to focus on what we need to do to comply with the law and keep our children safe and help them. And we keep discussing everything else, and I understand why we need to, but at some point, that's not, the conversation is about complying with the law. And every time we bring up everything else, it just muddies the water. And that's not what we're talking about. We're talking about communication. So I guess that's why I get frustrated. It gives people more things to tweet about, more things for people to be angry about, or this or that. This is, we know it works. We have the results. Our program works. And we see it. And we see it in the lives we've changed, in the testimony. And I totally understand why Dr. Osgood has to say what she has to say, because I agree with her. Her community it's overrepresented in the criminal justice system. It's a real problem. They're not treated fairly. I mean, you want to get into this, there are actually laws on the books in the state of Florida right now that you can get pulled over for riding on your bicycle without your hands on the handlebars. And I know students in our community that have been arrested on that law. But you can go to my neighborhood and kids are on their bikes without their hands on the handlebars. But you can go to another community and you get pulled over for that. So to say that there aren't inequities and disparities in the justice system is a fallacy. And so we're trying to correct something that exists, fix things, and ensure safety for all of our students and get our children on the right path. And everything's about behavior modification. There's behavior modification, there are consequences, but I just want to ensure that we're complying with the statute, how it's written. That's all this is for me. I didn't want to, but I get why we have to have the other conversations, because Dr. Osgood is absolutely correct, and I have not walked in her shoes. And I have to tell you, I know a lot of parents that are very afraid when their kid gets pulled over, and that thought never even crossed my mind because of who I am. So I totally get it, but I think we need to stay focused on just saying, look, we're gonna do what the law says and not get into all the other stuff. So because we have our data, we're following the law, that's what we need to do.
Thank you, Ms. Bartle. Ms. Good?
So, thank you, Madam Chair. So I just want to, in reading page 5, especially as it relates to elementary school, because in elementary schools, for some areas, we have guardians, right? So the issue of the threat assessment, including a law enforcement officer, obviously, we reach out to law enforcement and they, in turn, have to participate. But there may be a point in time where they are not responsive. So it's one thing to invite, but at some point, you're going to have to act. And you're not going to have an open-ended situation and not address it because maybe the local law enforcement agency does not want to participate or chooses not to. So how are we handling that? Because the wording in here is very specific. It says it's going to report it to law enforcement, which that's okay, but then when it says to, let's see where it says, which includes law enforcement. That word, which includes, doesn't mean you're going to necessarily have one at that meeting, especially at the elementary.
So I want to just make sure we're referring to the same thing. So the mandatory inclusion of law enforcement on a threat assessment team is not something which can be compromised. It can be complicated for those schools where there is not an SRO. But threat assessment processes are not part of the policy recommendation that we are bringing forward today.
But
that is part of policy 2130. Happy to provide both written clarification on how that moves forward.
But I just, when I read that, that's fine.
Mm-hmm.
But when I read page 5, and I get that we're required to do this, and you can, just like you couldn't force a colleague to make a comment, you can invite a law enforcement to be part of a threat assessment team, and they choose not to participate. So I imagine we have to keep everything well documented, but then at what point, what happens? You know, how is that addressed in this statement here? I don't want something to be, I know you're getting it from the bill, but if something's so specific and then we're not able to get someone to come to a meeting, then we're going to be held accountable. So I just want to make sure that we deal with the issue, you know? Do you know what I'm saying, Ms. Myrick? I'm just concerned. I know that we're going to do everything that it says. We're going to include law enforcement. But include means invite, or does it mean they be present? Because if they choose not to, I mean, at high school, the SROs are there, middle schools, but elementary is where the real issue comes up. When there is not potentially an SRO at the school and we only have guardian at the school, so then you have to invite somebody to participate. And then it's not, they could choose not to. So how do we deal with that?
Well, I've in talking with both Mr. Gall and the folks at ESE around the online electronic version of the threat assessment that's come up, you know, I have requested that there is a place for documentation. And just as there is in the Easy IEP system, there's a contact section for when parents are contacted and whatever for the IEP. So I am suggesting that part of the protocol be that it is documented when law enforcement is asked to come. You and I spoke about this, I think, a little bit yesterday. The problem is more in the elementary schools. There are some cities that don't have a full-time SRO in some of our schools, and they might be at another school or they might be doing something else. So when the SRO's on campus, I think they're always participating. I don't think that's a problem.
Absolutely.
But again, depending on what the threat is, and if the threat is you know, the second misdemeanor on drugs, there could be a reason to not hold this threat assessment meeting for a couple hours. But if there is a real threat on a campus, I don't think we can ask our staff to wait hours for a duty officer from any jurisdiction to come to the meeting. And so what they've been doing now is they've been holding the meeting, and then when the officer appears, they will discuss what occurred and ask them if they will sign. Sometimes they don't. That they were informed, not that they attended, but that they were informed. So I think the problem has occurred, just as you said, is when we do not have law enforcement on campus, and they're not there to participate.
Well, I guess I'm concerned on the way it's worded. It's so absolute. It clearly says they're going to participate. And again, we will invite, we will seek their guidance. They shall, we will request their participation. But, we don't leave ourselves anything else in here. I know you're getting it from the bill, but I don't want this to be so black and white that if all of a sudden, you've sent notices 1, 2, 3, and 4, or 5 notices to law enforcement agency and they're not responding, you're going to need to deal with it. And so
Absolutely. And so what we do, in addition to what Ms. Myrick said, is we rely on SIU, who has to come and respond to those. They are sworn law enforcement officers as well. But we cannot wait hours, much less overnight, in many of the threat assessment situations which our teams are asked to respond to. We need to act expeditiously. However, we cannot formally close it out until law enforcement has been involved.
So I just want to close. I just want to make sure we say what we do and we do what we say. So if it says law enforcement and you contact SIU, that's okay. There's not an expectation that law enforcement means the reporting municipal agency or county agency regarding law enforcement?
We always reach out to the governing jurisdiction, but we also have SIU as sworn law enforcement who are...
I know, Mr. Gold, I don't want us to get in trouble over a word, so
We're not. I'm trying to be absolutely do what we say and say what we...
I want to make sure our attorney agrees with what you're just telling me, so...
I agree with what he says.
Okay.
There is nothing in the law that indicates it has to be the local municipality. And there are some school districts, as you know, that have all of their own law enforcement, and they're dealing with it with their own law enforcement.
So I want to understand, if you can't get an agency to participate, you will reach out to SIU, but some law enforcement officer will always be involved?
Correct. Yes.
Is that a
Yes,
firm
yes.
Okay.
That's a firm yes. That's a concur.
Okay.
Yes. I'll
'Cause
nod
if not,
vigorously.
Then I want to make sure we have some language in here that
refer
we've
the
made
threat assessment
whatever
process?
effort to have that participation. I guess.
Thank you, Ms. Good. Next, I have Ms. Levinson.
Yes, I just have a quick comment about I believe what Ms. Korn was talking about. I couldn't understand most of it, but I know we were in agreement at the workshop when we were discussing this. The e-cigarettes for tobacco products, you have different consequences for tobacco and for e-cigarettes with tobacco, correct? Page...
Page 8 and 9.
So I'm looking at page 9 of...
Page 8. It starts at the bottom of page 8, and it's page 9, 10, and 11. So I will just say that I can't support something that's not equal consequences for the same thing in both devices. And you have expelling kids for e-vaping and not for tobacco. I'm not talking about if there's another substance in there. This is all tobacco, correct?
One is the page 8 and 9 are the tobacco. When you progress down into page 10, there is a different section that gets into the leaf marijuana.
Ms. Levinson's question, to your question, Ms. Levinson, on page 8, it speaks about tobacco, the plant, tobacco, the traditional plant that's been around for many years, rolled into cigarettes and smoked combustibly. The new piece that's been added is on page 9A2, which addresses the vapor devices and the inhalation of fluids that are non-drug fluids but may include nicotine products. That conversation was held at length at the workshop. I know there were many speakers.
So those are the tobacco products.
Those are not tobacco. Tobacco is A1.
Okay, they're nicotine
the
products.
plant that is smoked with a traditional cigarette. And the A2 are the chemicals and the chemical compositions that also contain nicotine and are used through the inhalation devices that have begun to impact the climate of the schools throughout our district.
Okay. So I'm not going to rehash the whole thing. I don't support the expulsion that you have on here. I supported the in-school suspensions that we were talking about and trying to change behavior. I don't support expelling kids and not having them able to continue their education as a result of it for the nicotine products. I'm not talking about the marijuana products. So I won't be able to support that. The one thing I do want to bring up, which I have brought, I would like the two to be the same. There's not support on the board from the discussion we had in the workshop, so, I'm not going to bother making a motion about something where I don't have consensus. But, to me, I would like the two handled the same way. Just as we spoke about suspending and expelling our kids and having them out of school. That's what we're doing here in this situation. We're having them out of school, not learning, not being educated. And that's, a problem for me. That's not a felony. Like, it's certainly bad for you. It's a dilemma we have, a huge dilemma in society. But it's not a felony like the marijuana. And don't agree with the consequences of keeping kids out of school again instead of learning. Our job is to educate them. And they are referred to a substance abuse manager with the tobacco as well, yes. I believe. Yes. So they still can get the help and the interventions without being expelled from school. So that is my reason for not being able to support that. So, if there is consensus from the board, I would be happy to make a motion, but from the workshop, there are only two of us who, and one of my colleagues was not here. So I just wanted to make the comment on that. And then I do just want to make a comment because, as Ms. Kearns knows, I have a student, and, we're starting to see where the vaping with marijuana is affecting our high school students. And I know I spoke to Dr. Wanza about it, I've spoken to Mr. Runcie about it, and on the topic of education, I think it's critical that when they are expelled, that they have the opportunity to continue their education, even in their higher level courses. And if that means them being able to do it online, being able to Skype into another school where the courses are taking place, I don't want to see their education ruined at the same time. So I believe it's something we need to look at and make it possible for our kids moving forward that they can continue to be educated.
Absolutely. We agree. We'll
So that's a
continue to look
challenge
into-
because
Yes, it is.
those courses
Absolutely.
are not offered in the places that they are, but we need to figure out a way.
And we believe we have the technologies now in order to deliver that. It will be a challenge because it needs to be on a case-by-case basis as
Right.
to the circumstances, but it is not our intent to connect behavioral consequences with academic progression.
Okay, thank you.
Mrs. Alado?
So for the triage form, could you please tell me who was involved with filling out the triage form?
The triage form is typically handled by a school administrator.
What page is this on, please?
It's not, triage form refers to a threat assessment process. It is not part of the policy recommendations or requests we have brought forward for today.
Okay.
I'll follow up with you later about that.
Certainly, I'll be happy to send you a copy as well as the guiding documents.
Thank you.
Thank you.
And then I wanted to ask you, can you please define what expulsion proceedings, what does that mean, what happens?
Okay. Could you bring me to where you're looking in the policy so I can address your
Page
question?
27, where we're talking about the notes, the student may not be subject to a mandatory expulsion proceeding.
Oh, on this one? I'm sorry, just a minute.
You just want to know what
Right, what happens during?
So, through the chair, she just wants to know what happens in an expulsion proceeding, not necessarily the context there, but
Okay.
just exactly, you know, how they come about and how they're.
Okay. So the note that you referred to on 27, where it just says, may not be subject to mandatory expulsion proceedings. So when a school leader identifies that there's been an infraction at a school campus, they'll investigate it and identify what rule they believe may have been broken. Then refer to the discipline matrix. If that rule is identified, aligned to school board policy as requiring a mandatory recommendation for expulsion, then that investigation is referred to the district for review, neutrally. Is it investigated, thoroughly? Is it substantiated to have occurred? Does it call for this level of intervention, meaning contemplation for an expulsion abeyance program in lieu of an expulsion? If all is identified correctly and substantiated correctly, then a pre-expulsion conference is held with the family. It's a very informal meeting and a low level of due process, meant to help the family understand the predicament and how to engage in alternative means. Our abeyance program that's offered through the abeyance sites and even Broward virtual education, so that they have a continuum of fully accredited education despite the infraction. And most of those come with, all of them have prescribed support services attached that we then engage the students with, hopefully to positively shape the behavior. And many of those infractions then also qualify for work back or early completion incentives so that we can transition the students back to school a little quicker.
Okay, perfect. So when they go to the expulsion proceeding, that does not mean that they will definitely be expelled. It's based on the circumstance, correct?
Right. When a recommendation for expulsion is made, it's referred to the district, all right, where it's determined is it identified and substantiated correctly or not. If it is, then a pre-expulsion conference will be held, which is a due process opportunity. Through that conference, we determine the next steps.
Okay, great. So I make a motion to change this note to say a student shall be subject to mandatory expulsion proceedings and then everything else. Page 27.
Policy or the change?
No, the policy, the long one.
The long one? Hold on.
Where, so a student shall be subject to mandatory expulsion proceedings.
So
The summary of changes.
that is equivalent to removing the note in totality. So rather than changing the language, through the chair, I may suggest that if that is a direction you would like the amendment to go, striking the entire note
May
would
I
be the
offer
equivalent thereof.
something for consideration? In past practice, when this language is used, which is almost never, it's done through a pre-expulsion intervention. It's not that a school-based principal would simply decide, okay, I'm not going to take action because the kid told me that they found this in the corner. The student is still issued the dispensation of the 10-day suspension and recommended for expulsion. And then at that level, at the district level, we collaborate with the school leader, and it sometimes even bring them into a conference to investigate it further. So if we change it the way you've suggested, Ms. Al-Hadaf, it would mean it would take away the opportunity for a child who had reported something or brought forward something that they had discovered from not experiencing the one-year expulsion. If there was a situation where a child truly...
No, but you said, though, before that they go through this whole process with the expulsion proceeding, so I
Right.
don't understand. They're still going through that proceeding, so what?
What would be missing would be that if we just changed it as you suggested, my read on it would be that even if they had gone through those proceedings, there would be no path for that student to not experience the one-year assignment to the alternative school. If indeed they truly and immediately brought something to the attention of adults in the building.
Ms. Myra, can you clarify?
Well, I think as staff indicated, if, and what Deborah Ms. Kearns just said is that it would go through the expulsion, but the issue is with zero tolerance, we have, you as a board and the staff have no authority not to expel a student for a whole year. Obviously, we don't totally expel, but out of their school. And so the only way that you could have an exception to the child being removed and sent to an alternative placement would be if you had some form of a note in here that said a student, like it says, may not be subject to a mandatory expulsion under these particular circumstances. So I think if you put shall in there, it would, as Dan said, Mr. Gall said, that it would just say that there would be no exception if you put shall in there. There would be no exception for the exception that they have discussed this morning or this
So
afternoon.
could someone help with the exception? Because I think what we're trying to get at is being able, if someone hands in something, to be able to have that ability. You know, sometimes we have to use common sense.
So are you saying
and-
to somewhat change the note so that it couldn't be necessarily that, is that what you're wanting, is that the note be explicit regarding if someone finds something on campus and turns it in immediately? I mean,
Can you
is that-
think of any other circumstance, Ms. Kearns, in your couple of circumstances where we'd need something else?
Well, there's been instances, for example, where I remember one scenario where a student drove their car on campus and there was something inside the car and immediately became aware of what was inside the car, and it wasn't a firearm, but that knowledge was there and we did not impose the 1-year expulsion. The issuance of 10-day suspension was made by the principal, along with an explanation of what had transpired. Everything was carefully reviewed, and the expulsion itself was not imposed. I have a thought about this note. Instead of saying mandatory expulsion proceedings, what if it just said a student may not be subject to mandatory expulsion? That's the final determination after all of the due process pieces.
And if I may, I think Mrs. Aladef's question about what is an expulsion proceeding, I think her point was she would like to see them go through the process, but not necessarily have an end result of expulsion if that's not deemed necessary, if extenuating circumstances were
So you could
involved.
just, as Ms. Kearns just said, you just could remove the word proceedings, and it just would say they're not subject to mandatory expulsion. But they've already gone through the proceedings prior to that point.
And so the off-ramp comes after the initial conference, but prior to the imposition of the penalty. We do want to encourage people who find something to turn something in without there being fear of negative consequences.
Yeah, that's because I think it still leaves you, if you just say a student may not be subject, that gets us back to the same place we were in. We want to just specify that if there's an extenuating, I don't know how to say it, but.
It should say if, like how it says, that they should not be subjected to mandatory expulsion proceedings if it's determined that the student immediately report or deliver the firearm or weapon to a staff, like that they did not bring to campus or they found on campus or something to that nature. But this does not say what you guys.
So what I would propose is this, and I'm editing on the fly here. A student may not be subject to mandatory expulsion after the pre-expulsion conference if it is determined that the student discovered. So this is maintaining that they must go through the pre-expulsion conference, that must be a determination of fact made by an outside agency beyond the school, but the penalty phase may be modified.
Hold on one second, because I
Say that something when determined that the student immediately turned in or provided to school administration a weapon or drugs or something or an item that required expulsion, like that.
Suggestion. I think I have it. All right, so a student may not be subject to mandatory expulsion subsequent to a pre-expulsion conference if it is determined that the student immediately reported or delivered the firearm to the staff member. And I think the immediately piece is important.
No, but you need to say that they found on campus. That's the point.
I think the difficulty if I may, what Ms. Kern said before was that if I'm in my car and I have something in my car from something I did over the weekend with my family that would be constituted a weapon, and I realize that when I arrive on campus, I didn't technically find it, I brought it with me, but I'm reporting it immediately. And I think that those are the nuances that we have to be very careful of when we're writing policy, because if we write an absolute, there's no wiggle room for anyone on that. That's an absolute. That's, and I appreciate the concern, and we all, I think, share that concern. It's just finding that place that is nuanced enough. If that were to occur, we wouldn't be expelling a student. It would be tantamount to a younger sibling putting something into an older sibling's backpack that they weren't aware of, and them opening their backpack and finding it there, and having a mechanism through which they could report it and know that they would not be expelled because they reported it.
So I would propose adding after the end of the sentence, or weapon to a staff member upon discovery or awareness.
And I think, and prior to the report of another individual is important also, because they need to have initiated that themselves, not.
Right.
I agree with that.
That works.
Now we've turned into almost a workshop. Mr. Katz? Mr. Katz? Yes, come forward.
Sorry, is this on? Can you hear me? Yeah. Brian Katz, Chief Safety, Security, Emergency Preparedness Officer. I'd like to add one more scenario to this that I think is important for us to be thinking about. I don't want to limit the ability for a kid to change their mind. We want to encourage the behavior of someone who has bad intent, who makes plans, who goes to act on whatever that issue is and changes their mind and does the right thing. We want to make sure that we have the ability and that to consider that to be an extenuating circumstance. So if I'm a kid who has, because again, if you don't, and it's again, going back to the conversation that I heard earlier today when we were talking about zero tolerance, we're taking that option out. So somebody has no choice but, well, if I'm going to get expelled anyway, even if I've changed my mind, then I'm going to do something. We want to take away the I'm going to do something. We want somebody to think, hey, there may still be some consequence to this, but the automatic expulsion shouldn't be the only answer. That's just my opinion.
Yes.
Me too.
I have many people on the list who still want to say something, and I will add you to the list.
Say something, that doesn't mean if you didn't have if you didn't have to expel them, that doesn't mean that they would not go to an alternative center for a period of time. It just might not be for an entire year.
Mrs. Aladeff, do you have additional comments or questions? No. Okay. I've gone from numbers to letters, so now we're on F. Ms. Rupert?
Gosh, I have so many sticky notes from conversations here. Where to start? I guess the zero tolerance on gun possession. I don't know how that you would work that aspect with those exceptions. So I personally think we need to have a much larger question and time to discuss this. I think we could talk about this another 4 hours and not even get any further than when we're at right now. So that's just a thought that maybe we could bring it to a workshop prior to the next meeting to get to consensus, but it's the will of the board, whatever they want to do. Accountability starts with sharing of information, and I think it was Ms. Brinkworth who reminded us about that. And the reality is we have a certain percentage of our students that have very high disciplinarian infractions. And these kids need to be part of an internal group where they are giving the tools to be able to work through the issues that they're bringing with them. It's our job basically to help them make their toolbox so they can move on with the rest of their life and have those supports ready to go. So if you show up on campus or Burger King and you were going to do something, you will not have that. Hopefully that thought is really what we're talking about. going back to accountability and who's talking to whom. Police, FBI, school, municipalities, they need to know how many students are in this high category zone of kids that are, and I'm not talking 20, I'm talking hundreds, or 125, or 150, or 200. Those are the kids that we hope are given the best help in moving forward, because obviously what we're doing at that point is not being effective for that student. Our responsibility, like I said, is to give students those supports. I wouldn't know where to go with the way the conversation is happening and going from one point to another. At this point, I personally would prefer if we had it workshopped, because it's taken this many hours to do this, and I am 100% behind my colleagues to hear what they want to say, and for myself to voice that as well. But I really don't think we're going to get to a point where we have consensus of what we really need to do, and I don't want to be rushed into making a decision because we're running out of time, et cetera, et cetera. This is an extremely important conversation, and each one of us needs to be heard on that. But I also agree with Dr. Osgood. The community has yet to weigh in on many of these questions on do they want to have SROs. I have students like Dr. Osgood, they don't want more SROs in their school. And that really is important to the community to share with what it makes them feel like. And that feeling is incredibly different than another student that's at that school. So I think it's a highly sensitive conversation, but it needs to be expansive.
So, Ms. Rupert, thank you very much. I just remind the board that staff will always follow whatever direction you choose. However, policy 5006, and we have to get to item CC2 in a minute, have been workshopped twice in order to bring it today for you. And should the board opt not to, as is your right to proceed this, then this existing policy for this year will remain in effect for 2019-20, and none of the proposed changes that are outlined in this policy will be in effect.
Thank you, and thank you for that, but I don't mean to be disrespectful by saying, I don't care if we have to have 5 workshops on it and a town hall. These are conversations that need to be had, and just by seeing how much conversation it is bringing from the dais, surely we can acknowledge the fact that more conversation still needs to be had. So I understand.
Now, the question for the board is, does the current policy remain for next school year? Or do we have the proposed policy for next school year? Because we will bring this policy back next year, as we have each year previously. This is a policy that is reviewed and updated on an annual basis.
Right, I'm well aware of that. This, I think, is my 9th, so very well aware of that. However, if we still keep having these conversations, I'm sure you could squeeze it in somewhere or something, or have, I don't think walk-arounds and I don't think phone calls are really able to do this justice, because you truly have to be able to hear what your colleagues are saying. Like, I wish I could hear what's going on that right side of the dais, but, you know, it just, you can't.
No, and we certainly welcome whatever regularity or however frequently the board would like to continue to discuss it. We just have the reality of needing to print a student discipline policy over the summer for distribution on August 14th.
Perfect. And to go back, Mr. Gold, to that high number of discipline fractions, we've discussed this. I've discussed that with Mr. Runcie, as well as people from the MSD Commission. So whatever form we are allowed to share with them, absolutely do what you need to do, but protect our kids.
Yep. And superintendent's been clear about that.
Okay, good. And I guess the only other aspect is, I have no problem with the changes for the last item about the shall. As long as we take the proceedings off, I'm for that. Hold on. It's too murky, I gotta say. So I'd like to hear from my colleagues if they feel they can make a valued decision today, or if they need more time. So I was throwing out a life vest.
Thank you. I would just like to remind my colleagues that we have workshopped these twice, and this is before us to approve a policy, and we are required to do this. And as Mr. Gold said, in order for this policy to be implemented for this next school year, it is time sensitive. So I will be going back to my colleagues that have additional comments, but I just wanted to say that as a reminder, we've already had 2 very lengthy workshop conversations with regard to this policy. Dr. Osgood is next, I'm sorry.
Thank you, Ms. Brinkworth. And I want to be clear, my comment earlier about community was related to the Promise program and making a change here to make it a diversion program. That's very different from this policy that's bringing us in line. I do have a question because I see where we have clarifying language to align with the Marjorie Stoneman Douglas Commission, but I don't see where we have clarifying language to bring us in line with 7026 or the policies. And I know we've had those discussions, and I think that would have provided some clarity to this discussion today if we would have listed where those things were changed as well, because I know we did them. I remember us having the conversation, because 7026 is a law. The Marjorie Stoneman Douglas Commission makes recommendations. To me, those are 2 different things. Many of their recommendations I embrace, I agree with. There are some I don't. But I think when it comes to the law or recommendations, those are 2 different things. I think that what Ms. Aladaff was talking about earlier is trying to make sure that we're communicating clearly that we have a 0 tolerance for firearms being on campus. And when we read the statement that we was talking about earlier, with your input and what you were saying, why you leave the caveat, I think that's what's causing the confusion. So I'm sure we can come up with some wording to accommodate both in this policy. And I don't want to delay this, because to delay this now, let me just ask very clearly. So what we have in this policy now includes the recommendations from 7026, and we're working on the recommendations from 7030. Is that correct? No. Okay. So if we don't pass this policy, then we're out of compliance with the recommendations for 7026.
Our policy will not reflect the updates as 7026.
Okay. So that means we'll be out of compliance. So Ms. Balderman stated very strongly how she didn't want to be out of line with that policy and not have her salary held up because we didn't implement those changes.
And Mr. Runcy's.
Yeah.
And get in trouble with the
you know, if I'm in disagreement with the law, if it's injustice, they could take my house, my salary, or whatever. Injustice is injustice. But I just want to be consistent as we look at this. So when we're talking about what we have here, we have looked at it twice, and I am prepared to move forward because I know every year we bring this policy back and we have these discussions. But what I will say here, Mr. Runcy, and I've said it before, when we have bodies like the MSD Commission, who I feel is doing a good job in trying to help us get to a certain place, there has to be some intentionality and some scheduling done that they come before this board or this board go before them. We asked before and we had the chair come in to us at some point, but in my opinion, it was way too many months late. We cannot afford to have that happen this time. This board is ultimately the policy-making entity for this district. So if we got any groups, like we have our advisory groups, we have the different groups that work with us and make recommendations, they all come and make a report, but they come where we interact with them in some form or another. So I'm going to ask that at some point we put something in place through the chair that takes place intentionally, that we're not, after we get a series of recommendations or something, requesting a meeting and then having to wait 3 or 4 months because of scheduling. I think if we take a proactive step now and being intentional about that, we can have that workshop and request that workshop where all of us will have opportunities to engage with, whether it's the chair or whoever comes to represent that entity, in a format that we can ask questions and go back and forth. And I know for me, it would help me make better decisions about policy and embracing their recommendations. Thank you.
Thank you. Ms. Bartleman?
Yes, I wanted to, we have to pass this, and I agree, and I wanted to say that very clearly that, and Mr. Katz brought up one example, but my example in my head about somebody self-reporting is that I have something I'm not supposed to have, and it doesn't have to be a gun, because remember, it's a Class A weapon. That's a myriad of things. That's like, if you look at the policy, it's the paint gun, it's the brass, it's a ton of stuff, brass knuckles, it's the knife. If we don't give children a mechanism to report, forget someone with an intention, I'm talking about someone without an intention, because my brother put something in my backpack, I'm gonna hide it the whole day. There's no incentive for me to get it out of my book bag, so you have to give them the opportunity to self-report. I mean, when he brought up that they were gonna come do something, that freaked me out too, because I guess you would never know if that's what they were gonna do or not unless they verbalize that. But the point is we've had little kids that have things in their backpack that they don't know. Elementary kids have brought in firearms, and not on purpose. And if you create a zero tolerance, I'm just gonna tell you, I don't know how many have been on this board where we have had the full expulsion hearing take place here in the room with the parents, with the student crying, with the news media, and you look like your heart breaks because you create a policy that's so tight, and then you don't give yourself a way out for those outliers that don't make any sense. And that's the problem, one of the problems with our legal system when we have zero tolerance. And so the language, for me, you can flip the words so it's after the proceedings or not, but it needs to be here. Mark my words, there's gonna be a kid that walks in here with something that is ridiculous, and you're gonna kick yourself because you didn't give yourself any way to help save that kid. And the more importantly, if I find that my brother left his paint gun in my backpack as a parent of a child sitting in that person's class, I want that kid to feel comfortable giving the paint gun than having it walk around that building where an accident can happen. And we always tell our children, tell the truth. I mean, that's what we tell our kids to do. Tell me, even if it's wrong. And so I think that goes against, for me, my parenting, even what I think. I want them to tell the truth. And there needs to be consequences. And you'll figure out, but didn't we have like a 7-year-old with the gun and they didn't realize the gun was in the backpack, or it was an elementary school student? It was, which one? It was a knife?
Yeah, there's.
I think we've illustrated there have been many different.
Well, I want to bring that up for people who want to change this, because this is not just a gun. This is a knife that someone put in your back. We have tons of these.
We have instances at elementary, middle, and high, and yes, at elementary, where children show up at school with the equivalent of a Class A weapon in their possession. Sometimes it's even inadvertently. There's language in our school board policy that defines the word possession as knowing, intentional, or even inadvertent control of an item. So if that child is inadvertently in control, it's in their backpack and they're not aware, they're accountable under school board policy for a mandatory expulsion for that weapon. The caveat, the note that we have here is the means by which they can self-report. They enter the campus and they realize, there was one little student I mentioned to y'all before, they were changing locations like on the fly the night before. And somebody kind of swept that knife into the kid's backpack and it ended up in the building. This would be a mechanism for the child to say, look, it's here, I didn't know how it got in here, and we would not have to do the mandatory 1-year separation to an alternative center. So it gives us a means by which, a lens to consider a mitigating factor when a child self-reports a situation.
Okay, so if it makes people feel better, I'm fine with the motion, but I am not for getting rid of anything like that. I don't. For me personally, the zero tolerance does more harm than good. The other thing I wanted to bring up, I feel I know what you're saying, that we are entitled to talk about it, but I really feel, Ms. Rupert, we need to pass it. So I would be comfortable with that language, and I have to bring this up because Dr. Osgood spoke about this at the last workshop, and it really made me self-reflect. All of a sudden, we're talking about leniency with the smoking and the vaping, which we know leads to greater things. All the studies show it, all the agencies show it, and we're like, well, let's not do this. Let's not do this. And then you think about what Dr. Osgood brought up and all the other infractions that occur. Shame on me for not thinking about the other students who aren't bringing tobacco products and getting or are expelled and not being able to have access to their AP classes. Like, we're bringing it up now, but shame on me. I should have thought of that before. All of us should have thought of that before. But now that we have a certain population that is very negatively impacted by these vaping devices, now we're not going to suspend, we're not going to expel. And we know, I mean, I wish everyone would go speak with the United Way and everybody. We know that those tobacco vaping devices go right to the THC oil. And the reason why you're seeing the THC oil now in such great numbers is because it's like a whole gateway system that occurs. And kids, it needs to be treated differently, because the last time I checked, I have not heard of a child pulling out their Marlboro cigarette in a classroom and smoking it while the teacher's lecturing. But it happens every day in this school system with the vaping devices. Every day. You don't, if there is a tobacco cigarette in the bathroom, everyone can smell it. Kids, I talk to parents all the time. We just had a meeting at Falcon Cove with all the parents and the PTA, and you can't believe the stuff that Kaplan has confiscated. The kids are afraid to go in their bathrooms. I had a parent call me, their kid was afraid to ride the bus. If we do not do something now about the devices, it is getting worse. Every quarter the numbers are going up and up and up and up and up and up. This isn't going to get any better. So I think what they did, and I don't want to have to go back and re-workshop this, is a great compromise. And most importantly, it's about treatment. This is all about treatment. I watched my mom struggle for years to quit smoking. I can't imagine being 14 or 15 and addicted to one of these vaping devices. I just can't even imagine how hard it is for that little 14-year-old to quit. So as long as the treatment is attached, it's not just about the consequence. And I think for all kids, not after this policy, but all kids now, and that was my issue with the student who I met, the one who was the ROTC kid who was expelled for the year for the paint gun. We didn't have the technology then we have now, but he couldn't take all of his classes then. So we need to make sure that we're linking all of the kids who are in expulsion abeyance to Broward Virtual and all of those classes that they can take. And I believe that occurs, I've seen it occur, but I don't know how consistently it occurs. So I think I'm okay to pass it as it is today with amending the language, however it will make everyone feel better, but I don't think we should go to zero tolerance, which is what some of the language offered does. And
Thank you.
So thank you.
Thank you, Ms. Bartleman. Ms. Korn? And then Ms. Levinson.
Thank you. Just for clarification, can you restate the amendment that's on the floor right now?
Ms. Carnes, can you read what you had written down?
I think I had stated, a student may not be subject to mandatory expulsion subsequent to pre-expulsion conference if it is determined that the student immediately reported or delivered the firearm or weapon to the staff member, and include language that immediately means without delay as determined by principal, totality of circumstances, and prior to the report by another individual.
That's what it says.
Okay, thank you. For me, immediately should actually be determined at the pre-expulsion meeting unanimously by everyone at the table. It should not be just by the principal. And I think it should also be unanimously agreed upon if there's going to be an alternative to suspension by everybody who's part of the conference. So both the definition of whether or not it meets immediacy or immediately, as well as whether or not an alternative would be offered rather than a mandatory expulsion, should be a unanimous decision by the pre-expulsionary conference team. And that would be a friendly amendment if that would be considered.
Okay, so just to help here as a point of clarification, so The 10-day, there would not be a conversation, there would not be a mechanism by which to determine whether there would be a suspension or not. The 10-day suspension would be issued upon the discovery of the item, and then it reads that they would not be subject to mandatory expulsion, again, subsequent to the pre-expulsion conference. Point of clarification, the pre-expulsion conference includes the family, any of their representation, and the assistant director of school climate. That's who would be present in the room. There would be
I'm referring actually to the expulsion, not the suspension. So the mandatory expulsion is what I'm referring to.
Mm-hmm.
And again, the members who are present during the conference would be the principal as well as an area director. Can you tell me who those members are?
Okay, so that's what I was explaining. A pre-expulsion conference, the parties present are the family and any of their own representatives, and the Deborah Kearns, Assistant Director of School Climate and Discipline. In an instance such as this, which we do on occasion, we engage the principal in that conference to seek their input, and that's what would happen in a situation such as this.
So, Ms. Korn, in order to get to the spirit of your request, which is appropriate authoritative oversight, I would propose that the recommendation be overseen by the superintendent's representative who oversees expulsions, and that traditionally has been the chief of student support initiatives and recovery.
I think that would be appropriate, but I'm a little confused because if the principal isn't always included, how in this note does it say that it was the principal? And I believe staff said that the principal makes the determination after they've heard all of the information and are aware from the pre-expulsion conference. Well, if the principal isn't always there, how is it that the principal is defining immediate?
Yep, I want to kind of re-summarize. An incident happens, determination of what it was, whether it falls onto the expulsion. That process occurs with the principal. There is no off-ramp to the consequence at that school-based level. If it is determined that the behavior is expellable, that entire case is then moved up and out on the school level into the expulsion office for review to determine if the proper evidence was gathered, if a due process was established, and then the family is engaged with to determine if they are interested in an expulsion abeyance process. This is where the process of off-ramping because of the circumstances of finding the gun would be able to be considered, including not requiring the expulsion to go into effect.
Sounds like that would really be a unilateral decision at the end of the day by the superintendent's designee in that role. Said attends the conference. The family is not going to be part of that decision. And there's only one required individual from the district to be in that meeting, correct?
Correct.
So then that individual has the outright authority to say, yes, they're expelled, or no, they are not.
Yes.
Whether or not the circumstances allow for this off-ramp from expulsion.
Okay, got it. Okay, and then to Mr. Katz's comment, I have to say I have absolutely no interest whatsoever in entertaining a student who had an intent, found a weapon, brought a weapon, located one and put it in their possession, brought it to a campus, and then changed their mind, and somehow that individual would not be expelled. That does not, for me, that is not a circumstance in which that would occur. This is for the student to, without, with all the different scenarios that were shared, but if a student had an intent at any time to use that weapon and brought it to campus, for me, they're expelled for a year. And I understand that that may keep them from reporting it. Fine, don't report it, but don't bring it on that campus. If you ever had an intent to use that weapon on that campus, and it's determined, even if you're the one who brought it forward, I believe you should be expelled from school. And it goes actually to number 2 in that same in the actual policy, page 19. Number 2 talks about the threat or a false report. At minimum, I would consider it to be a threat to have intended to use a weapon, brought it to campus, then changed your mind. I can't even imagine that scenario and not expelling a student. So, for me, that would not be something that we would entertain as a result of not being expelled.
Ms. Corn, actually, your interpretation is accurate. You know, when a school leader does an investigation and finds definitive infraction of a rule, there could then sometimes be concurrent infractions occurring or concurrent behaviors occurring. An instance where a student mistakenly or accidentally brings something on campus and self-reports it, that could, through this language that's always been in place, be entertained as such, self-report, and the expulsion not be required. But a school could also engage in a threat assessment. Remember, threat assessment is not about discipline, it's about safety, to determine if there's a compromised safety or a need for a supervision plan or something else to be put in place. So, you know, all of these pieces are here to maintain school climate. All of these pieces are here truly to ensure, you know, safe and serene and tranquil environments for all, and also to get support services to kids when they're needed. This piece that we keep talking about the self-report and all that, I don't want us to overlook the language about the principal. This has been here for quite a while. The term immediately means without delay, as determined by the principal, after concluding the totality of the circumstances. So through their investigation, if they realize these are the circumstances, let me clarify, it would not be the role of the principal at that point to take no action. That principal would still issue the 10-day suspension. The principal would still submit the recommendation for expulsion, include within their investigation their findings for consideration at the next level, and then through the pre-expulsion conference, that could be entertained as an outcome. As Mr. Gold said, the off-ramp to a different sort of intervention, needing some kind of intervention, but maybe not necessarily a one-year assignment to an alternative center for the expulsion program. It's a different behavior. We should have an off-ramp to treat it differently.
Yes, but what I'm saying is Mr. Katz came to the microphone and gave us a scenario where a student was in possession, brought it purposely to school, had an intent to use it, but then changed their mind and self-reported, and somehow they would be eligible for this. And what I'm saying is I do not want language fluid enough for that to occur.
Mm-hmm. So the current language that's here talks about the principal's determination, so that would be the input of the principal collaboratively with the designees around this work at the district. And then also keep in mind that any behavior that's perceived as compromising the safety of a campus would be subject to a threat assessment. And if it were a high-level threat, that in and of itself, a high-level threat would be a one-year expulsion assignment. So we're, you know, it's very strange. No two scenarios are ever going to be the same, but we really have to ensure that we have language that's specific enough to provide the appropriate level of safety and consequence, but also gives us the opportunity to treat children appropriately as children and give them the interventions that are appropriate based on their own decisions and behaviors. So
okay, well then I have to tell you, I seem to then be misreading what this says, because to me the second sentence, which is the asterisk, is supposed to only be defining what the word immediately means. That the principal's only discretion here is in defining what immediately means. It wasn't supposed to be the totality of the situation and to make a determination as to whether or not it was a mandatory expulsion. It's a mandatory expulsion, but it can go forward, and he or she, the principal, will define what immediately. If I chose to come to the school, had a gun in my car or in my backpack, I intended to shoot somebody, and I changed my mind, and I went to the principal and I said, hey, I'm changing my mind. I'm not going to use this. I'm not going to, injure the person I was intending to injure. I don't understand how a principal could then somehow say, well, that meets the criteria of immediately, so this child may not be
So, Ms. Korn,
expelled.
This is Dan Gold. Our previous practice and our current practice both reflect the approach that you are advocating here. That such circumstance would fall under the mandatory expulsion.
Okay, well, I was comfortable until Ms. Kearns just shared what she shared about the fact that we really need to be looking out for the student's best interest. Yes, we do. Every best interest other than the child who decided to bring a firearm to school with an intent to use it and then change their mind. So if that child somehow has an ability to not be expelled with this language that was proposed, I can't support this language. If that's not the case, then I can support it.
I believe that what you are saying you could support is, I will assert, is what the intent of this language is. There are considerations such as work back and other things that could theoretically be taken into account. I am in no way aware of any such circumstances where such a circumstance has played out.
And this is Deborah Kearns again. I've never even, that scenario never even crossed my mind in all of my time working with kids and helping us work through these situations. I will tell you, as the designee for this work, I personally would not avoid the expulsion in a scenario like that where a child had intent to hurt someone and brought a weapon in. So the language that's here has always kind of met our needs. It's been almost never used, and it's only been used in those situations where a child either inadvertently got to school and realized, oh my goodness, this is here, okay, or was involved in the reporting of an item that was not their own scenario. And they've served their 10-day suspensions. There's been engagement between school leadership, the principal, and the designee for this work at the district level, collaboratively to come to an agreement and an outcome about whether indeed this language, that it was reported immediately without delay, and only in those instances was the expulsion not imposed. And again, there are many instances where something that is a non-expellable act is accompanied by a threat assessment for safety. And if that threat assessment yields a high level of threat, you're back in the realm of expulsion intervention again, regardless of what the initial infraction was.
Okay, well then, you know what, I think I get more comfortable if when we put in this definition, we talk about a student may not be subject to the mandatory expulsion proceedings if it's determined that the student immediately reported or delivered the firearm or weapon to a staff member and had no intention for use. So if we want to put that in there, because at this point to me, there still seems to be something open-ended about it, because I gave the scenario, and Ms. Kearns, I'm sorry, but you said, well, yes, that does leave it open. That could possibly be considered a non-expulsion. This opens the door to that. So I would rather it have something in there that says, and no intent.
Trying to help here. What about if we include language such as, and did not disclose intent? Proving intent is a really hard thing to interpret, understand, and substantiate. We actually don't have intent really almost anywhere else in this policy. We're not a court system. We don't have months of litigation around things. We have to make decisions based on language with and for children. So if you want to talk about intent, maybe it would have to say something like, and not without intent having been disclosed by the child, verbally or in writing.
Yeah.
Or not being disclosed by the child, intent being, it could have been intent by a parent or someone else that had knowledge of information, and not that the child basically self-reported, but demonstrated intent. If you want to say something along those lines, that would be okay.
So what I'll do is turn to Ms. Myrick. We are trying to keep this without crossing the line of substantial clarification. This has been in process for a long time. We're simply trying to clarify here the limitations and capture board's desire in the phrasing. So we do not want to delay the policy any further.
Here's a suggestion. Inadvertent possession and immediately reported. Inadvertent possession would mean they weren't aware they had brought it on the campus, they didn't knowingly bring anything on the campus. So if they were inadvertently in possession of and immediately reported without delay and prior to report by another individual.
Perfect.
That sounds great.
Okay.
Can you read that one more time, please?
And then someone motion it so we can be done.
I believe Mrs. Alhadeff already motioned and Mrs. Levinson, yes, she'd have to accept, but let's hear it again, please.
Oh, I'm trying to get it in my head again.
No,
Okay.
that's fine.
A student may not be subject to mandatory expulsion if it is determined, a mandatory expulsion, comma, subsequent to pre-expulsion conference, comma, if it is determined that the student was inadvertently in possession of the weapon and immediately reported the firearm or weapon to a staff member, and that and then I think we need to leave the asterisks about the term immediately, meaning without delay as determined, and we could put collaboratively by the school principal and designee, school climate and discipline, after considering the totality of circumstances and prior to having been reported by another individual.
I can support that. Thank you, Ms. Winkler.
Thank you. Mrs. Alhadeff, do you accept that friendly amendment to your amendment?
No.
Okay, so. Can you read your motion again, please? Me? I will? Yeah, okay.
Student shall be subject to mandatory expulsion proceedings if it's determined that the student immediately reported or delivered the firearm or weapon to a staff member.
And Lori seconded it.
The student shall be subject to mandatory expulsion.
So it's zero
So just taking out may not and putting the word shall.
And are you leaving the word proceedings or taking that word out?
Keeping the word proceedings.
Doesn't that make that zero tolerance then with no wiggle room, or no? To me, that makes it zero tolerance.
Hold on, Ms. Bartleman, please.
Okay.
Okay, and that was seconded by Ms. Levinson, and we've been discussing it. Is there audience input on the motion?
Mrs. Brinkworth?
Yes.
I think that substantially changes the policy, and therefore, just for you to know that you will need to, this will need to come back not sooner than 28 days.
If it passes.
If it passes.
Right. Okay. On the motion?
Yeah. I guess what I'm kind of frustrated about with this is this language had nothing to do with what occurred in our school. This language has been working. There's only been 7 instances. But now we're going to respond with a zero tolerance and take it all the other way without taking into account all the 7-year-olds who have someone put something in their backpack and all of those things. And we've spent a lot of time on this language, which has not been a problem. But I'll tell you, we have other problems that exist in our code of conduct. We had a student who brought bullets to school and had no punishment, if we want to talk about the real problems with our code of conduct.
Ms. Bartleman,
No, but
at
my
this
point is, we're gonna respond in a sweeping motion when you hear all the situations of the poor kids who things happen to, but we haven't, but all of the things that led to what happened had nothing to do with this. That's what concerns me here. You can't, if we just take the pendulum all the way the other way, children are going to get hurt. This is not just a gun. This is a paintball gun. Look up what a Class A weapon is. Someone can inadvertently and self-report the little kid with the knife. You want to have the 7-year-old, because what your language does is take that little kid with the knife, who they left it in the backpack, and kicks them out of school for a year. Is that the best educational decision to make for that little kid. So I don't mind, you can't swing the other way and then harm children. And that's what this motion is doing, and I don't think that's your intent. So I want to find a compromise motion that would do that, because I have to tell you, I'm going to be hard pressed to follow my own policy to expel the child that we didn't expel. And remember that you put yourself in a hole. And all the policies talk about looking at things individually and not having zero tolerance. This is not about Mr. Katz's example. Mr. Katz's example freaked me out as well. This is about all the other examples, the 7 examples that we have used. That's it. So when you vote on this, know that you're going the whole other direction. And there will be consequences to children's lives. And you will not give yourself, as a board, you cannot do anything about it. As a board, we had to sit here and vote unanimously to expel a 5th or 6th grade student for his Nerf gun. And it was on every national news station.
Ms. Bartleman, we need.
I know, but do you understand we're about to vote on it? I don't know where the support is, and I'm freaking out about it, because once you go this way.
Understood.
All right.
Understood, and I believe that your message has been delivered loud and clear. Any additional comment on the motion from my colleagues? On the motion? Yes, Ms. Good.
Thank you, Madam Chair. So you went back again to understand my colleague's motion. I don't think your intent is to inadvertently hurt anyone. So I think your focus is zero tolerance. So the way that the wording is right now, it doesn't afford any opportunity then, after the proceedings take place, if it was found that the child had inadvertently found a weapon. And I thought you were supportive of that. So I'm just trying to understand the motion. I'm in agreement with your zero tolerance, but I'm trying to get to a point where if at least a child finds something and turns it in, that child wouldn't be held to the same level of punishment as someone who had a bad intent. So that's where I'm at struggling. So I really want to support you, Ms. Halliday. I just want to make sure that we have an opportunity for that child that may find something and wants to turn it in and do a good thing, but now they're not going to turn it in. They're just going to leave it there because they may be held to that same standard as someone who's really coming to do harm. So I'm just asking for your thought process here and hoping that you can wiggle it a little bit so that I can be able to support you, because I really want to. Thank you.
Dr. Osgood?
Ms. Brinkworth, if you would allow Ms. Aladav to explain what she's trying to intend, because I'm in the same predicament with Ms. Good. I'm not for kids bringing weapons and guns on campuses, but I do want to give opportunities, because I just think about, we just did that, see something, say something. I mean, and this is the dilemma that I continue to have, that we kind of talk out both sides of our mouth. So we've been really encouraging, and I think we've gotten responses. We just did the see something, say something. We have 911 Broward schools. We have safe watch. I mean, we put in a lot of things for students to help us to govern and be able to speak up and report things. So if we don't have a provision, if I'm walking in the school and I find a gun in the school and I turn it in, now I got to go through a whole proceeding for doing what you told me to do was the right thing to do. And that's my tension. I am total agreement. I don't want someone bringing a gun at school and just getting away with it. But I do want children to be able to report stuff if they find stuff and not be penalized and having to go through a procedure like they did something wrong, because they're going to say, well, I'm doing what you told me to do. You just took me through this see something, say something curriculum, and I saw something, I'm saying something, I'm even giving it to you, and now I'm being brought up for exposure. So that's my tension as well.
Mrs. Alada?
Sure. I think we're talking about two different things, talking about someone purposely taking a gun into a school to do harm, and then someone accidentally, I guess, having maybe someone putting something in their bag and bringing it to school. It's a felony if you write or post or transmit something to make a threat to a school. So I guess when I was looking at this note, that it seemed very lenient. And so when I asked about the expulsion proceedings, I felt that that would be at the opportunity for all the people involved to have a say and to be able to kind of decide whether this was an intent or whether this was by accident.
So through the chair, Ms. Aladeff, the insertion of the word shall into where it currently says may not is substantial to the general counsel's point because it both reverses intent and requires that regardless of if it's someone who brought a gun with ill intent, someone who was possessing a gun for self-protection, or someone who found a gun, they must be expelled for a year. There would not be any discretionary authority handed to the expulsion office. The other consideration which the board currently has in front of it, which is the modification of the language in order to provide additional clarity, would allow, under those extremely rare and limited circumstances, such an alternative to the imposition of the year-long expulsion, but it would still require the person to go through the process of having it considered. And I believe that your intent is to make sure that there are consequences regardless of why, and only if there are those exceptional circumstances that the expulsion not be for a year. That phrase requires something of may not with conditions, which the board has. If we invert the language and put shall, it will not allow any discretion.
Okay, so I believe Ms. Levinson and then Ms. Good.
Say something.
Yes.
So what do you think about what Ms. Kern said? I still don't know exactly what you said, so.
Read it again. Want me to read it again? Okay. A student may not be subject to mandatory expulsion if it is determined, okay, let me start again. A student may not be subject to mandatory expulsion subsequent to pre-expulsion conference if it is determined that the student inadvertently possessed and immediately reported or delivered the firearm or weapon to a staff member. And also leave this asterisk. The term immediately means without delay as determined by the principal after considering the totality of the circumstances and prior to being reported to another individual.
So what did you, I mean, I'm the one who seconded it, so I'm trying to see what you think here, because I have the same view as you about the zero tolerance, but I want to make sure that if someone does discover, you know, especially with some of the things we may be doing in the future, security type things, that, you know, if there is something discovered, that someone will hand it in, and awareness. You know, originally you said upon discovery or awareness. I kind of like that because the discovery was if you found something, and awareness was if you inadvertently brought it on. So to me, that was like narrower in scope right there to just those two things, which I can't see right now any other reasons I would support that it would be. And then I'd like to put something in there that it's not just the principal and the superintendent's designee, but also the superintendent. If there have been 5 cases in 9 years, I also would like to go up to the superintendent as well, to have another layer there to ensure that.
Staff is stepping away from the front panel in order to go back and write it out as a complete sentence.
Would that be acceptable, Ms. Aladeff? for them to-
That is
Okay.
awesome language.
Hmm?
It's awesome.
Okay,
See
is that,
if we
okay.
can come up with something.
Ms. Good also had another suggestion, so let her throw that out there, so it's all in the mix.
I actually like what was just said, but I think what I'm a little bit weary of is when you first start the statement, it doesn't sound strong, and maybe that's why you're a little hesitant. So I thought it should be more as the student shall be subject to mandatory expulsion unless it is determined. Love.
That's what I
Is that
wrote.
you had?
That's what
Okay.
I wrote, by the way.
Because to
So
me,
shall be
it's
unless.
strong, unless it's whatever else you said.
It's
because
establishing the baseline and then
Yes,
the
sir.
conditions of exceptionality. So
Exactly.
I know
And thought
staff's
maybe
capturing
you'd be more
that.
comfortable, the both of you. of
Yes,
that.
thank you.
Okay, so at this point, staff has stepped away to write the verbiage so that we can then vote on it.
I think it was great. That was a lot of cooks and mushing, and it came out perfect. Good job.
Okay. And I just have to make a statement about a statement that was made earlier that I must respond to. When we were talking about the vaping and expulsions, I am 100% consistent about all students, whether it be those students, whether it be our promise students. I don't believe in kids being suspended or expelled on either side of this district when they should be in school for infractions that don't rise to that level. So that was totally not what I said. And the only reason I brought up the higher level courses, it's the first time I've ever been contacted by a constituent in this situation. I don't care whose district it was from, what kid it was. If they're not able to continue in their education appropriately, it is our job to make sure that every child can continue in their education appropriately. Thank you.
Thank you. So about how long do you think we need?
So I think we'll just be a few seconds, but I do believe that there is a motion already on
She
the
has
floor
to-
concerning the shall.
Well, I mean, if you'd like, we could just remove your motion and your second, and then you can make a new motion when they get you the wording that you're happy with, if you'd like, withdraw it.
I withdraw my motion.
Draw the second and
Thank you.
do
And
it again when.
now, here's the big question, Ms. Myrick.
And we are ready to go.
After you hear their motion, I'm going to ask you a question. Be prepared.
How about asking me the question before so I can be thinking about it? as
I need you to
well?
think about whether or not the motion is substantive, oh my goodness, it's getting late. Substantive enough that it would require the 28 days.
Ms. Kearns?
Okay. Try this. The student shall be subject to mandatory expulsion for possession of a Class A weapon unless it is determined through pre-expulsion conference that the possession was inadvertent and immediately reported or delivered to a staff member. The next statement would remain.
Hold on one second.
Upon awareness or discovery.
Hold on one second, because the possession is not delivered, and sorry, that's just the English teacher in me, so whatever it is that's being delivered, you need to add a noun in there.
I was an English teacher too, but I'm going on the fly. I'm sorry. I'm embarrassed. Okay.
As you
Give
should
me a
be.
moment.
Given the conversation and what the intent and how that sentence has been used for the last several years, I do not think that it's a substantive change and that this can proceed.
Okay, thank you.
And your language was about what? 2 phrases you said?
I wanted to put awareness in there
Awareness,
somehow.
awareness or discovery.
Discovery and awareness.
Inadvertently pass or through discovery or awareness. Okay. Try this one. A student shall be subject to mandatory expulsion for possession of a Class A weapon unless it is determined through pre-expulsion conference that the Class A weapon was inadvertently possessed. Discovery and awareness, where do you want that?
Or transmitted.
Or possessed, no, transmitted would be something very different.
Okay, it's possessed.
Right. Possessed or discovered. Wouldn't discovered and awareness be the same thing?
No, upon discovery or awareness.
Oh,
So-
possessed upon discovery or awareness. Okay. Okay, inadvertently possessed upon discovery or awareness and immediately reported or delivered to a staff member.
And if we could just add in the superintendent as another level as well.
Okay.
Such a determination must be approved by the superintendent's designee for expulsions.
And the
And the superintendent is what she's asking.
Oh,
Both
and the
is what I'm
superintendent.
asking for.
Okay.
And the principal. I want the principal to be part of agreeing as well, because I've heard things in schools that don't correspond. Everyone needs to be on the same
Well,
page.
I think it's important that that next statement remain. The term immediately means without delay, as determined collaboratively by the school principal and the designee to the superintendent for expulsion. When you say the superintendent, do you actually mean Mr. Run? Yeah, okay,
They are now meeting Mr. Hudson.
okay.
However, I think that it's important that it go to the superintendent's designee for expulsions, and as it normally does through the process, and then for these that are these specific little ones, then those are the ones that go to the superintendent. I think that should be the superintendent's designee that makes that decision, not Mrs. Kearns.
I'm looking for any Class A weapon exception to go to the superintendent.
That is clear.
That's good. That is the best language.
Mrs. Alhadeff, would you like her to read it again, or are you comfortable making the motion?
Can you read it again?
Okay. The student shall be subject to mandatory expulsion for possession of a Class A weapon unless it is determined through pre-expulsion conference that the Class A weapon was inadvertently possessed upon discovery or awareness. Is that it?
So you're making that motion?
I make a motion.
And
Wait, I'm sorry, discovery or awareness and immediately reported or delivered to a staff member. Now, the next phrase was, the term immediately means without delay as determined by the collaboratively, by the principal, and you wanted to say the designee and the superintendent?
Yes, superintendent's designee for expulsions and the superintendent.
After considering the totality of circumstances and prior to being reported by another individual.
so the collaboratively includes the principal. Ms. Kearns, currently in your role, you're that superintendent's designee for expulsions?
It's technically whoever is chief of student support
Okay.
initiatives and recovery.
So that's what it would mean, and the superintendent.
Correct.
In all of those instances, policy read chief/designee. So laying it out, it would be the party conducting the conference on behalf of the chief, but you're also asking that Mr. Runcie be involved in that decision. Yes. Okay? And then understand, I hate that this is taking so much of your time, understand that in those moments when those conferences are being held and we need to get those outcomes, if Mr. Runcie's not available, we would not be able to bring closure to some outcomes which might impact negatively or prevent a child from being able to return to school, that's all.
That delay will be a necessary part of the new expectations.
Okay, and I second it, but I'm just, the way you said it, it sounds like he's involved in the immediately part.
He's involved in
That's not what I'm talking about, the determining
in-
immediately. The principal determines that, and then the collaborative team of the three of them.
concurs on the application of the exception to the baseline. Yes.
Okay, I second that.
Did you say you have a question, Ms. Rupert? Oh, okay, I was like, I can't take any more questions. Anyone from the audience have a comment on the motion? Any of my colleagues have a comment on the motion? All in favor of the motion indicate by saying aye.
Aye.
All those opposed say no. Motion passes unanimously. Any conversation from the audience with regard to the item as amended? Any conversation from my colleagues to the item as amended? All those in favor of the item CC1 as amended indicate by saying aye.
Aye.
All those opposed say no.
No.
Did you get that, or do we need to do a roll call? You have it? Okay.
Yes. Yes.
Yes?
No. No.
Yes.
Yes.
Thank you. Okay, may I have a motion and a second on item CC2?
So moved?
Moved by Ms. Korn, second by Ms. Rupert. Audience input on CC2. Seeing none, I have Ms. Korn, Ms. Levinson, and myself.
So mine is actually on the same point, and so I don't need to speak to it again. I'm not going to make a motion. I think it's been very clear. For my colleagues, it has to do, again, with specifically the possession of having an e-cigarette, second time, 6 days, 3 of those in the school, 3 out. I think it's, I just think the extent of that response, knowing that this is a choice, although a horribly bad one for an individual, is most harshly impacting that individual, and we have decided to take it upon ourselves to treat it more harshly than most of the other occurrences that happen in our schools. And for me, that's detrimental to their educational experience. I understand this is very health sensitive, but I think that there are other ways of going about this, and I cannot support 6 days out for a second possession offense of an e-cigarette. Thank you.
Thank you. Yes, Ms. Good?
So, Ms. Korn, in light of your commentary, can you, would you be willing to make a motion on that issue? Or propose an amendment?
Well, so thank you, Ms. Good, for the question. Because we just passed what we passed, it's
I
already
forgot to
been
mention
done.
it, I know.
So to do that,
I wasn't here that day when you had the discussion, I was listening.
Okay.
So, and I meant to bring it up when I think Ms. Levinson had brought it up earlier, so. But if there's a motion necessary, we could always amend.
Can I ask a question now?
so,
In that policy, did you mean, Ms. Korn? Because I thought that if you obey the contract, you only get 3 days, and that's what you said.
Ms. Bartleman, we can barely hear you.
Oh, can you hear me? Oh. So you said that they would have 6 days, 3 on and 3 off. But the way I read it was that if they...
It's up to 6 days.
Right, but the way I read it is if you...
You could read it that way if you'd like, Ms. Bartleman.
No, but I'm just wondering...
It's up to 6 days, that's my comment.
Oh, that's your comment. Okay, good, but
Thank you.
the policy says if they follow the
I'm
contract, it's
sorry,
only...
I thought I had the
Ms.
floor,
Bartleman?
and I'm very confused as to why. I
confused.
understand that Ms. Bartleman does not agree with me, and I
No, but-
wholeheartedly appreciate that, Ms. Bartleman, but I have to tell you, I had this conversation at the board workshop. I don't agree with the premise, and that's okay if you don't agree with me. I'm totally okay with that. I wasn't even bringing a motion forward. I literally just wanted to have something stated for the record. I see there being a conflict here between us as a board deciding to take a very specific stance on the health of our children, which I fully appreciate, but my greatest burden is educating our children. And I believe that there is a different method in which we can facilitate encouraging the best health for our children without this type of negative impact on our decision to educationally impact them this way. And I'm totally aligned with the fact that my colleagues don't feel that way. And I don't really want to rehash it or argue it. So, thank you.
Thank you, Ms. Korn. Ms. Good?
Actually, I do want you to rehash it, but in a very positive way.
Okay.
If I could just ask my 2 colleagues that spoke to the issue, if you don't mind, if you feel that strongly, I'd like to just hear what the motion would be and have the opportunity to second it. And if it's voted down, it's voted down, but I would certainly like, I appreciated the commentary from Ms. Levinson earlier on the issue, and I meant to bring it up when we were talking about the other point, and I'd like to have the opportunity to just, if you can try, and if you don't want to at this point, I can respect that.
Thank you, Ms. Levinson.
Ms. Good, I appreciate that, but having a really extensive conversation at the workshop, I know that there's not enough support for, you know, the belief that two of us have. I'm not sure what your opinion is because you were not there. But I just would prefer to move on. We have so many other items, and, you know, I'm not going to rehash it again. My primary thing with kids is to keep them in the classroom, have support and interventions, and proceed that way.
I just had one second question. I'm
Yes.
sorry. On page 38, just for my clarification, which staff I'm sure is very clear on.
Is this, I'm sorry, page 38 of the
Of
changes?
the actual, no, of the actual item.
Thank you.
So this is under the drug and substance abuse offenses leading to suspension and possible expulsion. It talks about the accruals occurring by school level. If I understand correctly, when we start talking about then first offenses, second and third offenses, they're accruing at each level. And the levels are defined as K-5, 6, 8, and 9, 12. Is that correct? Yeah. So if I have accrued 2 incidences in K through 5, come my 6th grade year, I would then be a first offense again. Is that correct? Yeah. Okay. So we talked about this at the Promise program level, and I don't want to mix, but at the Promise program level, we've talked about 6 through 12. So I'm confused as to why we're now segregating 6 through 8 and 9 through 12 on first, second, and third offenses. I understand from the kindergarten, right, for the kindergarten through 5th, but for Promise, which is 6 through 12, why are we treating those as one accrual period, but in everything else in the district, we're separating those accruals?
This is not Promise. No. So,
Yes, and this happens in multiple places. I'm just pointing that out in the one specific location, sorry.
so when the committee was putting forward this recommendation, because Promise was being addressed a little bit differently, it followed a little bit different guidance. All of the other infractions that are high level that possibly qualify for a recommendation for expulsion, they wanted to tier it out. So for example, if I'm in a section 4 of policy 5006, let's say vandalism, well, I shouldn't use that because that's a Promise infraction. Let's say this is one of our substance-related infractions that's non-Promise eligible. If you are in the middle grades, 6th through 8th grade, you are in section 4, the first offense would be 6 to 9 days of a suspension with alternative probationary contract. On your second offense, you would qualify for a recommendation for expulsion. However, if I am, excuse me, I misspoke, that's for the high school level. If I am in middle school, you would be one tier down. First offense would be 3 to 5 days of a suspension. Second offense would be 6 to 9 days with an alternative probationary contract. Third offense would be expulsion. If you brought through a 6th through 12th grade, it would not allow the middle school student, when they do a second offense, to have that second opportunity. They would immediately go into the recommendation for expulsion when they were in the transitional years from middle grades to high school. That was why the committee...
I fully appreciate what accrual means. I don't think we contemplated that at this level in our last conversation. And so with that said, this would be a substantive change. I'm not looking to recommend it today because I want us to have a much more thorough conversation. I would specifically like, through the chair and Mr. Runcie, that before this comes back to us, that be a specific thing that is vetted in the conversations with the AC, whichever full groups see this. I would like them to weigh in on the accrual periods for each of these categories.
So absolutely, and connected to the accrual periods is the issue of, do we treat younger students with different consequences than older ones? 6-12, 6-8, we will loop it and make sure that everyone is consulted before you see it again.
That's exactly what I'm looking for. Thank you.
Thank you. Ms. Levinson? Oh, you're asking?
Are we voting?
We
Could
are.
we vote,
We are, but
please?
Ms. Bartleman has her hand up. Ms. Bartleman?
So, the reason why I was asking Donna about her question was because the way she said it, I hadn't thought about it, and I thought of some compromise language, which wouldn't be 6 days. So I wasn't actually going to argue with her. I was going to try to find a way, because when I thought about it, in my head, they would go to the 3-day tobacco program, take the class, meet with the substance abuse, and the thought didn't occur that it didn't process that then if they don't do that, then they have the 6 days. So I was going to offer, and I don't know if it's a big change because I could keep it either way, but I understand her point, so that's why I was trying to fix that, is instead of having 6 days, it would just be the 3-day, and they go to the program. And even if they don't go to the program, it's the parent's choice. They don't have to go to the program. We want them to go to the program. But it would still be the 3 days and take out the penalty for the 6. And I don't know if we would need to do that in the other one or not, but I was trying to get to a place, because the idea was to get the kid to go to the tobacco abuse program. It was an incentive. And so I would hope that there isn't a way we can incentivize them without it being a full 6 days. So that's why I was going to try to see if there's a way, because until she phrased it that way, I hadn't thought of that. Like, if I'm a mom, I'm going to be like, you're not going. But then that is 6 days. So if there was another way we could change it to make it the 3 days. And I don't know if anyone has an appetite to change that, or if they just want to keep it. I could go either way, but based on her comment, it made me think of it in a different way.
Thank you. So I have a question for Ms. Myrick. If there was an appetite to change it and a motion was made, would that require it to come back?
If you're just changing the days.
Yes, it's a substantial change, changing the days.
And we can't do that. Okay, so but for next year, I think it should be flagged to possibly change it, for possible changes, and we should look at the data and see the impact it had, and see how many really took advantage and went with the 6 days, and then modify the policy. So, thank you.
Mr. Gold is shaking his head, so I think he's making a note of that.
Okay.
If there isn't any further conversation from my colleagues, all in favor of item CC2 indicate by saying aye.
Aye.
Those opposed say no.
No.
Yeah.
Yes, it's the same as CC1, the yays and the nays. So now I'm going to ask Mrs. Levinson to clarify, you would like me to pull CC 3 through 12?
Yes.
In addition to II1, all at the same time to be on the table?
No, I would like to take II1 first.
Okay.
And then once we decide what we're doing for II1, then it'll translate to CC3 to CC12.
Perfect. All right.
Is that acceptable?
All right, that is perfectly acceptable, because we want to make this as easy as possible.
Okay.
Given the fact that it's 417. May I have a motion and a second on item II1, please?
So moved?
Second.
Moved by Ms. Korn, I think, seconded by Ms. Good. Anyone from the audience on II1, please? Oh, I'm sorry. Yes, for my colleagues, that is in the second box of items that we received, so you might need to switch out your...
I already
boxes.
pulled it
Yes.
out.
So we'll start with Ms. Levinson while I look for
Okay.
my items.
Thank you. Okay. So I'm just gonna just go through the sections, and I just have a couple of quick comments. And I just want to make sure, under financial management, the changes being made there with benefits and budget analysts, support specialists, there'll be no shortage there of analysts or support specialists, since you're cutting a few of those positions.
Through the chair, thank you for the question. Judy Marte, Chief Financial Officer. No, ma'am. We continue to align staff, and I think I've said this before. There was a period in time where there was a preponderance of buying positions below the line because they didn't have to come to the board, so it was easier.
Right.
They just, and many of those people do a wonderful, tremendous job and are highly skilled. But as vacancies come on board, it's been my practice the last few years I've been here, and tomorrow's my 2-year anniversary.
Already?
It is. So to hire in degreed accountants, preferably with master's degrees or CPAs, who just have the training to do the analytics we need to move the work forward. So there will be no shortage.
Perfect.
This continues to correctly align the staff for succession management, to have people ready to take over as people grow and assume other roles, and I'm confident we'll end up with a better result for the district.
Okay, thank you. I'm in full support of all the safety, security, and emergency preparedness positions. I'm moving forward with those. And actually support all the other areas. There's only one area that I'm not able to support, and that would be under portfolio services. I cannot support another director for school choice and parental options. As Ms. Marte just mentioned, what she's doing in her area, we need to look at how work's assigned and work with what we have within there. I know there's analysts and a specialist being eliminated. I am not looking to eliminate those people who are doing the work to add another director position, so I will be unable to support that, and we'll ask to separate that out after I hear from my colleagues. Thank you.
Thank you, Ms. Levinson. Dr. Osgood?
I'm good. I got my question answered.
Thank you, Mrs. Alhadeff.
Page 9. So the chief auditor reports directly to the superintendent and indirectly to the school board. I asked Ms. Myrick to give a formal opinion on this based on the new Florida state statute, and which says that the internal auditor shall prepare audit reports of his or her findings and report directly to the district school board or its designee. Ms. Myrick says in paragraph 2, refers to the requirement that any reports prepared by the chief auditor should be given directly to the school board, not the auditor organizationally reports directly to the school board. So that's her professional opinion. I believe that we are not in compliance, so I've sent an email to Cheryl Norman, the Florida Auditor General, to get her opinion on Ms. Myrick's opinion, and so when I get that information, I will share it with the board. Thank you.
Thank you.
Can I ask a question?
Hold on, not yet.
Oh.
It's good. Nope, I'm good. Ms. Bartleman?
Should we, if that's our attorney's opinion, why wouldn't we just change the line today? I'm just suggesting that.
It's, I don't know,
Yeah,
it's
it
my
could go-
opinion that, it's my opinion the way the organizational chart reads now is within
But
the
it could
law.
also go to us as well. Directly
Yeah,
report to
it
us.
does. In fact, you have a policy. I also put in, and I sent to you, I think you all received the notice.
Okay. Well,
The school board's policy about the chief auditor, sorry, I'm looking at this, also states that the auditor shall report the superintendent and is accountable to the school board. The policy states that all of the audits that the auditor does goes to the audit committee to be transmitted to the school board and to the superintendent. What I believe the statement that Ms. Alhadeff reads is that the report, that nothing should interfere with the reports going to the board. In other words, Mr. Runcie can't get the reports and say, I want this changed. They need to go directly to the board. He doesn't even get them before the audit committee does. And so that's how you all have set that up. So to me, the answer to this is, to that number 2, is if you want the audit reports to go directly to you, all three of you, audit committee, superintendent, and/or and the board at one time, I think that would be perfectly acceptable, but I just don't read that phrase in that paragraph means that the superintendent reports, because it's talking about the reports the auditor does, because if the beginning of the statute, it says the internal auditor shall report directly to the school board or its designee. And I believe by the policy you have written, as well as your approval by the organizational chart, that he reports to the superintendent with a dotted line to you. To me, the dotted line to you means that they're accountable, which is what your policy 1002.1 means, so.
Okay, well, I guess for me, I know we can have a solid line to us. I don't know where
You
the
could.
board is.
Sure you could.
And I also think we should wait, if we want to wait for the Auditor General's opinion, because there has been no appetite to do that. I've been trying to do it for years. Also, your comment about the audit not going to the superintendent before the audit committee, has that always been implemented with fidelity in this district?
I don't know, I'm just telling you what your policy says. Your policy says that, your policy says the audit committee for review. Additionally, the policy states that all completed audits must be presented to the audit committee for review and transmitted to the school board and the superintendent. I don't know the order of
Because
that.
I believe audits have been discussed in APG before. So how would that, maybe not under this gentleman, but under Mr.
Well,
Riley?
that means
I
it
know
still
it's-
might have gone to committee. I don't know what that means. I'm just reading you what it says.
I just
in
know
your
something
policy.
that happened with Mr. Riley at one occasion that I'll speak to, and I want to make sure that we're following that with fidelity now. So do you give it to the audit committee first?
Hold on one second. Please put the microphone on at the podium for Mr. Jabon.
Good afternoon, board members. I'm Joris Jagoan. I'm the chief auditor. Mrs. Bartleman, your question again, please?
Do you give the auditor the audits directly to the audit committee without it going through APG or any other of the staff?
APG is the process that gets it to the board, so we do that afterwards. So it's presented to the audit committee. So for example, we have a meeting on June 20th.
Okay.
The reports will be sent tomorrow on June 13th to the audit committee members, and then it'll go through the APG process after that.
Okay. All right, and not before. They don't ever see it before it goes to the audit committee.
The people who are the auditees will see it before because they'll have an idea what the findings are and so forth.
We have to provide management responses.
And if I may, through the chair, in light of some of the questions that have come up, I can address the questions with independence, if I may. I have been a chief of audit since 2000. And with respect to our work and our reporting that we do in this function, and I've now been here for 1 year, my function is working as independent as it ever has been throughout my career. So in my involvement with the various chiefs and the superintendent, there is no meddling in our program. There is no changing of the reports, changing of the findings, don't look at this area. None of those type of activities occur. In fact, it's the other way around. We've gotten support from the superintendent and his office with respect to being able to add to our staffing, with be able to engage consultants to be able to do the work, and there's been additional work that's been added to our team as a result of that. So there is no concern that I have with respect to the work and the reports that you that I would go over in this meeting with respect to how we function and any concerns on that on my part.
And then when you guys go for the staff responses, in the past, and maybe it's because they're responding really well, but in the past, Mr. Riley has had some issues with the responses, so I'm hoping that the issue is that they just have had good responses that you agree with. But he, in the past, if he didn't agree with the staff's recommendation, he would note that for us as board members. So did you follow that protocol, or do you just accept the responses?
Let's just be reminded that we're having a discussion about
Oh, okay, all right, well, do you want to answer that, or no?
I could answer that question. With respect to the responses, I am reading them very carefully, and I'm looking to ensure that they're addressing the root cause of the issues that they have due dates, and to the extent that they're not, then I am sending them back. It does impact the timing because we want to be able to get the responses back to get them into the report, but I think that there is going to be more of a learning as I work here longer with what the expectations are on responses. So I'm not fully happy with some of the responses, but I am sending them back. But the cooperation has been good. What's on your agenda today are the Auditor General findings. On the first draft.
Mr. DeBowen, we're only talking about the
sorry.
organization.
Okay,
Oh,
so
thank you. I'm sorry about that.
I feel, for me, I would support a solid line, and I will, and I have other questions, but I'm going to make a motion with a solid line to the board.
Second.
It has been moved by Ms. Bartleman and second by Mrs. Alhadeff that the chief auditor have a solid line as reporting to the school board. Any audience input on the motion? Any input from my colleagues on the motion? Yes, Dr. Osgood.
You know, this is a hard decision for me because so it has been a situation on this board, and I'm going to say this to say why I don't support the solid line. When you say that the auditor is going to report to the board, then we would have to identify who the auditor is going to report to. And I know in the past, and I have proof, that board members have instructed the auditor outside of the board to do an audit on a particular staff person. That staff person filed a complaint on those board members. It could have been a really bad situation for all of us. We had nothing to do with the decision. The board members dealt directly with the previous auditor, and they went forth with those board members' recommendations. When the board makes a decision, it's all of us having a conversation and voting collectively on that decision. We have a process in place now where we can ask for workshops to talk about any audits that we want to audit and see. It is a part of the audit process that when the auditor makes a report and has findings, that management responds to those findings. They respond in the way that they respond. If the auditor feels like the response does not give enough information, they can request the additional information. It's not a matter of whether you agree or disagree. If I have a management practice and the audit finds that it's improper, and I respond at the way that I'm addressing that issue, I could be out of compliance. I can't change my response to please anybody. The audit does research of the facts, and the facts are the facts. So I can't be manipulated to change my response. But I would not want to have this board be responsible for that because of past practices of particular board members operating and, in my opinion, compromising the auditor by instructing the auditor to have moves and question a particular employee because they were individually having an issue with that employee. Their issue could have been warranted. I don't know. I wasn't a part of the issue. I didn't have the information. I didn't appreciate the auditor responding in the way that the auditor responded because it did not represent the whole position of this board. I was never given an opportunity, nor my colleagues, to even weigh in. We might have voted that we wanted the same thing, but we were not given that option. So when you set the auditor up to respond, to report directly to the board in that indirect way, in that direct way like that, then who does the auditor respond to? Ms. Levinson may want the auditor to do this, you want the auditor. All of our voices and all of our votes are equally important. So then how does the auditor decide how the auditor is going to respond? I have a lot of confidence in the audit committee. I think they've helped us out a lot over the years that we've been here. They're kind of that accountability piece that's outside of any of us that makes recommendations to us a lot. And sometimes their recommendations are very challenging. I don't see them as a group that rubber stamps anything. They come, they give full reports. They're down in the, they're down on all the levels of the organization looking at things and doing their function as an audit committee as to why we have them. So if I had not had that experience, I probably could support what you are recommending. But because I had that particular experience that ended up with a case and information, you know, to the state attorney's office and a whole big report and everything around that, is why I'm hesitant to put that in place. In isolation of that experience, I could agree with it. We also brought in an attorney general. We had a long discussion. Ms. Levinson brought an item about the attorney general. We had input, we had a whole workshop on that. We was given information on how we have access to that function of that attorney general to have things done outside of the practice and within the district if we felt like we needed to have something extra done. We was given the contact information to the person that was here and told how we could follow that process. We also talked about having the Attorney General of the county represent us as well. We found out through some legal or whatever that that was not the appropriate way for us to go. So we have talked about this issue. We've tried to address this issue, but I wouldn't want to put the auditor in a position to be compromised, because as a board member, if we have the auditor reports to the board, and then we would have to decide who the board, what that would look like, how that would be implemented, then I need to be assured that everything that's taking place, that I have an opportunity to express my concerns or support for it. And in the past with Mr. Riley, I felt like he was compromised because he had relationships with certain board members, and they had conversations with him, and he took actions based on those conversations. And what I'm saying, if I have to bring a recording to say what I'm saying, where you could hear the voices and hear this going down, I'm able to do that. So that's why I'm not supporting that direct line, because I felt that it compromised Mr. Riley, and I don't want to be in a position to do that again.
Mr. Runcie.
So this is a conversation we had on a number of occasions, and I distinctly remember a school board workshop we had within the last couple years, where the conclusion was that there were a number of ways that the auditor would determine what he would audit. One, recommendations would come through the audit committee. Number two, I could identify areas or opportunities that I would see in the organization. Number three, this school board at a workshop, or it could be a school board meeting, could collectively decide that there was an issue of significance that they want to be pursued, and they would direct me to have the auditor go ahead and pursue that. So we've created a mechanism where the school board, the superintendent, and the audit committee can have some discipline and structure around focusing on areas that need to be audited. In addition to that, as you mentioned, we brought in an auditor from the Federal Department of Education. He's their Inspector General. You know, if we needed to have additional work done. And we also use external auditors as well. So there's always been a plethora of opportunities for us to conduct audits. Relative to the quality audits, I can tell you they've improved, because we've had conversation here over the last couple of years about the quality of staff's responses, and sometimes those responses were not thorough, or they were quite frankly weak, and that created some issues for us. So we have been pretty diligent in demanding that staff collaborate at a high level, that responses to the internal auditor are given significant priority in terms of how those are done. That's why you probably see improvements in the quality of the responses that are given. It's not that the auditor just sends something out and wait for any kind of response to come back from staff and they check it off as a compliance item. We're being pretty comprehensive in what we're doing in terms of how we're responding. So that's my sense, and just to bring some history for anyone that wasn't here and recall that.
I have some other people that have asked to speak. I have Ms. Good, followed by Ms. Ford, then Ms. Bartleman.
So this is just on the, yes, just make sure. So to to the motion, I guess what's missing as part of the discussion is the fact that the audit committee is not referenced on this page in any way, and I know that typically we don't, but the audit committee to me is a little different because we have appointees on that audit committee, and then the chief auditor works with them, reports to them, the reports that were mentioned earlier, and then that goes up to us as far as their reports goes to us. So I think a dash line needs to be reflected, and I think it's critically important in the conversation of whether or not to make the chief auditor directly report to us. Did I do something? Did I miss it? Madam Chair?
Page 1.
Oh, it's on that page. Sorry.
Yeah, it's on 9.
I'm sorry, but when I was looking on page, oh, it's not on my 9.
It's on page 1.
It's on 1. Oh, that's why
Oh,
I
okay.
wasn't following.
It's not on 9. That's why, I'm sorry.
So we could cross-reference.
It's on 1, but you're saying it's not on 9. We could certainly
and I
add
guess-
it there. That
We
would-
can add them.
But I just think it's important, because all our committees are important, but the audit committee has a critical function in what we do and what we review, and they're very independent, even though we have appointees on there. The relationship between them and the auditors is very crucial. I apologize, it is there. Okay, and so there is a line that goes straight to us. So I will not be supporting it, because for the same reason that when we all got on this board, there was issues of board members interfering with day-to-day operations. And I do not want there to be any perception that us as a board or any one of us as individuals has the opportunity to influence our chief auditor. I think it's critically important that that individual remain independent from this board. And that's why I brought up the issue of the audit committee, because he right now works through them, and then that comes to us, and the same way with the superintendent. You know, it's critically, it's independent of us, and I think that if that were to change, it could really cause issues for this board. And I really appreciate the chief auditor's comments earlier. He stated on the record his satisfaction on how he functions within his department, the independence of that department, and I have to say that Mr. Runcie has been extremely supportive of how that department functions and their need to have additional auditors so that we can ensure that they are on point on the schedule of audits that need to be conducted. And when items have needed to be audited, there's been discussions here on this dais as to the importance of those. So I will not be supporting the motion at hand.
Thank you, Ms. Good. Ms. Korn?
Thank you. Just a quick question. Ms. Myrick, does the dotted line give us as a board the authority, if we collectively want an audit, to request the audit and it be, the audit be completed without the superintendent necessarily saying that he's included it in the year's audits?
I'm not sure the dotted line does, but I believe your policy does. And let me go back to the memo that I wrote. So I quote the, hello, am I on there?
Yes.
The memo says that, that your policy, says that the chief auditor reports the superintendent administratively and shall be accountable to the school board and the audit committee. So I believe that that language clearly allows you to make a collective request of a specific audit if you wanted to do that.
Okay. So to me, it's important that we collectively have that ability, not independently, but then also that we have the opportunity to be able to see the audit as it is presented, as it's issued, as well as obviously the comments, the feedback, which we do. So I I don't see a need to make that change. To me, there's a risk involved in putting that direct line, which I don't think we need to put ourselves in that position. Thank you.
Thank you, Ms. Korn. Ms. Bartleman?
Yes. Other school districts across the state have policies and procedures for doing this. It wouldn't be an individual board member. It would be a collective making a decision. I guess my issue is the independence issue. And first, let me preface this. Any audit that I have ever asked for, I usually ask for on the dais at a workshop, and Mr. Runcie has agreed to every single one. He is not afraid of looking into his books. He is not afraid of identifying problems, and he's not afraid of fixing them. And I will always give him credit for that. So all the audits, like the asphalt one and all of those are all brought up on the dais, and Mr. Runcie agreed to them, and things were found. The reason why is, and to be independent from the board, an auditor doesn't audit the board. The auditor audits the operations of the district. The operations of the district are handled by the superintendent. So to me, the independence would be from the superintendent. If you look at any company or how people do things, they hire an outside auditor to audit because they don't want anyone involved in the operations as part of the audit or them reporting to the person. Now, because we have an internal, we do have some outside auditors, you're correct, and we have outside auditors at the state.
Not for that
Yeah,
reason.
you're right, but my point, I'm not arguing that with you, Mr. Runcie. My point is that the independence doesn't need to be from us, but as far away from the operations. And I actually prefer having a totally outside person like the county does and totally independent, but people don't want to spend money on that. And again, I'm going to say this again. You can tell me to call the different lines, and I will say this again, everyone is responsible for different things. If you have federal Title I issues, you do not call the FDLE. You have to call the gentleman with the cell phone number, all of those things. So it makes it hard for the person. I also asked last time about all the hotline tips that he gets for audits. He has not been able to complete, last time I spoke, he hadn't been able to address any of the hotlines. Have you been able to do any of those lately? Those are issues to me. Those should be issues to Mr. Runcie. That wasn't brought to any of our attention. That this whole year, those audits, or none of that stuff has been looked into after a year because there's not enough staff or people catching up. So I will support, I just want you to know I support giving you more people or whatever you need to get this done, but those are issues, and it could be a solid line to us and a solid line to Mr. Runcie. And we could make policies that it's a collective decision. It's not unheard of. I'm not asking for some terrible conspiracy thing. It's something that's done in other counties. It's done in other organizations. That's all I was asking. If there's no appetite for it, I'll withdraw it, but I still feel that way. But I will make do we need the motion for the line to the audit committee, Patty? Because I will withdraw my motion and add that one, or was the line there? To the audit committee, was the line already on, did you find it on the page or no?
With regard to the committees, there is no line to the
Okay, then I'll
auditor
make,
on that.
then I will, because I don't want to fight this again. Clearly, it's going to be a losing battle. But Mr. Runcie, he either needs more staff, which we're giving, but something's, when I heard that, and that just happened, like I didn't ask that specific question, but it came out, that concerns me. Have you been able to address any of the hotline audits or anything? The tips you've gotten
The
since
answer
we
is
spoke?
yes, Ms. Bartleman.
Miss-
There are.
Ms. Bartleman, excuse me, Mr. Jaboan. So the difficulty is, here's the difficulty. We're having a conversation about the organizational chart.
Okay.
And whether or not he has the capacity through the boxes that he has on his organizational chart to fulfill his function is a different question as to the reporting structure for the auditor. So,
Okay, well, I think he needs to let us know if he needs more people to complete everything.
agreed, I think we would all agree with that.
Okay, number one. Number two, I'm not going to argue this anymore. I stand by why there should be a line to us. It could be to us and Mr. Runcie, but I'm not going to argue it. But I'll just make them. So I'll withdraw my motion and make the motion to add the line to the audit committee.
Ms.
Brinkworth?
Brinkworth, may I just make one correction to what Ms. Bartleman just said?
Sure.
you made the statement that you would prefer to have it all being outside, and the new statute requires us to have an inside auditor.
I know.
Okay.
I
just
get
wanted to
it,
make
I
sure
get
that-
it, but I
okay.
think it should be all outside.
Okay.
And in addition to your auditor, you could have someone like the county has. We could definitely do that, and we don't. And that is something that I would have liked to see. But there is no appetite for that, nor is there any money for that. And it's been, I think Ms. Levinson's the one who brought the item for it. I agree with it. There isn't an appetite for it now, but in the
Ms.
future, it's
Brickworth?
something the board should look at. So I will just withdraw the motion, so we don't have to talk about this and go to my other questions, and make the motion. You don't want me to withdraw it? All right, then I won't. Okay, we'll just vote on it. We'll stop discussing it. I'm going to amend no, I can't. It has to be a separate motion for the audit.
Okay.
Ms. Brinkworth, may I
Yes,
please add
Mr.
something?
Jaboan.
Thank you. One of the things that that may not be known is my previous job, I was the chief of audit for the Massachusetts Port Authority. And under that organizational chart, I reported to the full board. The dynamics of that board is much different than the way that this board works as far as some of the discussions. So we didn't have the instances where I was being pulled, which apparently there's a history of that. So it was a much different type of organization, and the audit committee was a subset of the board members. So when it came to my reporting, I reported to the chair of the audit committee, who was a member of the board as well. So what I see that's happening through my experience is that how are we functioning on a day-to-day basis as an audit function? And we are indeed operating independently, and as independently that I have seen in my career. So I don't face any issues. I do address the matters that come in the hotline. And there's something very important that I'd like to close off on is, though, the chief executive officer at Massport, I did not report directly to him. And I didn't feel the involvement that I have as far as getting information from the chief executive officer as I do now, because it was more of the person didn't really welcome the audit function and didn't view that in the way that I see that's happening here at the district. So there are a lot of different dynamics in that workplace than there are here, but I can report that we are operating independently with respect to the work that we're doing in all matters of our function, if I could add to that.
Thank you. Thank you, Mr. Jaboan.
Okay, so what I'll do is I'll just let us vote on it so we're on the record, then I'll make the motion for the audit, and then I'll ask my next question.
Okay, can you repeat the motion?
The motion is to add another direct line to the school board.
And the second was?
Instead of the dotted one. No, because we have to do them separately because there's not going to be support, and I really think everyone supports the audit committee motion.
I'm sorry, so your motion is only for the direct line from the chief auditor to
Just
the school?
yeah, you can have them report to superintendent and us, just change the dotted line to a solid line. And then from there, we'll have to have a workshop on a policy, but it's not going to pass, so.
And who was your second?
Lori.
Al-Hadaf, Mrs. Al-Hadaf. Any discussion on the motion from the audience? I think we've already had our discussion. All those in favor of the motion indicate by saying aye.
Aye.
All those opposed say no.
No.
Okay. I'll let Patty make the other motion, then I'll go to my next question. I just thought it would be easier because we were on the
Thank you.
Audit committee, and then we could clean it up. Okay. So I asked a question of Mr. Moquin, and apparently I didn't ask it the right way, because I had a question about the money and how we were saving all the money with all the positions. And so my question was about which positions we were eliminating, and I guess it came across as which positions were we eliminating that weren't filled. And then I was told these are below the line positions. And then I was told that, oh, there's only one below a line position that we're eliminating that is filled. But then I know people who are not going to be working for us anymore. So I have subsequently asked for the people, and how did you term those people who aren't working for us but aren't the way I phrased it, Mr. Moquin? Like, how did I have to ask that question so I get the right, and I know you're going to get it for me, but what's the question?
Well, I don't think it's an issue of how you asked the question. What I tried to explain to you was what staff had provided was a list of individuals that they were aware of at this juncture, recognizing that the reappointment item doesn't come until 2 weeks, that are not being reappointed, as well as those positions that we are eliminating as part of the budget cuts to central administration.
Correct.
And that all those positions were vacant.
Okay, correct. And the reason I'm asking that is because you show for the district that we're actually saving money, but we're eliminating positions, but then we're also eliminating positions that people are in. And I wanted that list because what happens is if people hadn't contacted me that they didn't have jobs, none of us would have known, they just wouldn't have not been reappointed. And are we sacrificing those positions to keep the budget where it needs to be?
No.
At the district level? That's what, so then why are we eliminating those positions?
I'm not sure I understand the question.
Use your microphone, please, Ms. Marte.
I'm sorry, Mrs. Bartleman, I'm not sure I understand the question. So I was the staff member that responded to what I thought was your question. The one meet and confer individual not being renewed, you received. We have, in 2 budget workshops, gone over with the board a number of vacant positions that the chiefs have collectively eliminated as a budget savings. They are all vacant.
Okay.
Aside from those positions, there are additional, we're not double counting, so I'm not counting the savings twice. We actually went through one by one, made sure we weren't. There are positions we are recommending to eliminate here. None of them would cause anyone to lose their job. I don't know if that answers your question.
So you're saying on the record that everyone in all of the district departments are going to be renewed and keep their job? Is that what you're saying?
So as it relates, so I.
No, it's
wait.
a very.
No.
It's a.
No, let me just say, as far as the org chart and the
Yes.
budget's concerned,
Yes, yes.
we're not, if we decide not to renew someone, we decide not to renew someone. That doesn't mean we're eliminating a position. We may actually go and refill the position, but we're not, to your point, eliminating positions above and beyond what we've put on hold to create budget savings.
The reason why I wanted that information is because we're adding a lot of top-level positions, and we are eliminating worker bee positions to balance a budget and get it within. And I am, look.
I don't know that that's the case, Mrs. Bartleman.
That's
What
how
I
I
would like,
feel.
what I would like is if you know of people
Yeah.
who have indicated that they're not getting their job,
Yeah.
I'd like to see if there's some sort of a category that somehow we overlooked
I get it for
in
you.
fulfilling your response. But we are not eliminating or laying off or surplusing individuals for the purposes of trying to save money on this org chart. The individual that we did identify, that position's staying.
Well, I was
It's
just
just the
shocked.
person's being non-reappointed.
I was just
Or that's
shocked
the
that you
recommendation
said
from the
only
director.
one person, and I know very well there's more than one person.
So
And
if you'd like
but
to share with them
I will, but
offline,
you know
I'll see what the.
But you're not aware of it? That's what scares me. You're not aware of that there are other individuals and other
There's a-
positions that are being eliminated?
There's a difference between non-renew and eliminating position. If you're not being renewed, doesn't mean we're not, that we're gonna eliminate the position. We are probably gonna rehire for it, or, I'm sorry.
I don't think that's the case in this, but you know what? That's not the case, but we can go around in circles. Again, it goes down to the nuance, non-renew or not. I just want the list that you have of the people who are not going to be renewed. That's all I need.
We gave it
Thank
to
you.
you.
No, the individuals
me,
who are not being
Ms.
renewed.
Bartleman, I'm trying to be very patient, but
I'm
it is.
sorry. It's very frustrating when they tell me one person, and I know there are other people, but I'll just,
As
it's okay,
Mr.
I'll do
Moken-
it all in memorandum. No, but you understand, I'm sitting here, and they're telling me there's only one person.
I understand, and Mr.
And I
Moken
know
asked
there are
you
other
to
people.
provide the list, and I think that you should do that to the entire board so that we're all aware and that the communication
It's
be
just-
shared between everyone, because it's important for all of us to know.
It's very frustrating. You understand my frustration. So, okay. All right, so I'm not going to say anything else. That's fine. I don't understand how the numbers work and we're saving money. I'll just leave it at that. And do all the safety dollars come out of the safety, is it coming out of the referendum money for the safety positions? Are we funding?
So I'll let Ms. Marte address that. That was one of the reasons why she called me for the revision of the items that came to us this morning with the yellow papers.
Okay, well, it's really hard for me to look at the yellow papers during the meeting, so can you tell me?
So, yes, ma'am. Through the chair, all of the org chart positions are funded by general fund dollars. So last year, when you all adopted the budget, the final budget, there was an item that you supported for the organization that now is constituted under Chief Katz for an annualized cost of $3.2 million. So that was fully budgeted going forward into next year. So the short answer is everything on the org chart is general fund. The referendum dollars are staffed directly out of schools.
And so we're still saving money, but even though we're cutting those positions?
Can I try to provide some clarification? Because I know that there was some inquiry about this that I had to respond to the PIO's office, right? So there's no doubt that by adding positions and adding an entire new division, that's costing the district money. That's different than the issue of the financial impact of the action you're going to take today, right? The financial impact is based on the action you're going to take today to approve this. And the fact that last year, positions in the PIO office were approved, and that financial impact was identified in that particular item, and that the financial impact of approving the new division was included in the budget, we're not going to repeat those expenditures in this item because it's not a function of what you're being asked to do and approve today. Those are two different things. But yes, that division is costing $3.2 million. But it was previously approved, and that's why it's not included in this financial impact.
Okay. Thank you.
Any additional questions?
No, that answered that.
Thank you.
That's good.
Ms. Good?
So just real quick, on page 19 with the Officer of Economic Development and Diversity Compliance, so that position now is reporting directly to the Chief Strategy and Operations Office. Is that how it is? The one on page 19?
Yes, that's correct.
Okay. And it's right here, right? If you could just highlight for me again how that's going to function.
So good afternoon, board members. Maurice Woods.
I thought I'd let you stretch.
I needed to, actually. Thank you very much.
You're welcome.
So your question is around how that position is going to function?
Yes, sir. Is that your position?
Yeah, so just give me a second to get my paperwork together here. Okay. So the way that the rationale for this position involves a couple of things. One, we've done some benchmarking with other organizations. Two, we're looking to continue to mature and grow this area. And we think that by reallocating resources, this is actually a cost-neutral proposition that we're bringing forward, that this position will allow us to have increased focus on the outreach efforts, which we understand and we know based on recent data analysis that we need to continue to improve our outreach across areas to include non-SMART or GOB commodities, related commodities. So we talk a lot about, across our entire portfolio, we need to focus our efforts on outreach in that area. In addition to that, we know based on some of our peer districts and some of the pain and pressures that they've had in the past, that it's important that we continue to improve our ability to monitor the data and make sure that we're in compliance with the commitments that we are making on our contracts. Okay. This position allows us the opportunity to do that more effectively.
And I appreciate the dialogue, and I wasn't able to be part of the conversation when it came up to the board, but I'm certainly supportive of this measure and think that it's necessary in our efforts to further diversify our opportunities for businesses in the community. So I'm supportive of that. And certainly I would just ask then in relation to page 9 with regard to the auditor that we have a dash line from the chief auditor to an audit committee box and then back up to the school board, just to, in the event that anyone looks at this particular page, they can see the interaction between all the various components. So that would be my motion.
It's been moved by Ms. Good and seconded by Ms. Korn that page 9 of the organizational chart include a dotted line to the audit committee with a dotted line up to the school board. Is that correct, Ms. Good?
Yes, ma'am.
Thank you. Any audience input on that motion? Comments from my colleagues? I'm sorry, Ms. Marte, hold on one second. Any comments from my colleagues? Ms. Marte?
I just want to be sure we're clear. So on page 1, the line from the audit committee to the school board is a solid line. I think you just said dotted line.
Okay.
You want the same line that's on the first page to show on page 9, correct?
No, you're right. Yeah.
So let me ask Ms. Good, do you want a solid line for each, or do you want?
So I'm just trying to,
It would only be the audit committee box to go on the auditor's page. You
I
want that-
really want to show the audit committee box on this page. I think it's really important.
So you,
And
I think you want a solid line to the school board of Broward County for the audit committee with a dotted line to the superintendent of schools like it shows on page 1. Just on page 9, the
But
exact same
see,
thing.
my issue though, and maybe there's some, I don't mean to have great dialogue over this box situation, but the auditor right now,
Talk about the audit committee.
right, the chief auditor makes reports to the audit committee, and those audits come to us. See what I'm saying? He may have a direct line through the superintendent and a dash line to us, but he also has, he also should have a dash line to the audit committee. He can't have multiples, I don't know, I mean, multiple.
Ms. Myrick, did you have a comment?
Well, it just seems to me that page 1 is out there to show the board committees that you make direct appointments to. I don't think that that solid line means they report to you. I think it means, as it says there, school board appointed committees. There are other committees down here that you don't make your appointment. So it would seem to me that if you're going to put something on 9, that you should have the box with the dotted line
Right.
to the superintendent and to you, and probably a solid line to the chief auditor.
So the chief auditor, you're saying
No?
he doesn't report to them?
Well, they don't really report to anybody. They are your committee, but they don't
I
really
understand.
report.
But they do. They send their reports to us.
Then put the solid line
Yeah,
there. That's fine.
well,
No.
no, so what through the chair, I'd recommend, just for clarity of how we actually function, that there would be a dotted line
Yeah.
on page 9 to the audit committee. I mean, we operate with them very differently than we do
Yes.
any other committee in this organization, so I believe
So
it
my-
would be appropriate to do so.
So I thought that the dotted line would go from the chief auditor to the audit committee and a dotted line back to us. It's a relationship.
Okay.
That's all.
And that was seconded by Ms. Korn.
Yes, it was.
Yes.
That's-
And I asked for audience input, and now I'm asked for input from my colleagues.
Yes.
Ms. Levinson?
Ms. Good always talks about consistency, then you have to change what you did on page 1, because you don't have the same line on page 1, so, I mean, it should be a solid line to us. That way you have a solid line to us and a dotted line to the chief auditor. Just like every other committee has a solid line, the school board appointed committees have a solid line to us. So it would still have a solid line, and you'd have the dotted line to the chief auditor. Just, otherwise,
Okay.
we have to change page 1.
All right, that'll be my motion. Let's get through this.
Accept that? Yes, and Ms. Korn agrees to accept that change to the motion. Audience input on that motion. Colleague input on that motion. All in favor of the motion to have the audit committee dotted line to the chief auditor's solid line to the school board on page 9 of the organizational chart indicate by saying aye. Aye. All those opposed say no. Okay, so that motion passes. Ms. Good, was that the extent of your comments?
I think, hold on one second. Yes, everything else sounds fine.
Thank you. Ms. Korn?
Thank you. I know Ms. Bartleman referenced there being, that we have some, or there were some questions regarding some specific employees that you are aware of that are not going to be with us. They were not renewed. And I think there was, and Mr. Runcie said there are some that are not renewed, but the positions still exist to be filled. My takeaway from Ms. Bartleman's comments, which I may have misconstrued, so I just want to make sure, there is a significant difference between not renewing an individual and having a position open over eliminating the position and the individual losing their job for that reason. Because that means we still need the function, we just aren't renewing the individual. So I know that there was a request to send us the information about those positions. Could you just make sure that you designate the difference? If someone was not renewed but the position remains active and therefore needs to be filled, if you can just make sure that you identify the difference between those where a position was actually eliminated and someone lost their job and someone who's not being renewed but the position will remain active. Okay, and that was, the you was referring to Mr. Mokrin as I'm looking at him. So questions, page 10. And this actually goes to the CC9 item, so I don't want to speak about it at length, but this is an individual. I know that there are a few where we go from manager to director. In this case, we're going from director to manager. When I looked at the job description, it looks like there are some significant changes. And so I guess what I'm trying to figure out without going into the CC9 item is an overall understanding as to why we think this position is no longer needed at the director level. As I read the job description, there are certain things that they used to be ultimately responsible for, and now the individual is just managing things rather than being directly responsible for the task itself. Now they seem to be working collaboratively or advising rather than outright being responsible for tasks. And so I guess what I'm wondering is, do we believe that to be the role in general? I'm on page 11, no, I'm sorry, I'm on page 10, far right, director to manager, business process and performance improvement. And they seem to now be going directly to, they report directly to our chief facilities officer. Anyone? I don't know who made the recommendation to ask the question.
Yeah, so we'll have, Ms. May came up, but I think that was just an alignment piece.
I believe Ms. May is coming up. Chief May, Dr. Mary Ann May, all of those things.
Dr. Mary Ann May, task assigned Chief Facilities Officer. We were trying to realign this position to work more effectively in the facilities division. And it does report directly to the Chief Facilities Officer as it has in the past.
So I thought, Mr. Runcie, we weren't making any significant changes here because we don't have leadership to then, because this job description, and again, I don't want to jump to that, but if you look at the job description, the role is quite different. They will do many of the same tasks, but clearly they are stepping down from a director position to a manager position. And so I guess it seems to me more as if it's the individual who's filling the position that we're making this change to, rather than a realignment of how we feel this job should be held in this department. So I was just trying to get some clarity.
So let me, go ahead. Did you have any? Sorry.
Go ahead.
So I guess given the fact that, we intend to fill this as urgently as possible.
It's filled. That's
No,
why.
I'm talking about the chief facility.
Oh, I'm sorry.
Yes,
Thank you.
sorry. I need to clarify. The chief facilities officer, we certainly could just wait until that time to make any adjustments, again, which I think is appropriate. I don't think there's unless there's a really strong and urgent rationale of why we need to change it, I'm not pressed to make that change today unless staff has.
This person has no direct reports either. So this was a standalone
Right, because they didn't have
position.
anybody reporting to them. But-
So, and I'm not saying
yeah.
I don't agree with it, I just am trying to understand it. We originally saw this as someone who should be at a director, and when you look at their job description as it is today, without us agreeing to CC9, it is definitely, to me, it seems to be a director's position. They are very autonomous. They have a lot of roles in which they are very independent, and they do go directly to the facilities officer. So I understood that as a director. If we accept the CC9 changes, and again, that's why I'm having a little difficulty saying yes, not questioning this position here without speaking more directly to CC9, because their role does change significantly, and I'm trying to understand them now being a manager, directly reporting to the chief facilities officer, and why someone else is gonna have to take on some of the roles that this change in job description is giving up. So I'm okay to step away from the conversation here. The only problem is if we do have the collective conversation, we're gonna have to reopen this, because I think we may need to go back to the director position if we don't fully, if we don't agree on the CC9, and I just having a hard time understanding the CC9 as it was brought forward.
So I'd request the board to make a motion to keep that one as is.
As a director.
Right.
Okay. So, and I guess we can always go vice versa, right? We can always, if we like CC9 and somebody, I was just, I guess, waiting for someone from staff to explain why we've done such a significant job description change for this position, which would then explain why we would keep this and manage as a manager as it's being recommended. So I'm not saying how it should be done. I don't know. I'm just trying to understand a very specific rationale to it, and I couldn't figure it out when I looked at the job description. And I'm not getting a lot of help. So, Mr. Runcie, this is your organizational chart bringing forward. I do not believe as a board member that I don't want to direct a change, so I'm asking you to make.
Yeah, no,
I believe that Chief May is looking to
I'm
say
sorry, I
something.
can't see Chief May, so I couldn't tell, that she was looking to speak.
So the other thing, when we were evaluating the positions within the facilities department, is we now have a full SIMS team that provides a tremendous amount of support throughout the district, which is going to reduce some of the need within the facilities division just to have one person. But we still needed some of that hands-on from a person to continue to help us in facilities with streamlining operations, but we didn't feel we needed it at the director level. We felt pretty confident in making that into a manager position and also having support from the SIMS team.
Judy and I.
So with that said, Mr. Woods, if I could, through Mr. Runcie in the chair, Mr. Woods, that would mean now someone in your department will need to take on some of the leadership that goes along with this job, because this job, again, was fairly autonomous and had very specific things they were required and responsible to do that they are now doing collectively, or they're doing it only in a advising level, right? So help me, because this is obviously now tiptoeing into your area.
Yeah, well, thank you for the question, and I want to be crystal clear. No one from SIM will be taking on the functions of this particular area. What SIM's expertise does is we offer value-added services and templates and supports across the district, and we will do that for this department as a whole. So as we continue to engage with the different departments, there will be opportunities for her to leverage some of the SIMS resources, but it's as a service that we provide.
Okay.
Did that answer your question?
So to me, then, it sounds like what the department is trying to do, this department, meaning facilities, is trying to do, which I fully appreciate, right? We don't want to have someone at a director level if some of those things are being done through the SIMS department, even though they may not be taking away. So, Mr. Runcie, again,
Yes.
I'm going to look to you, and if you want to give this some thought before you make a recommendation. I was just trying to grasp, when we look at that job description, I'm going to need some answers as to who is going to take on some of these responsibilities, because the jobs themselves, and as we all read them together, we'll see it, the jobs are still being done. They're being managed very differently. So if this person is not going to be taking that strong leadership and is still being autonomous, I need to understand how that is going to play out day in and day out. So that's what I need to understand. I don't need a director there. I don't really care what level. I just want to know how it's actually effectively going to happen. So if maybe we need to wait one more year to do that, I'm okay with that. Or if you think right now's the time, fantastic.
I'd rather just wait until we bring on a chief facilities person that we can talk this through. And look, if we need to change this sometime during the course of the year, we can always do that. We don't have to wait till, an entire year. We've made recommendations to the board throughout the year relative to any organizational chart adjustments. So I would propose that we just leave that the way it is for now and focus our efforts on staffing the chief facilities officer position.
Okay, so with that said, Ms. Myrick, I'm sorry to interrupt you during your conversation. Ms. Myrick? Sorry.
I'm sorry.
That's okay. So I'm not a fan as a board member of changing something on the org chart that is Mr. Runcie's org chart. At the same time, I believe that once he gives it to the board, it's now the board's org chart. So help me understand, if he's recommending it stay where it is, and I don't want to look on the record like I'm the one changing his org chart directly, how do we manage that?
I think that a board member makes a motion that, Mr. Runcie, I mean, it's in your hands now, that Mr. Runcie has requested that this position remain a director and be reevaluated once a chief of facilities comes in, or you don't even have to put the last part in. But that Mr. Runcie has requested that this position remain as a director for the time being.
So I'm going to make a motion that per Mr. Runcie's specific request, the position of business process and performance improvement remain as a director rather than a manager.
It has been moved. Is there a second?
Okay. Going to page 13. So on page 13, question. We have the director for classroom technology and desktop support services. Sounds like a very, very important job. Why are we eliminating the customer support service, which to me seems like, under that role, seems like really a very direct classroom level support position? And maybe you have people under the line who are doing that, and that's great. I just wanted to understand.
Good afternoon. Matthew Bradford, Task Assigned Chief Information Officer. We found that we could spread out the support services as far as the responsibilities are concerned with team members within IT. And as far as a mandate or the request for us to save money, we chose to eliminate the position.
Okay, so I appreciate that. None of these job descriptions around in this area have changed to take on these specific responsibilities that would have been in this job description. So are they, I guess what I'm asking is, how do we effectively ensure that all of these job responsibilities are going to be absorbed by others who currently have positions? Have we done a thorough look to make sure that we can cover that in other job descriptions and that we're not going to have a job study come back to us now for 2 or 3 other jobs because they've assumed these responsibilities?
Of course, we don't foresee that being the case.
Okay. Page 19, last question, by the way, so that you can all prepare for whoever's next. Going to our student transportation services. In our student transportation services, we're going from a manager to a director. And just based on title and what I was able to read in the, based on job description, how is this broken up where above the line, of course I know there's a lot below the line, but so you have 4 people reporting to a director who reports to the executive director, but then you have 4 others who are managers who are reporting directly to an executive director without a director. So help me understand the balance as to why half of the department, again, above the line, is reporting to a director and the other half is still going to an executive director.
So the short answer is we're actually starting or trying to create some career pathing.
Okay.
So what we identified during their last executive director transition is there was such a gap between the managers and the ED that it was hard to find the type of skill set that we needed to move up. So we're creating some career paths as part of our succession planning. The way that the organization is separated now is you kind of have the terminal and the transportation side, and then you have the operation side. So that's the distinction between the reporting. The managers are on the operation side, and then you have the director who's responsible for the transportation and terminal side of the business.
And so we feel with that purpose, right, of being able to do that job ladder, that the terminal side is what gives us the best opportunity to give someone the experience that they would potentially not walk into, but be applicable for an executive director side rather than the operations side.
So that's a great question. And I will tell you that both Pat Snell and Mr. John Lyles actually has a combination of both of those sides. So by creating this director position, managers from the operations side of the house can move over into that director position as well to get the transportation side experience. So
Okay.
it does create an opportunity to have more breadth before you get to that executive director position.
Okay, and so to Mr. Runcie, I fully appreciate our intent, and I actually like that this is the first time the district has really talked about this in building our own within in this way. I just want to make sure that as we're adding positions to do that, that we're very thoughtful about ensuring that the positions we add are specific to being able to go up that ladder, that we're really making the next rung in the ladder that gets you all the way up without then having a missing piece and you're only halfway connected to the ladder and the other half doesn't give you the full step. Does that make sense? Okay. Those were that was my feedback. Thank you.
Thank you, Ms. Korn. I just have a couple of quick comments. I can find where I wrote them. So just to follow up, I don't need a lot of conversation. I just need to ask us a very simple question. I need clarification. Are we eliminating any boxes in this org chart that will eliminate people from the organization? No. Can you say that again, please, so I can hear you?
No.
Okay, thank you. And then something that I'm going to talk about in the E1 and 2 items, but I just want to make reference to it on page 19 with regard to Officer of Economic Development and Diversity and Compliance, and then Manager of Diversity and Outreach Program. So last meeting or the meeting before, I asked some questions with regard to the numbers of certificates that had been processed, and it was difficult, the way that it was reported, to make sense of where we were, and I asked Mr. Moquin this morning to pull the report that was provided at the meeting at this juncture last year. Unfortunately, last year on the meeting on 6/12, the report was through May 14th, and the report that's given to us today is through April 30th. So once again, it's not easy for me to make the comparison. My comment is this. I want to make sure that whatever we're doing with this, that we are ensuring that we are increasing our number of certifications through our efforts, because here we're adding an additional person. And then I also want to make sure that it's very closely monitored through your department, Mr. Woods, and I guess it's direct report to you with regard to adherence to policy.
And before Mr. Woods mentions that, I also want to mention that it's not just, increasing the number of certifications, but it's the level of participation that they'll have, because you're going to have certified folks that don't properly position themselves to participate in the opportunities that we have. So through these resources, we expect to help build that capacity for greater participation.
Understood. And so just as an example, I'll tell you, at the meeting for last year, the number of approved recertifications was 95. This year it's 95. This year it's 62. Last year it was 95. So yes, there is work to be done on both sides, but we have to be able to do both things, and that's why I'm asking the question.
So without getting too far ahead of ourselves with E2, I will say that we continue to make our efforts in the certification piece. Also, we continue to adhere to the policy. One of the items in the policy talks about the significant business presence in the Tri-County. Historically, we haven't had that. So as some of these recertifications are coming up, we're identifying vendors that don't have a significant presence in the Tri-County. And that's why you don't see the number of recertifications as high as they were in previous years.
Okay.
And that's something we want to talk about when we bring the policy changes back in a few months.
Okay.
Because it's
Thank you.
you can see the impact that it's having.
Thank you. That is, oops, sorry, that was the extent of my comments. Any additional comments from my colleagues? Ms. Myrick?
Yes, if I may. If you'll look at page 3, which is the general counsel's page. We never had a full page to ourselves before. So as I've been meeting with you all, as I've talked with most of you, but at the Legal Services Committee meeting, which was about a month ago, that Ms. Murray, Ms. Korn, and Ms. Aladeff are on the Legal Services Committee. I requested another attorney that would increase the Assistant General Counsel box to 5, where it says 4. And we had a good discussion regarding the need to make sure that if we do that, because of the finances of the district, that we could do it at a cost-neutral basis. And looking at my report, you'll see that we're going to be spending more money this year than we have previously out of our budget for outside counsel. And I believe that we will save the money if we hire a new attorney. We will save more than what we have spent as an outside counsel. So I did not request the superintendent or Ms. Marte to put add this number add another attorney to this box until I talked to you, because I report directly to you, and I didn't think that was my prerogative to put more attorneys on here or the superintendent's thing. So I did not do that. But I would like to request that we are allowed to hire another Assistant General Counsel who will work in the areas, kind of more of a generalist, will work in the employment area where there will be significant savings, will work on contracts, which I think we've done a good job this past year. Be honest with you, I have not gotten one complaint all year long from staff that we are behind with our contracts, which has been great. I think part of that has to do with one of our new staff members, and of course Kathleen Jock Adams, who works continuously. And the person will also work with contracts, and we'll begin to learn a little bit more about school operations and school calls and the issues that we deal with principals on a daily basis. So that's how I would like to use them. So obviously there will need to be a motion from anybody on the dais if you agree.
Thank you. Ms. Bartleman?
I'll motion to add the attorney position. I think it's really important that on all levels we're complying with the law and have that set of eyes. And you work for us, and your job is to protect us as a board from litigation, bid protests, all of those things. And if you're telling me you need another position, I will motion for that other position. Make a motion for it.
It has been moved by Ms. Bartleman and seconded by Ms. Good on page 3 of the organizational chart, to change under the center box Assistant General Counsel the number from 4 to 5. Audience input on that motion? Seeing none, colleague input on the motion. All those in favor, I'm sorry, yes, Ms. Good. All those in favor of the motion indicate by saying aye.
Aye.
All those opposed say no.
No.
Okay, that, I-1 passes.
No,
I mean,
that
I'm
was,
sorry, the motion, I'm sorry. I was so eager to be done. Yes, Ms. Levinson?
Yes, I wanted to discuss page 14 further. which I had mentioned at the beginning. I wanted to get the superintendent's thoughts and my colleagues' thoughts. I am not going to be adding another director at $150,000 as a new position to the org chart. I know this is Mr. Runcie's org chart. This is a position that has been brought to us before as a board. We have said that we were not doing it, and it's back again. And school choice and parental options are part of portfolio services. That's what portfolio services is all about. I do not believe we need a director in that department. Yeah, it's a brand-new position, a director. Well, there's two new ones. One's a slight upgrade of a position, it says. Right. So I don't really get involved normally in the nitty-gritty of people's departments, as long as they're keeping them fairly cost neutral. This is doing that, but I've said this many times before that I'm not looking to add director positions to our organization unless they're essential. Especially when we've discussed it before.
I don't know if Mr. Runcie or staff has a comment.
Leslie Brown, Chief Portfolio Services Officer. Thank you for the question. Ms. Levinson, I believe that we have shifted as an organization in some great work as directed by the board, significantly in the area of choice as compared with the area of school boundaries and demographics. The choice area has grown significantly over the past year. In our enrollment study, we have found that we need additional support in shifting the processes and systems that we use for choice, which I actually wrote into an MSAP grant for $15 million, that we would be able to afford a brand new turnkey choice process that will come back to the board in order for us to be able to have real-time data on enrollment from every single school across this district so that we can continue to place children within a 24 to 48-hour period over weeks instead of having to wait for systems to catch up and have data transported between different systems across our area to get it into one system with a director of choice and parental options. The opportunity to be able to perform that duty requires a completely different function than the director that we currently have in demographic and boundaries. The demographic and boundaries position is an analytical position which requires significant research and the opportunity to do analysis and making recommendations for changes in uses of space, facilities, and opportunities for using space more efficiently. The director for choice and parental options is more of a technical position, which requires information systems, database systems backups, and the ability to connect data real time rather than waiting. And also the opportunity to take those data systems and make them opportunities for parents to be able to have options across our district in every seat that becomes available when it becomes available. We believe that it is time now to split these job functions. If you would notice that the current job description for demographic and student assignments has never actually included choice. We added that layer of duty onto that team in order to be able to build choice. Now that we are ready to take off to the next level in new data systems and connecting data behind the wall, we believe it's time to separate it to continue the great work that we've been able to do in real-time data information systems. That's our goal.
Okay, I will just say that it's wonderful that we're going to have data systems that are better. We should have data systems that are better. Our demographers work with data systems all the time when they've done boundaries and many other things. I still do not understand why you need a director at that level. It has been put in the same area, and you need people to do more of the work, not another director.
I know you have comments. Mr. Runcie, did you want to
Yeah, no,
respond?
my understanding, this director position will absolutely be doing the work. This is a very hands-on role, but you need someone with a skill level and expertise to be able to do this. Given what we know is happening with student populations and demographics, we have to be as efficient and effective as possible in this area to be able to retain as many students as we possibly can through innovative offerings that we continue to provide in the district. So I felt for us to be competitive in the marketplace, be able to operate and do this work in a more efficient and timely manner. You know, if we can retain even a single classroom full of students, this would pay for itself.
The systems make it so we're able to do that. Having another person making a very large salary, I am worried about paying our employees in this district and not increasing at that level. And so I understand the explanation. We all agree with it. We've all been working on school choice parental options. That's what we do every year. But having another level at that having another person at that position, I just can't support another $150,000 position. I will be making a motion after, or I'll make a motion now.
I have two board members waiting to make comments, so.
Okay, well, it would be on this, wouldn't it? On whatever motion
Yes,
I'm
it
making.
would be.
Correct?
Motion?
There's going to be discussion
go ahead.
on it.
Okay.
I'd like to make a motion that that new director position be removed from the org chart.
Second.
It has been moved and seconded that the director position for school choice and parental options on page 14 of the org chart be removed. I have Ms. Good and then Ms. Korn.
Can I be on that motion then?
Yes, I can.
Could be on the page? Nope.
Um,
I was trying to throw all my comments in. So thank you, Ms. Rich Levinson, for your comments. So how many individuals would report to the Director of School Choice and Parental Options?
The Director for School Choice and Parental Options would have one analyst working with them, as well as a systems analyst that helps run the data, and four what we call our customer service experts. And then we have between 3 and 4 temporary staff members that come in and out during the time when we have heavy phone call service.
So those positions, not the temporary ones, but the analysts and the other ones you mentioned, they're below the line?
Yes, they are. They're 24. I think one is a 19 and one is a 24. The other one is the evaluation administrator. That is the person that works with our class size reduction. And as we place students in choice, we need to monitor what's happening with class size. So we aligned that person underneath the Director of School Choice and Parental Programs.
So did you consider in this area here within your department the opportunity of having positions lower than a director level in some other way of configuring it? Or was the decision made that it needed to be at a director level?
The skill set that is required for this is on the technical side, not unfamiliar or unsimilar to the work that is done in IT, where directors have engineering, computer science degrees, where this particular person would be working not only with a call center philosophy and working with phone systems, as well as data systems that would require a programming information systems background.
Okay, Madam Chair, I need guidance, because before I can vote on this, I do need to ask a question on the same page in that same department about another position.
Well, if it's relative to the ability to vote on the motion, I think you can ask the question.
I just wanted to clarify. So with regard to the property coordinator, you're asking for another position for that?
No, ma'am, that is an upgrade. It's listed as a new position because it's under the chart position. Currently, it is...
It had a 1, and I guess now it's a 2?
Yes, because we took a position that's below the chart, that's a 24, and we asked for it to be upgraded to a 26.
Okay. And that position oversees what?
The current position is, I'm sorry, let me make sure that I have the language right here in front of me. The current position is a property analyst, and the request is to upgrade the position to a property coordinator. A property analyst is more of a data position where they are responsible for keeping all of the lease, property information, real estate information collected and usable in the right formats.
Mm-hmm.
The property coordinator position is actually an evaluative type position. It actually chairs committees, works to include site administrators, coordinates between schools and governmental agencies, and also does legal preparation as well as review across divisional work within the real estate department. So basically, it's going from an analyst that keeps and provides data to different parts of the organization to a coordinator position that's evaluating requests for work with real estate information.
So I just, in considering opportunities, what I guess I'm a little concerned about, and I didn't have an opportunity at the workshop to mention it, is the fact that, I mean, we're not in the acquisition and even leasing anymore. So, you know, we've turned, our tide has turned a little bit, and we're now more focused on, you know, selling some of the parcels, which we don't have that many to sell. So, you know, we have a director for facility planning and real estate, we have a coordinator for facility planning and educational, we have a senior program property coordinator, we have another property coordinator, and then we have an analyst, and then on the growth management side, you know, you have a planner, a couple of planners to deal with it. And I don't see where the need exists to upgrade any positions within that area. I'm struggling.
So if I may, I think some of the work that has been going on, often it runs sort of parallel to the work that we do directly with the board. One of the big requests that the board recently asked us to do is to go in and take a look at all of the property across the district and find components within that property that we could separate out and look to turn it into assets for the district. We are getting close to being able to do that work and be able to analyze all of our assets across the district and portion off sections of property that could create a revenue or a different type of asset for the company.
And
The
Ms.
other,
Bar-
I'm sorry.
I know exactly what you're talking about, and I know your department works very hard, but I do see that this area of focus for this district has changed tremendously in the last 10 years. So maybe there's opportunities for, revamping what you have. But to have a director, coordinator, a couple of planners are all pay grades 27, and then you have a senior property coordinator at pay grade C, and then to upgrade another position, I'm having difficulty supporting that action. It's my opinion. Now, in regard to school choice and parental options, to me, that is something that we're pushing more and more. So, but at the same time, I don't think everybody needs to be a director either. And so, this district is very heavy on the top level management, and I do agree. I'm not saying that you would not need someone to, further focus on that area in particular, but at that high level, I think it's also, it's not necessary. So, I think that there's opportunities within that general area for maybe consideration on doing it a little differently. Just because, I'm just not sure that that's what we need. I know that's what you're recommending, and I know that's what the superintendent's recommending, but I will definitely not be able to support the upgrade of the property coordinator, and I needed to make that comment before we take action on this one. I'll keep them separate that way in case somebody's, so that's the extent of my comment.
Thank you. Ms. Korn?
Thank you. So, question, was it considered that this would be at a manager's level rather than a director, or was a director really the only level in which it was considered?
So I appreciate the question, Mrs. Korn. In the bench that we have in this particular work, we have never had a manager-type position. If that is something that the board would like us to consider, it's certainly something that we could take a look at. We have directors, and then we have reports to directors, and we, again, just historically, a manager position has not been a part of this org unit.
I noticed that when I was looking. I see you have one assistant director.
Yes.
So you had referenced a $15 million grant.
Yes, ma'am.
When was that grant done?
The grant was done a year ago. It's the Magnet Schools Assistance Program Grant. As a part of that grant, we did request the opportunity to consider and the funding for a turnkey choice application process. In the work that we've done with the board has asked us to take a look at waitlist numbers rather than waitlist pools, opportunities to look at per seats per school by grade level. In the homegrown system that we use right now, that IT helps support us on, we do not have the capability to be able to do that.
So I appreciate when we constantly have the conversation about our traditional schools as well as our charter schools. We talk about how much choice we offer and how that really is a goal for this district. And we've been very effective when you look at all of the choice that we have. And I think my sense from the board is we're constantly looking to be able to provide more of that whenever possible. So I can appreciate wanting to have leadership in this area. Someone new at the director level does seem to be a high level to just now introduce the tasks in which this person's going to be taking on. Who's doing this work now?
Currently, it is split between a TSP position as well as the director position. And then there is a TSP that also helps support the other TSP. So there is no specific leadership level position other than the Director of Demographic and Student Assignments that understands the nuances of the programming needed.
And what value add is there to the district? What are we as a district going to be offering when this individual, if they were to come in, what are we as a district going to experience differently for our families and our students?
So thank you for that question. I think it's an important one. One of the things that we do see is the opportunity to be able to communicate directly with parents based on their choices as soon as the seat becomes available. Right now, we have to create windows because we don't have a system that's reading how many students have withdrawn and entered. Sometimes we'll hear a lot about students that enter the school, but we're not hearing about the numbers that withdraw. This type of a process would be able to get us closer, not a real time, minute by minute, but a closer opportunity for parents to be able to see their responses to their requests to move. We also would be able to use a similar system to be able to do a withdrawal survey immediately as a parent withdraws, be able to forward out to them, trying to find some of the perhaps more systems reasons, not information systems reasons, but systems reasons as to why a parent might be looking for choice or leaving our district altogether. So we believe that by having a person that this is their function, their expertise, and they have the programming and the systems information background to be able to do this work, we would be able to see a much more direct link to the parents and a much more direct link to each of the individual schools based on their needs for students by grade level, which we cannot do right now. We can only do it by capacity of the whole school. And so that parents and schools will be able to see those places filled in a more efficient and timely manner for parents to make good decisions.
Okay, so, well, that feedback's very helpful, because obviously that makes a big impact for our families, to be able to say, there is room for a child at the first grade level. Overall, looking at it, we may not have otherwise been able to identify that.
Correct.
So this is what I would ask, and I think I'm hearing this from my colleagues, if I'm hearing correctly, that school choice is important, that we want to be able to support these initiatives. The question is really, does it need to be a director to do those types? Because normally that kind of impact is not something a director would be hands-on, day in and day out, responsible for in other departments. And I understand how your department is set up, but I think, especially with this, grant that maybe is obviously well aligned with this, maybe, Mr. Runcie, we need to think outside the box a little bit. And if we need the additional support and we do want to continue to go down the path of opening up more and more direct school choice options. And when I say that, we went from one window of time to 2 windows of time. Now we're going to be able to get potentially within days or weeks, we're going to be able to be very specific and targeted in terms of where are their actual seats rather in a class rather than in a school. Those are worthwhile to pursue. I can appreciate we don't have the staff right now to be able to do that with the expertise and potentially with the bandwidth. But a director level to do that seems like it's far reaching at that level of management. So my question is, would it be something that you would consider? And I think as a board, I would be happy if we didn't do it today. Mm-hmm. I would be happy for you to think with staff a little bit harder about how else you might be able to bring this forward and maybe bring a position that's not at the director level. You have brought other positions to us mid-year and asked us to consider a change on the org chart. I would ask that you consider that, unless you think the only way this can be effective is as a director.
So again, the director position is really reaching out and touching many different parts of our organization. It's not just a manager of people, and again, I think it is a semantics piece. If the board is not comfortable with a director level, I do have an assistant director in my org unit, and if the board was willing for us to take a look at an assistant director, the opportunity to work with other directors across the organization as well as principals, that's the level of this position. If the board is not comfortable with that for budgeting reasons or just a level of a hierarchy reason, we can certainly take a look at an assistant director. I would prefer not to wait till mid-year to do this because the work needs to be done now. And it is a heavier workload than a TSP. A TSP should not be expected to do this kind of level work at the level of pay, at the expertise level of a TSP, when being asked to work with other directors at the same level, doing really, really heavy lifts for this organization. So maybe something in between.
Ms. Brinkworth, can I just expand on one other?
Sure.
If there was an assistant director, and Mr. Runcie, again, this is your org chart, typically an assistant director reports to a director. Mm-hmm. So it wouldn't make sense for them to report directly to the chief. And so I guess we need you to rethink, and maybe it's one meeting from now. It doesn't have to be mid-year. I guess I said that. And,
I appreciate that.
So, but I'd rather it not be something off the cuff done here in terms of how that's handled, and potentially that will change the job description. But I want to support having more resources in this area. But I hear my colleagues in terms of having another director level here in this place where we are on a financial, looking at it financially. So
I have Ms. Levinson followed by Ms. Good.
Actually, Ms. Good had made some interesting points that made me think harder about this. When you look at both sides of where this position is falling, you have the facility planning and the real estate, which has completely changed over the years, as she pointed out. And you have demographics and school boundaries, which are almost non-existent school boundaries anymore. Things have changed. With the advent of charter schools, we don't do boundaries. We don't move kids around like that anymore. So my problem, especially with this division, is times have changed. You have to realign. It doesn't mean that you add new positions because of times have changed. It means you realign and you become more efficient and you focus on what's happening now, which is school choice and parental options. When these two others have changed drastically, you retarget the work to what the work should be. If we keep adding positions because new things are happening in education, we're adding all the time. We can't sustain that, and we can't keep doing that. You know, we tell our kids that the jobs that are going to be coming out don't exist today because they don't. The world changes. And so we have to adapt, and we have to become an organization that adapts and realigns to what our priorities are. And that is not by adding positions at this level. It's realigning.
So if I may, through the chair, I think it's an important point to understand that demographics has shifted significantly over the past 5 years. If we all understand that what demographics does is not just boundaries. The work that we have been doing with municipalities, with teaching our constituents about who the students are that we serve, as well as the information that we work on with community presentations and data systems to track down where students live, using investigators to go and find boundary jumpers so that we don't actually have to do boundary changes any longer because we are doing significant analysis about who is attending the schools. The schools have been very helpful in this process, and at the direction of the board, the demographics office has been working very, very closely with every single SMART project so that they can do white paper analysis of 5-year historical as well as 5-year projected trend analysis to see if we need to continue using the space that we have been using it, saving the district potential funds, or being able to realign SMART funds into new ways of using space. This is critical work not only for the SMART projects, but also for the cost of maintenance as we move forward in trying to continue to maintain old buildings that have been gestalted that may or may not be needed for a new building in the SMART program. So I think the team has evolved. I do not believe that they continue to do the same work as when we did boundary changes every single year or when new schools were opening. So I certainly appreciate that. I think that this team has been one of the most awesome teams of evolving over the past 5 years and shifting how that data on demographics specifically is used not only to make decisions, but also to educate on how we repurpose schools, which we have done through the work of that team, and connecting space needs with the communities and what opportunities might lie within those communities. So while I certainly appreciate and will do as board directed, I believe that the demographics team has actually evolved over the past few years.
Thank you, Ms. Brown. Ms. Levinson?
Yes. You know what? I really don't want to continue to go back and forth like this. I really, it's bothering me now at this extent to be going back and forth like this with staff. Demographics is one of the most awesome departments we have here. A lot of their work has changed to school choice and parental options. That's what they do. That's what they deal with every day. So you can talk about all the other things, but that department has evolved into doing that and needs to evolve more into doing that. And I've heard all the reasons. I've listened to all the reasons, but the reasons why organizations stay at the top of their game is because they evolve and they realign. They can't afford to keep adding and adding and adding. So I still contend that that is the way we need to go in this organization. And portfolio services, this is a main area in it. The acquisition of land, all of those areas that we dealt with in the past does not exist anymore. So we need to look at where we are now and make the proper changes.
Thank you, Ms. Levinson. Ms. Good?
So just very quick, so I understand, so you currently have one property coordinator,
Yes.
and then the other one is under the
Analyst.
line?
Yes.
Okay. So the N just applies to the one that you're upgrading?
Correct.
Okay, just wanted to understand that. So, Ms. Myrick, what options do we have as a board if we can approve it, we can, we can pull a particular page out and defer it? What are my options?
Well, your options are to do what we've done for these other motions and to make a motion to change something if you want to do that. You could eliminate the position under the caveat that giving the superintendent the authority to bring it back, later this month or later in the summer to relook at what you want to do with that department.
So we can move to take a particular page and table it to a future meeting to allow the superintendent an opportunity to review and provide revisions if he feels warranted, and then at that time, I mean, he may decide to leave it the way it is, but at that time, we could vote it up or vote it down.
You could, yes.
Okay. So I'll just say, Mr. Runcie, that I do have concerns with this page. I think that there is great opportunity here to reanalyze the structure of the department and the functions within, the various areas. And I'll say this. I know there was a comment made that the position needs to be a certain level to deal with certain individuals in the district. I think that I don't agree respectfully with that. The coordinator of JROTC and military programs, is that Colonel Green?
Yes, it is.
Okay. That's a coordinator position level C, and that individual deals with everybody, inside and outside the district. I just think there's great opportunity here for, I think, reanalyzing this entire page, and I think if the individual is a capable professional individual, then they're able to work across lines of different levels of authority. And so I'll leave it. I know Ms. Levinson brought some concerns. I'll leave it to her if she's going to make any motions, but I do not feel comfortable approving this particular page here today. I don't know if Mr. Runcie has any comments.
Yeah, so, through the chair, in light of the conversation here today, and I think it's been a good conversation, I'll sit down with Ms. Brown. I think, I'm already thinking about some alternatives in which we can realign the resources, given the focus and how that's changed over the years. So, I'm open to coming back to the board. If we do pull this page, it would be my understanding that the current structure is the one that would stay in place.
So, Ms. Brinkworth, according to what Mr. Runcie has said, I would agree to change my motion to pull the page and let the superintendent review page 15. 14. No, 14.
Can you remind me who had the original
I
second?
did.
Mrs. Alhadeff?
I'll remove my second.
You can second her current motion if you'd like.
Yes, I second.
Okay. So we have a new motion on the floor to pull page 14 from the organizational chart for further consideration by the superintendent and staff to bring back at a later date. Is there any audience input on that motion? Oh, my colleague is asking whether or not we need to give a date. Or Mr. Runcie, do you want to bring it back on?
The next
Is it the
board meeting.
25th?
Yes.
Okay, bring back page 14 of the organizational chart on June 25th. Is there any audience input on the motion? Any colleague input on the motion? All in favor of the motion indicate by saying aye.
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 Those opposed say.
I just got on the phone, Ms. Brinkworth.
Thank you, Ms. Rupert. Let the record reflect that Ms. Rupert was on the line. All those opposed, say aye. Okay, the motion passes unanimously. Now we're back to the main item as amended. Is there any additional comment from my colleagues? Oh, I should ask, is there any audience input on the item as amended? Any additional comment from my colleagues on the item as amended? I'm sorry, Ms. Marte has a comment.
Me too, Ms. Brinkworth.
Okay. Okay, do you want Ms. Rupert to speak before you say what you need to say, or?
I just want to adjust the savings so that the item is voted is completely correct, and it's a small adjustment, but I want to make sure that.
Okay.
No, the net of that page is $6,833 because of the number of positions given below the line, but it is a change from the $340,000. I just want to be correct.
But you also have to consider the additional Assistant General Counsel position too. Ms.
Yes,
Marte.
there were other amendments.
That was cost neutral. That's what the council said, because she won't have to hire as much outside counsel. You said cost neutral.
Cost neutral in the total overall budget, not
Yes.
not in personnel.
That's
Okay.
Okay. Ms. Rupert?
Have we discussed the whole org chart? Have we done every page?
This is the opportunity to discuss the whole org chart for the final
Okay.
time, as amended.
I'm just catching up here. I don't know, was there any discussion on page 19?
We did that.
Yes, do you have additional comments on page 19?
Yes, I do. What I'm trying to say, look, I'm going to pull off the road here. I actually am not going to be able to support the position of officer. I think it would be a terrific idea as a manager position, kind of next to the other manager on the left part of the page, if I'm thinking about where it is, because I can't look down. It must, on the same conversation that we just had by my colleagues. So I think there's a little bit more thought can go into this, and that we don't need to jump and make a giant change, that a change, and let's see how that does. 6 months, we can certainly upgrade it. Whatever, I've missed the part of the conversation, so for me, that's my comment for that page.
Okay, Mrs. Alhadeff?
Can I separate the page 9 out from the vote?
Yes, when we get to that. Did anyone have a comment yes, Ms. Good?
Yes, thank you, Madam Chair. I am supportive of this position of Officer of Economic Development and Diversity Compliance at this level. I think it sends a message that this is a priority for our district. And certainly, as it involves a lot of what we're doing with regard to our procurement and our bidding process, and really the need for our district to ensure that we have, minority participation in what we're doing. So I think that there's value in this position being at the level the same as the other director positions within this section of our organization, and I support it.
Thank you. Any additional comments? Ms. Rupert, do you have additional comments?
No, those were the 2 pages, the one that I came in on at the end, and then this one.
Okay, Mr. Runcie?
No, I was just going to echo that the officer level is consistent with what we found, in other districts. In fact, in some districts, our neighboring district to the south, it's even higher level position than that. It's like a chief level position. It reports to the superintendent. We already have a manager in there. We're already doing that. We're trying to elevate this to a very different level to, again, advance the work that we're doing in this district.
Thank you, Mr. Runcie. Mrs. Alhadeff?
Can we separate page 9 out from the vote?
Mrs. Alhadeff has made a motion to separate page 9 from the vote. Is there a second? To
I'll
vote
second it for.
Seconded by Ms. Rich Levinson. Audience input on separating page 9. Colleague input on separating page 9. Yes, Ms. Korn.
So I'm concerned we're going to start separating pages not on the recommendation of Mr. Runcie, who's going to bring something back to us, but so that we can now individually say we like something or don't like something. So this is the auditor's page. So each time one of us doesn't like a specific position, we're going to separate each of those pages going forward so we can each vote down certain pages? Is that, I mean, that's what we're doing here. This will be a precedent, so going forward, each time someone doesn't like a specific recommendation, this is how then we're going to basically kind of get around accepting Mr. Runcie's organizational chart, and we're just going to start to piecemeal it. I can't support that.
Ms. Good?
Actually, I view it differently. I mean, I will say that each page reflects a different division with different individuals. I may be in full agreement with his entire organizational chart, but may have concerns with one particular department and how he is envisioning it. You know, I remember years ago when there was issues within the facilities area, I had concerns with it. I voiced my concerns then. So, you know, again, it is the superintendent's organizational chart, and there may be areas within his organization that I don't agree with how he is envisioning it. And so this is the only opportunity I have as a board member to voice my concern. I mean, we have all spent the last hour voicing concerns on individual pages. I might not agree with my colleague regarding the position of the auditor. I think she should be able to vote it up or down, and the majority of the board support whatever it is that's before us. But that can happen with any given department. And I think that, you know, unless there's some prohibition against it, Ms. Myrick, is there any prohibition in us doing that? I mean, we've just gone through the whole org chart and amended individual pages of departments. And we voted on them individually, of which some of us voted for it, some of us voted against it. So the opportunity to vote on each page separately, I guess, is the concern of my colleagues. So is there anything prohibiting us from doing that?
No, I mean, this is not a policy or a rule, so you can separate them and bring them back the way you want. I mean, I hear Mrs. Korn and her concerns, but there's certainly no legal reason why you can't do that.
And I'd like the same when the other chart comes back. I may agree with what comes before us, I may not. And I'd like the opportunity to be able to vote it up or down and allow the superintendent to provide recommendations, so.
Any additional comment from my colleagues with regard to the motion to separate? Did I already take audience input? I think I did. Okay. All in favor of separating page 9 indicate by saying aye.
Aye.
All those opposed say no.
No.
Ms. Rupert, are you on the line?
Yes, for me.
Thank you. So the motion passes to separate page 9. We're going to go ahead and take a vote on page 9. All those in favor of page 9 of the organizational chart indicate by saying aye. As amended, I'm sorry. As amended, indicate by saying aye.
Aye.
All those opposed say no.
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 Okay. You can do a roll call, please.
No.
No. That was weird that
Yes?
Yes.
Yes.
Ms. Rupert, if you could repeat your vote for page 9, please.
Mine's a no.
Thank you. She said no. Item passes. Thank you. And now to the organizational chart as amended without page 9, which we just voted on, and I'm sorry. We just passed one page, page number 9, and just refresh my memory. Is page 14 not part? It's been removed by this.
It's been removed.
Okay. Is there another question from one of my colleagues? So this is the organizational chart. Page 9 we voted on separately. Page 14 has been removed. Will be brought back to the 6/25 meeting for separate consideration. And this would be all of the other pages as amended. All those in favor indicate by saying aye.
Aye.
All those opposed say no.
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 Bartleman's a no.
Did you get that, official school board records? Two, Ms. Bartleman and Ms. Rupert?
Yeah, I said no.
Thank you. The item passes. Okay. So it has been indicated to me that we are well past our time for public speakers. And so we will take public speakers at this time. Let me make sure that I read what it says on here. Each speaker will be allowed 3 minutes. Speakers are reminded to demonstrate proper decorum, and school board members will not discuss or take action on any speaker comments. Any persons present who wish to speak and are not listed as speakers on the agenda may be heard at the conclusion of the listed speakers. Further, at the conclusion of public speakers, the chair will provide an opportunity for the superintendent or his cabinet at his discretion to provide comments regarding any subject matter or issues raised by public speakers. Additionally, the superintendent may have members of his staff speak to an individual public speaker in an effort to address his or her concerns and provide any follow-up to public speakers' concerns back to the board. I will call the first speaker, Mildred Martin. Mildred Martin. Terry Lopez Price.
Hello, my name is Terry Lopez Price, and I am the Vice President of the Broward Teachers Union, and I just wanted you to know I had an awesome day today at the Equity Conference put together by the Diversity Group. There's so much good work being done. I just want to say thank you, Mickey Pope. She gave an amazing speech today to all of the people that are involved in that work. We need to learn to understand one another, and it starts with educating people on our differences and how we can coordinate, collaborate, and meet each other where we need to meet each other. So it was a very nice day in and out there. One of the things that I wanted to say is that this work with equity is extremely important to me, and I sometimes don't understand the disconnect between the work that we're asking our educators to do for students in the classroom and what is happening, you know, with our teachers in some cases. So I was here earlier. President Fusco wasn't able to make it today for the speakers because there were 200 teachers who were non-renewed. And she was spending most of her day on the phone and texting and trying to save some jobs. These people will not have insurance. Many of them are AC and probationary teachers. And this has happened over and over again in our tenure in BTU leadership. We've spoken about it over and over again. I personally think that principal autonomy that allows these things to just occur without a whole lot of oversight is something that we need to look at. I do know that every year we send people to places like Chicago and Boston and Puerto Rico, even Spain, to recruit new teachers. And maybe some of these 200 were from those recruiting efforts. Nevertheless, they apparently didn't get the support that they needed, and they are not non-renewed. So we have a problem. We need to find the support that they need, and I certainly understand the conversations that President Fusco wanted me to relay the understanding and sensitivity to the administrators who need some kind of security in the amount of money that they're going to be making, but this is a security that all of us need. So we're asking you to please help, get to the bottom of it, find out what's going on, and why is it that Dade and Palm Beach can figure it out and we can't. Thank you.
Thank you. Roosevelt McCleary. Roosevelt McCleary. Heather Hall. Heather Hall. Trudy Germanovich. Trudy Germanovich. Jamie Boss. Jamie Boss. Allison Hankerson Harris. Allison Hankerson Harris. Kelly Brandenburg. Kelly Brandenburg. Ted Simonin.
Good evening, board members, ladies and gentlemen. I've been working with Florinata Elementary School, and they recommended that I come this evening to speak. My husband and I are in the process of adopting a child who has been in the foster care system for 7 years. He is 9 years old, and his name is Daniel. Daniel is currently living with us now, and we have been working with ChildNet. We are hoping to finalize the adoption and become his legal parents in September. Back in April, we began looking at elementary schools and felt as though Florinata Elementary School would be the best fit for our son. Not only is the school close to our home and on my way to work, it has excellent IEP services that we know would help Daniel cope with his past trauma. When we made this decision in April, we immediately scheduled a conference call with Daniel's educational coordinators at ChildNet and asked if they could please enroll him. And even though everyone on the team agreed that Florinata would be the best fit for Daniel, they were unwilling to complete the request because they wanted to make sure we would not change our minds about the adoption. It is now June 11th, and we have not changed our minds. We've attended an open house at Florinata on May 17th, and we're fortunate enough to meet Lauren Gordon. She is an educator at the school and would be working with Daniel on his IEP. She is familiar with the changes, with Daniel's challenges of dealing with his past trauma. She's worked with foster children, and she genuinely cared about our situation. We spent over 30 minutes talking with her in the hall. I emailed her after the open house to thank her for speaking with us. We've been in contact, and again, this reassured us that Florinata Elementary is the right school for Daniel, and I'm getting to the point now. With this in mind, we then scheduled another conference call with ChildNet and its team of educational coordinators and asked, can we please make it official and enroll Daniel into Florinata. At this point, Daniel was living with us permanently, so they decided to move forward with his enrollment. They felt that the best course of action would be to apply for the McKay Scholarship. They submitted an electronic application while we were on the phone, made a few phone calls, and we were told that he would be in on the spot. Great, perfect, everything was working out perfectly. Unfortunately, later that day, we learned that someone who had applied a few days earlier took the last spot, and Florinata is now full. And according to ChildNet, the only thing we can do is apply for reassignment on July 1st. If the school is not accepting applications for reassignment, they said they will assist with a hardship reassignment. However, someone also suggested I speak to the school board, and this is why I'm here today. I'm here to ask you to please enroll my 9-year-old son into Florinata Elementary so he can work with Lauren Gordon, develop an IEP, and maybe, just maybe, have a fighting chance at overcoming his traumatic past. So
Thank you.
that's
I'm
it.
sorry, could you state your name for the record?
My name is Ted Simonin.
Thank you. Mr. Runcie?
Yes, sir. Thank you for coming today. Appreciate your interest in enrolling, your child in one of our outstanding schools in Broward County. Ms. Brown will talk to you. We do have to adhere to our process because we have to ensure that we're consistent and fair with everyone we deal with, that we start making exceptions to that. I mean, our whole system and the integrity of it breaks down. But Ms. Brown will talk to you and let you know what options you still have. And Ms. Brown is in the back of the room there. Thank you so much for coming today.
Thank you.
Thank you.
Elijah Manley?
Good evening. Is the mic on? Okay. Good evening, and thank you all for allowing me to speak. First, I want to say congratulations to a wonderful school year. I first wanted to address the e-cigarettes. I think it's important to have this conversation. I did reach out to a few members. I think we need to take another look at that. I don't think we need to go down the penal route. I think we need to look at making sure that we have a mandatory education regarding substance abuse for all of our students, not just when they commit an offense, just year-round. Every student should get at least one course on substance abuse education in their high school career. That was something I didn't have. I also want to move to another issue, the 4,479 students that are homeless in Broward County. That number jumped dramatically. In 2017, that number was just over 2,000. It jumped over 50%. And I do think that a society that allows thousands of kids to go homeless and hungry is a society that has failed, or this generation has failed the world. I do want to thank Mrs. Korn for meeting with me twice about this issue. One of the things that we are working on was an app that would show the resources to every student on clinics, food banks, all the services that they can get. And a student from, I believe, South Broward High School actually developed this app within less than 2 days. I would like to show that to all of you so that you can see what an innovative student, decided to do that with hope in this situation, and to Dr. Osgood, who also worked with me on this issue. But we have to continue the dialogue because this is a very big issue, and those numbers are probably going to continue to jump, and they're probably higher than they are here. And I'm not going to stop coming here until we address this issue and make sure that we're addressing this issue every single day. On the other issues I think we should talk about, it is Pride Month, so I definitely think we should keep human trafficking awareness within our minds. This is something the Human Relations Committee has been working on. Keep talking about teacher pay. And I also want to respect that we continue to hold yourselves accountable. I do want to say that you all need to continue to have a relationship with the media as well, instead of, I see members going back and forth with the media. I used to do that too a lot, and I don't agree with everything the media does, but you guys, this is a public institution. I think it's best that you all maintain a relationship so that the public knows what you're doing, because sometimes we don't have a clue what you're doing. But please, please, please deal with the issue of student homelessness. I'll be in contact with all the officers again, hopefully, and we'll start working on something to solve this issue. Thank you.
Thank you, Mr. Manley. That concludes our public speakers for today. Mr. Moquin, what is your suggestion for where we should move next in the agenda?
I do believe there's an individual in the audience who had pulled I3. Maybe take I3 out of order and then go back to the CC job descriptions that coincide with the org chart.
Okay, thank you. May I have a motion and a second on item I3?
So moved.
Moved by Ms. Korn, second by Ms. Good. Audience input on I3. Come to the mic, please, and state your name for the record.
Good afternoon. Dagoberto Magana, math teacher. Yep. I want to know if you received, I sent three pieces of information, 3 letters. One was for Friday last week, and the other 2 was yesterday. And my surprise, yesterday when I called at 3 p.m., the previous letter was not received at Mr. Runzi's office. And in the past, I have a similar situation. I had a couple cases at SIU. In my first case, I make a letter of response to the allegations, and the letter never arrived on time, and it was missed. It was lost. And I got 5-day suspension for those allegations. By the way, those allegations are false. I never made those allegations. I just took the 5 days to avoid the situation because it was almost a year going on in this back and forth. I never had made those allegations. I'm an ethical, honest math teacher that I have been always working to make the students learn. I make learning required in my classes, and that's why I get in trouble with the students sometimes. Not all, some students that I like to do math to perfection. I like them to learn properly. That's what I've been doing for 33 years, 25 in Florida. And I've been teaching also 20 years as an adjunct professor in college. I've been teaching college classes. I love to do math. Math is my passion, and I like to do the best with my students. I want them to learn from me. I want them to do it right. My problem is some students, when they turn in incomplete or wrong work, and I tell them, listen, the work is wrong, you gotta go over and fix your problems, try to learn it right. The student refused to redo the work because they considered that they already did some work and they need some credit for that. When I said, no, you have to go over, review, and learn the content, they get upset with me. They have been in the office, and my administrators in the school, Miramar High School, have used some of those students that refuse to learn proper math and asked them to write statements against me, and it's been cumulative for the last 4 years. First case, I end up with 5 days suspension. I did not fight the days. I said I want this to be over and want to continue. I tried to communicate with the district administrators, and I hear a lot here about communication is very important, but I haven't been able to speak to anybody that I have called except Mr. Daniel Gold that I spoke once in 2016, December 2016. I've been trying to clear the issues because some administrators, and I can mention the name, but my administrator from Miramar High School, the one who prepared the report, has been lying about it.
Thank you.
It's a lie.
Thank you. Your time is up. Thank you very much.
I'd like to keep my job, please.
Thank you. Thank you. Any comment from my colleagues? Ms. Bartleman?
Yeah, I guess I don't know if this gentleman is part of BTU, but he needs to talk to his BTU representative because he will have due process rights after the termination. But we have to act on the termination to have the due process. And I don't know if he's aware of any of his rights as a teacher under the collective bargaining contract. So once you're terminated today, you do have a right to due process, and you should contact your union. Okay.
Thank you, Ms. Bartleman. Yes, Ms. Myrick?
This gentleman has already requested a DOA hearing, so
Good.
he will proceed with that after you take action today.
Okay, thank you. I just want to make sure he knew he had those rights.
Thank you, Ms. Bartleman. I had a question that I asked Mr. Moquin earlier with regard to the status. So if you look at the chronology of events, you will see that on 2/25, a DOA hearing was requested regarding the 10-day suspension served on February 15th. And then it came before the board, and obviously we voted on it. It came before the board. Now he's with the DOA process, and so now we have a termination request in front of us. How much time do we have, or what implications are there? And this might be to Ms. Myrick as well, with regard to what is the result of the first DOA hearing. Because I don't know as a board member, I've had this situation before where one is pending and we're taking a subsequent action in progressive discipline.
Okay, I do not know that. I will see if Doug's still upstairs to see if he can answer whether or not there's a result yet of the other DOA hearing.
Okay.
Heather, can I ask a question?
Sure.
To follow up on that, because I didn't catch that. So if he wins the DOA hearing on the 10-day suspension, then how do you terminate him with the progressive discipline? Don't we have to wait no matter what?
The answer to that would be no. If he wins the DOA hearing on the 10-day suspension, he still has had other suspensions and progressive disciplines, so you could, still vote to terminate him, or the DOA judge could come back and not terminate him, but, recommend a different order. Remember, it's a recommended order that will come from DOA.
Okay, so can I make a motion to put this on the table until Ms. Meyer can get in touch with Doug, since we have like 6 million other items to do? At least just to give her the time instead of sitting here and waiting, because I think that's important information to have.
Well,
for me.
I mean, I think it's something that we should know, but I don't think that, given Ms. Myrick's comment just now, it's not going to change anything with regard to our ability to move forward with this item today, based on the comment that she just made. That was just my question, is how do we move forward in progressive discipline when one of them is possible could come back to us from a DOA?
Yeah, I think you can move ahead based on what you see before you, as I've advised before, that given the facts that are in here today, do you agree with the recommendation from the superintendent? If you do, you can move forward, and he has requested another DOA hearing, so this will just be forwarded for another DOA hearing at that point.
Can I ask another question?
Thank you. Yes, Ms.
Doug is
Barman.
on his way down, by the
Thank you.
way.
Ms. Barman?
I guess, Barbara, my question is, what if we totally outright lost the DOA because we didn't meet the standards? Then we terminate him. We've had a recent case that we had to settle to pay all the attorney fees and the back salary. And so I just want to make sure that, I mean, you're telling me to terminate, but we will owe him money and everything. And if we find out we lost the DOA and our whatever because of our documentation or because of whatever, I think that puts us in a bad position.
Well, I think,
Because
it's hard to compare this case with the other case, because the other case that we are paying the legal fees on was so involved with the evaluation procedure that it was difficult. I think this is a different one, but, you know, if you want to go to something else, Doug is on his way down. He's still here, so.
I would like that, just to hear if we have an outcome.
So are you making a motion?
Yes.
Motion to table till later in the meeting. Is there a second?
Okay.
I'll second it just so that we can get the information as a courtesy. I don't know if it's going to pass or not.
It's okay. Thank you, Heather. I appreciate that.
Any audience input on the motion? Any colleague input on the motion? All those in favor of tabling the item till later in the meeting indicate by saying aye.
Aye.
Aye. All those opposed say no.
No.
Okay, motion fails. So we'll take a vote on the item I3. All those in favor indicate by saying aye.
Doug's here.
Aye.
Aye.
All those opposed say no. Robin, did you vote?
Yeah, I just thought Doug walked in the room. We were not going to let him answer
Could
before we voted.
Could you
We
give
already
us
voted.
I think we voted, but could you give us a response to, we're on G3, and it indicates.
I3.
I3, sorry. It indicates that this gentleman had a previous DOA hearing?
He has one pending.
Okay, so we haven't gone to the
Yeah,
hearing.
so, and the misconduct here is very similar to what occurred that you voted on before and gave the 10-day suspension.
Yes, we read
So
it. We
when
read
this
the
case-
item.
When this case is approved, we will move to consolidate the two cases at DOA.
Okay, perfect. Thank you so much. So, official school board records, you got that? Item I3 passes. Thank you.
And she has that it was unanimous, so, okay.
Yes. Okay, now we are going to the CC items. Do we need to take them all separately is my question, Ms. Levinson?
May I just suggest that we take all of them except for the page 14, which is, let's see which item number that was. CC 11.
Yes, CC 11.
So if we could take CC 3 through CC 10 and CC 12.
Okay. Is that your motion?
So moved.
Moved by Ms.
Second.
Levinson, second by Ms. Korn.
What are we taking? Would you say it again?
Items CC 3, 4, 5, 6, 7, 8, 9, 10, and 12. Audience input on those items? Colleague comment on, yes, Ms. Korn?
So I'm going to go back to CC 9. This is the role that we approved to go from director to manager. And I guess when you look at the job description and how it's been changed, I need some assistance in understanding who's now going to take over. So I will give you a couple of examples. Before it said take the lead in the creation of measurable performance metrics. Now this individual will be assisting the development of measurable performance. Before they were facilitating the identification and prioritization, selection, and scope of division processes, now they're partnering with the chief facilities officer. Before, they were developing, implementing, and promoting best practice standards. Now they are only researching and recommending. They were overseeing and serving as the liaison for the execution of internal controls. Now they are only serving as the liaison for the executive. Before, they were providing direction for prioritization and conflict resolution. Now they are providing assistance with. So I'm just giving you a trend. So the trend here is they are clearly collaborating, working with, assisting, serving, but they are no longer leading, facilitating, taking the lead, developing and implementing, serving as a catalyst. So someone help me understand who is now doing all of those things. Because this person's job is to still assist in all of these things. So who's doing the lead on all of this? Because we just took them from a director to a manager.
Hello again, Dr. Marianne May, Task Assigned Chief Facilities Officer. So this person will still be doing pretty much the same functions as far as working with the other directors and helping to streamline the processes that we have in place. She just will not be working at a director level. She has no direct reports.
But that isn't what this job description reflects. This job description reflects a very different job. Very different, not just a org chart name. Who now is going to be the catalyst identifying recommendations? Because she is just submitting them. Who is now developing, implementing, and promoting the best practice standards? Because she's only researching them and recommending them. Who is now taking the lead in creating the development of measurable performance metrics? Because she's only now assisting somebody. Who is now who is now overseeing as and serving as the liaison? Because she's only overseeing. She's only serving. Someone must be then taking on the job of overseeing. She is, I've already gone through a whole list. Before, she was leading and facilitating ongoing performance improvement sessions. Now she's only facilitating them, so someone else is leading them. So I don't care. I just want to know.
Her direction will come from the Chief Facilities Officer.
That's what I was going to say. Yeah.
She will get her direction. She will get whatever she is to work on, whatever's going to be measured, whatever initiatives are coming down will be through the Chief Facilities Officer.
So the Chief Facilities Officer is now going to lead the ongoing performance improvement sessions.
Yes.
Yeah, they should.
And the new chief is going to actually oversee being the liaison. The chief is going to oversee being the liaison. And the chief is going to take the lead in creating the measurable performance metrics.
Yes.
These are their day-to-day operational things the chief is now going to be. So then we should be getting a new job description for the chief. Because these are some significant day-to-day operational things they have to do.
Let me just say this, all those chiefs sit over there, that they do that as part of their regular job. I don't know if it's in their job description. Through the work that we do in SIM, they're required to do that. So for example, in the strategic plan, a lot of the metrics that have come about has been a result of SIM collaborating with those chiefs to identify what those metrics are and then cascading that down to their team. So,
but that's what I asked, Mr. Runcie, but that's what I asked before. So I said, then these have to fall to someone else. And Mr. Woods said that his SIMS team is not stepping up to make these.
No, his SIM team is not working directly in the department, but
right.
what I'm suggesting to you is that the chiefs are responsible for those particular duties that you just described relative to key performance indicators, metrics, holding sessions with staff. That's the expectation of what our chief officers are doing in their respective areas.
Okay, so that's a great answer. Why did we have this person as a director before then?
I think there was a sense of trying to, I guess, get someone at the right level to be able to perform, the work in the district. It was the first time we put that in place. And as we go along and we put these positions on the work chart, that's why we come back to you and the rest of the board every year, and we make adjustments based on our lived experience with these roles and the value that they're contributing to the organization. So this was an opportunity for us to, I guess, retune and redefine this position based on how we saw the role actually functioning in the department.
Okay, so then that would have been helpful when we were at the org chart, and I was trying to understand why we were moving from that position to this position. And there's an individual in this position already, I know, because I actually heard from her.
Right.
And before, I know one of my colleagues made quite an issue of another gentleman who was moved from one place to another on the org chart. And there was a really big to-do about it and how it was communicated and so forth. So I don't know how that occurred in this area, but I would just ask that whatever kindnesses were shared with the other individual who was moved, that we would afford the same to this individual. Thank you.
I did do that. I did speak with the individual before we made this change.
Okay. And I will, so since you brought that up, Ms. May, I will tell you the other individual was also told, but there wasn't input from that individual, and the board member and Mr. Runcie agreed that the conversation would go beyond just being directed and told. And in this case, it appears, could be wrong, that this individual was told in a similar way that the other one was. So that's why I'm asking that if we're going to be extending ourselves for individuals who are going to be moved or changed in this way, that we treat them all similarly. And I did not get that takeaway. If that occurred, fantastic, but that's not the takeaway from the employee.
And there was a long discussion on it with her.
Thank you.
Thank you, Ms. Korn. I have Ms. Levinson on multiple items in the CCs. Originally, you said CC 3 through...
I was just asking that you hold them until we did II1.
Okay, you didn't have comments on that?
No.
Well, look at how helpful that is to mark all that off on my list. And on CC 12, I had, Ms. Rupert, are you still on the line? Ms. Rupert? Okay.
For CC 11, do we just table that till next?
We will in a minute.
Okay.
Let's get through these first. So, any additional comment on the CC items with the exception of CC 11? All those in favor of items CC 3, 4, 5, 6, 7, 8, 9, 10, and 12 indicate by saying aye.
Aye.
All those opposed say no. Items CC 3, 4, 5, 6, 7, 8, 9, 10, 12 pass unanimously. Mr. Runcie has asked whether or not we should table CC 11 since it's directly related to the page that we've tabled. Ms. Myrick?
I think that would be wise, and then you can bring it back. If Mr. Runcie doesn't change the thing, then he can just bring it back at the same time, or they can adjust it if they change the org chart.
Thank you. Can I have a motion?
To defer?
Yes, I'll make a motion.
Ms. Levinson is making a motion to defer.
To table, or no, to defer, yes.
CC 11 to
June
June 25th. Second by Ms. Good. Audience input on the deferral. Seeing none, comments from my colleagues. All those in favor of the deferral of item CC 11 indicate by saying aye.
Aye.
And all those opposed say no. Item CC 11 is deferred to the June 25th meeting. Ms. Levinson, can we take them all together?
Yes, you may.
Okay, thank you. Only, I'm asking you because you had comments on all of them. May I have a motion and a second on item DD 1 through 4? May I have a motion? Who made the motion? Okay, moved by Ms. Good, second by Ms. Levinson, items DD 1 through 4. Audience input on items DD 1 through 4. Seeing none, I have Ms. Levinson on items DD 1 through 4, and then I have several of my colleagues on DD 3.
And I will make it quick. The first one's just a comment. Congratulations, our 22 schools, 100%, no exceptions. Love to see how that has changed in our district over the years, to have such great audits in that area. DD2 on the State of Florida Auditor General Financial and Federal Single Audit. I want to commend staff, both areas, the financial statements and the federal awards, had clean audits, and want to congratulate both of those departments. DD3, the State of Florida Auditor General Operational Audit. I believe we've talked about some of these before, so I'm just going to speak quickly on them. The salary overpayments, we have all discussed how unacceptable those are. We are in the process of fixing that. Thank you, Ms. Marte, for leading that. I know that a lot of the chiefs in different areas are working together to put that in place, under Mr. Runcie's.
And, I also want to give the board credit for passing the item to give us the funds to do the SAP upgrades. They're actually very critical in all this work.
Right. So we are very happy that we're going to see that be corrected. As far as monitoring the P-card limits, I know, and making sure effective procedure is in place, I know that we hired someone recently specifically for that position, so I am anticipating that everything has been implemented there to make sure that we have effective procedure in place for our P-cards, and having restrictions to areas authorized for purchase and having immediate cancellation. Are those all in place?
Those are, some of them have due dates for June 30th.
So by June 30th, all of that will be in place?
So the purchase card is an example of an issue that has multiple parts. So Mr. Woods was able to compile a response that has due dates of June 30th on 2 of them, and then the last one actually has a long-term solution that has a partial due date and a long-term due date, if Ms. Coker can expand.
And I'll just say for the board is, once the particular solutions are implemented based on whatever timelines and procedures that are indicated, we have the auditors go behind to make sure that was done appropriately. So that's part of the process we put in.
Good evening, Mary Coker, Director of Procurement and Warehousing Services. Thank you for...
Hold on just a second. I don't think your mic's on. Could you please turn on the mic for Ms. Coker at the table? It's on now.
Thank you. Good evening. Mary Coker, Director of Procurement and Warehousing Services. As part of the recommendations from the Chief Auditor's Office as well as the State Auditors, we have began our implementation for an upgraded process to P-cards. As Ms. Rich Levinson stated, we have hired a P-card coordinator. That was the initiation of our processes. We've also included 3 different levels of stages between the findings, which included the limits, the transactions processes, as well as the cancellations. As was stated, we have a due date of June 30th for implementation of those, but we've already implemented some of them. One of them being on the cancellations from the SAP side. Some of the changes that were made were with the I believe it's the ES system, HR system. So once the employee is terminated, automatically it generates a notification to us for us to cancel. That in the past used to be manual. That was one of the findings previously in the P card. That was also discussed at the committee meetings. So there has been, the majority of the implementation has been complete, but our due date is June 30th. So we can very much come back to the board after June 30th and advise the status of all completion of the 3 recommendations.
So there's nothing after June 30th?
So the recommendations, we've committed to completing and implementing everything by June 30th, of which we have almost completed the majority of the items. As I mentioned, the hiring of the coordinator was one of them. We've began automating some of the things within the work system, the Bank of America work system, as well as the SAP enhancements that allows that when an employee is either terminated or they've lost or the card has been stolen, that there's an automatic stop. We've also worked on the...
I just want to make sure everything will be completed by June 30th.
Yes, and we're tracking also the limitations of the thresholds of the purchases, the financial statements also, that was another finding. We've implemented a process to ensure that all of the P-card users that have a $20,000 threshold purchases are filling out the financial statement. I mean, it's a robust plan that we've created, and we've almost fully implemented all of them, but our due date was June 30th.
Excellent.
Ms. Coker, there is one of the portions that has a more longer-term solution. I'm not sure if Mr. Woods can expand.
No, I mean, I think Mary Coker summarized it nicely. There is an item that has a phase 1 and phase 2. It's a longer-term technology enhancement. So we will hit our June 30th due date, and then we have another item for phase 2 that will come back. And I believe, I don't know exactly what the due date is for that.
Okay, my question is why?
Yeah.
Mr. Unsi, I'm going to ask why, because if the ROI is in our favor to get it implemented, why do we have a phase 2? Why aren't we taking care of it now?
I can explain. Through the chair, can I explain?
Yeah, absolutely.
So part of the enhancements that we're making currently, so we have Bank of America, and we have the Bank of America work system, of which currently today it doesn't talk to SAP. So the transaction review that we do with my team under the P-card coordinator is very manual. When a person goes to make a P-card purchase and we receive the statements at the end of the month, we manually check to see that they were in compliance with, that they shouldn't have bought something, et cetera. The system doesn't automatically alert us, or they've purchased something that they're not supposed to purchase. So we're working.
So we're currently checking it manually to make sure it doesn't happen?
Yes, which
until this is implemented. That's my number one concern.
Yes, we are definitely doing that, and phase 2 would encompass us interfacing both SAP with Bank of America Works for this to become automated. Therefore, we would have parameters by which when a person goes to use it, let's say to go to Macy's, they can't. Right? Okay. It restricts it. So there's just some interfaces that have to take place, and this is why there's a phase 2. But the fact of the tracking is being performed today manually.
Okay, well, welcome to the 21st century, but in the meantime, we need to make sure that we're doing it manually so we don't have this finding in the future. So you are assuring that we're doing it manually?
Yes.
Okay.
Yes.
Okay, and then just quickly, the school internal funds. I know that we've allotted extra resources, Mr. Jaboan, so those are underway to be completed very shortly, correct?
Actually, as of last Friday, we had completed the field work on that one, so that finding will close out by the end of the month. So Ms. Ann Conaway will be reviewing them, but we've done with the actual field work at all those schools.
Okay. Excellent, and I know that you reported in here that number 1 and number 2 have already been closed.
Correct.
Okay, so the ones that we are finalizing right now are the IT ones, and when are those anticipated to be completed?
So I believe that I have a response from them that I don't recall right now over the past few days. A couple of them do have some June 30th days as well. I wanted to mention that as part of my audit plan, I previously reported to the board, what I'm doing is I've developed a database where all of the findings, including these as well as my findings, are making their way into the database, and I intend on providing a district-wide update on the status of each of the findings, including these, where I'll categorize them as closed or in process. And so I'll be able to have a very good snapshot of all of those. So it's my intention to do 2 of those reports during the next fiscal year as well. So these findings will continue to be followed up even beyond the due dates that are being provided right now.
Okay, so you'll give us an update on those?
Two updates.
Okay, very good. Thank you, and let's see. Okay, and then the last one was the FTE overpayment on these 2 charter schools. What is the follow-up to collect the dollars on the holdback?
So I've been speaking with the Inspector General on this audit for several reasons. One is to make sure that the procedures that we're following are consistent with what they do when they're out on the field reviewing our schools and the various charter schools. So I anticipate that they will send a letter to Chair Brinkworth tomorrow indicating that they've accepted this audit. And at that point, I will liaise with Ms. Myrick's team as well as Ms. Brown's team to send them a demand letter. That's the current plan right now, unless I get some different advice.
And Ms. Myrick, what have we done in the past? Because I know when I was chair, and I'm sure when others were, this has been an ongoing problem with a charter school or two each year. Have we been getting that money back with the FTE overpayments?
Generally not, because they generally don't have the money. And this has been reason why we have gone to close some of the charter schools, and this will be reason to close, but we will be, I know Bob has already, Mr. Agnola has already been in touch with the charter school, and they have an attorney. They are going to disagree with the amount that is here. They've already started that, but we will do the demand letter, and if in fact they cannot figure out a way to pay it back, at least even a payment plan, we can do a couple things. We can start to keep the money from their monthly.
Right, we do a holdback.
We can do the holdback over a period of time. Leslie, maybe you want to respond, but if they close, you know, we probably will never get the money. So it will really be a way to try to figure out to do a holdback. Leslie.
Yes, thank you. Leslie Brown, Chief Portfolio Services Officer. Just for the board's knowledge, I just really want to take a minute and really recognize Mr. Jabowen. This is the first time that we've been able to move this process fast enough where the charter school is still open. So we actually have had 4 meetings with them, and through Mr. Jabowen's work, we have brought this to our former chief auditor with very little action. And Mr. Jabowen and his team jumped on it right away. We were able to have meetings with them, have 4 opportunities for them to produce additional documents which still did not meet the standard that Mr. Jabowen and chief auditors expect from charter schools or anybody else. And the fact that our state chief auditor has confirmed exactly what Mr. Jabowen has done really creates a great opportunity for us to be able to make sure that everybody is doing the right thing in the right amount of time. And with Mr. Jabowen at the helm, I just wanted to take a minute as personal privilege and thank him.
Okay. Well, I thank you too, Mr. Jabowen, and your staff for acting in a timely manner. There is an agreed upon difference. Can we collect that amount now that's agreed upon and then deal with the difference in the future?
So, page 38 summarizes the...
Yeah, that's what I'm referring to.
So yes, the column before the last column is the amount that they never provided us with documentation.
Right.
I would hope so, because at that point, that's about 20% of it. But I'm not sure. I guess it's the next steps that we would take from a legal standpoint.
I mean, because if they've agreed, I'd like to at least move forward with that portion of it and then deal with the disputed amount.
Yes, we can move in that direction with them, particularly if they're willing to pay all of that agreed amount in one lump sum, then we can move forward. But we will be working with Leslie and Mr. Jabowen about that. We also have another letter in from the state that for another charter school, so we're keeping them busy.
Okay. And for those who are listening who may not realize what we're talking about enrollments that wasn't actually verified in these charter schools where they were paid for that enrollment.
Correct.
So, thank you.
Thank you, Ms. Levinson. Ms. Bartleman?
Yes. So my question is about finding, I have 2. Finding 8.
Which one are you on, please?
Oh, I'm sorry, I'm on DD3.
Thank you. DD3.
So I can see why the specific issues are not listed, which means that they are very sensitive. So my question is, when are they going to get done? And then I guess I'd have to ask you offline what some of them are, because they're not listed in here.
Yes, I'm sorry, back to the Auditor General's.
Yeah.
They did have a meeting with us back in January where they had verbally told us what the issues were. And so that way we can work on them. So I recall from our meetings what the specific issues are, and that way I can work with Mr. Bradford on them.
Okay, I guess finding Ada's, there were 14 and 11, 12, 12 and 14, 15. If they're so sensitive that they can't even be listed in the report, shouldn't they be a higher priority and not repeated?
Yeah, I think overall there's a process that needs to be cured, so it's not really regarding the specific findings. It's to make sure that the controls are there so that they don't repeat, and that's what Mr. Bradford is working on.
Okay, so I guess since we really can't talk about it online, I'd like to talk to you separately about it,
Sure.
because to me, if they're that sensitive, I need a better timeline, and especially since it's a repeated audit finding since 2011. I don't even know if it's the same audit finding because they don't list what it is, but is it the same since 2011? Is it the same?
It's not the same specifics, but it's the same issue.
So we've had the same issue since 2011, 12, then we had it again in 14, 15, and now this is 18. And it's so sensitive that we can't report it, but we haven't fixed it since 2011, 12. That's disturbing to me. Okay, my next question, and this doesn't have to do with you, it has to do with Ms. Marte. So my question to Ms. Marte is, we have to collect overpayment because of payroll overpayments. I have now received 2 emails that the district determines how much we're going to garnish from the teachers' paychecks. So it's not that teachers don't want to pay us back for our mistake. It's that when you take $200 out of somebody's each paycheck, that impacts their ability to pay their bills. And so is there a way you can do a different payment plan, or is there payment plan flexibility? Because, look, bottom line, they didn't catch that we were paying them more. I don't know how subtle it was, and actually one person explained it was very subtle. And then they have to pay us back by law. The Auditor General is saying pay us back. But for some people, the $200 a paycheck is a bill. It's lights, it's food. We talk about our teachers all the time. So who determined how the payment plan would work and over what period of time?
Through the chair, Judith Marte, Chief Financial Officer. The determination of how the overpayment would be paid is governed by BTU contract that they have agreed to. So the BTU contract says that authorizes us to take $200 per paycheck, assuming the overpayment's bigger than $200. Or in the event of a hardship, it would be $100. So in the case you're speaking about with these people that have started, the 25 people who were getting paid a double incentive, if they've notified us, we've worked with them for the $100. Some people have asked for less, but quite frankly, it will take us so many years to get the money, and the bookkeeping to do. So first of all, that's what the contract says, and that's what the unions agreed to, and that's what we're doing. The notion of us taking $20 at a time for a $3,900 overpayment, where we've got to track that all manually for up to 6 or 7 years, is problematic. We just don't have staff to do that. So we comply with the contract. We try very hard to work with people. I think one of the letters said that other districts do it, let people take longer. I take exception to that. I've talked to 4 districts who make people pay it back within 6 paychecks. So,
I know I haven't sent you the one from today, but the one I sent you before, the woman who had the real hardship with the $200, does she have an opportunity that you'll now potentially reduce it to $100 a paycheck? You're saying that's what's happened, or that's what you're doing?
anyone who sent a letter and asked for a hardship waiver gets it. We don't negotiate that. It's an automatic. If you want a hardship waiver to pay the 100 that's in accordance with the contract, it's an automatic. We will give it to you. We don't ask you for proof of a hardship. We don't invade your privacy or anything.
Okay, and do all 25 people know about it? Because we just got one today. I'm wondering
So,
what the communication
I would
is.
assume they read their union contract, Ms. Bartlett, but Sue sent them all a letter explaining the mistake, explaining them their rights to work with payroll, that they could have a repayment plan. They've all been notified of all that. And to
But are
contact,
they notified about the hardship, the ability to repay under the hardship?
if they have an issue with the 200, they call us and, some of them have not contacted you. They've contacted us directly and we already have them on a $100 payment plan.
And so the one that contacted me today,
If
I
you
need
forward
send
it to me, I'll make sure they're given the opportunity for the $100.
Okay, I just think it would be nice if we, in our letter, could say you do have an opportunity to apply for a hardship, because clearly, if we were getting emails, then they didn't understand that, and just say there's a hardship process for them. This is the trauma, like the one letter from the one teacher and the impact on her life with the $200 and the stress it caused her, and she may not be able to afford the $100. I don't know. But if you would have said that in the letter, she wouldn't have written us the email where she's like pouring out her soul and crying and upset.
I'll make
So
sure I
can
speak.
you make sure?
I'll make sure I speak to the staff who initiated the overpayment and did the letter, and we talked to them about doing that. Hopefully, this is a very short-term discussion as we move forward to create processes where overpayments are minimal.
Thank you, and I just feel bad because it's our mistake. So I know they owe us the money, but thank you. I'm glad to hear about the $100 reduction.
Thank you, Ms. Bartleman. Ms. Alhadeff?
My concern was on finding number 8, Ms. Bartleman, I think, talked about. On page 1, I don't feel very comfortable with the response of the summary, just basically saying that it needs improvement. This is the integrity of the security of district data. I would like to hear what we are going to be implementing moving forward and how we are going to be proactively fixing finding number 8, and it could be with a school board follow-up.
Sure,
Thank
I will work with Mr. Bradford on providing that information to you, and to the entire board, of course.
Great, thank you.
Mrs. Korn?
So mine was on finding number 2.
Is this DD3?
I'm sorry, DD3, yes. I'm finding on number 2, and I'm just looking at it a second time. This was in the recommendation that the board actually take action on the money that was spent through the unrestricted. And I don't see in the in the response, how we address that part of the request, because it looked like we should, as a board, do something. And I know that it says here that it was not clearly communicated and that there's going to be a process so that we minimize the overpayments. But I thought, as I read their recommendation, was that the board actually take action at this point. So unless I misunderstood it, it said the board should take action to either authorize the district use of the $881,000. Does that make sense? Does my question make sense?
I think the board did that in a previous K item or something that you explained, Ms. Martin, a couple months ago.
Thank you. So the item you're speaking to is best and brightest. So
yes.
Last year, the interpretation of what the state said was the amount to be paid was $1,200. What the state actually said was inclusive of the employer's share of fringe benefits,
right,
which made the gross payment to the individual less.
Understood.
Given the timing of what happened, I just want to put it in context.
Sure.
Given the timing of what happened, I went to Mr. Runcie and I said, we have teachers overpaid, it was less than $100 a teacher.
Ms. Marte?
Yeah.
Can you hold on for just 1 second?
Oh.
I know, but I have to, just give me
Can
1
we
second.
still discuss it without the vote?
Ms.
Can we still
Barman will
discuss it
stay
without
until
a
she
quorum at the
returns. Go ahead,
dais?
Ms. Martin. We can't conduct the meeting without a quorum. Okay.
Thank you. Sorry, yes.
Given the timing of what happened, I went to Mr. Runcie and I said, to notify what's hundreds and hundreds of teachers of a small overpayment, this was right after the tragedy at Marjorie Stoneman Douglas, I think it's just going to create significant strength. We agreed it was prudent not to, and I had identified a resource to fund that. In the next budget amendment, which was in the spring, we came to the board and increased salaries. What I did not do was say, the reason I have to increase salaries is because we paid this extra money to teachers. And the auditor said, had I done that, had I explained why I was increasing that line,
Then
they
it
wouldn't have had a finding. So this year we paid them correctly, which, by the way, I got 450 phone calls because none of them could understand how being paid correctly was, but that's another story. So the problem has been resolved. The board did take action in that K1 item.
Okay.
They took exception with how I explained it, which won't happen again.
Okay, thank you. And then, I know the finding was for that specific year, but if that's how we did it that year, how are we sure that we have not, we've had Best and Brightest now for a few years, how do we know that this was not something that we've now done collectively more than 1 year?
So you have.
Okay.
But last year, sorry, this is 2017, the year we're talking about, was the first year that it was effective and highly effective, and there were huge numbers. Before that, it was based on the scores of their SATs, and it was a very small population, and the overpayment collectively was very, very small. I can get the board all that details, because we've gone back and researched it, but it was in the thousands of dollar range, not the 880,000, not anywhere near that amount, because not as many people were eligible the year before.
So, Mr. Runcie, here's, my concern is, as much as it was less than $100 for 11,000 teachers, it's still $881,000, and when we as a board were talking raises, funds available, being able to pay our pre-K teachers, $881,000 would have helped the conversation in many of those areas. And if this has happened now for a few years, and I get the 881 was a 1 year. Okay, I thought you had said it was a smaller amount in prior years because it was
Smaller,
applied.
I mean, less than $10,000. It was
Okay.
significantly, it was a
Got it.
handful
So
of
it was
people.
not a significant,
Oh,
okay.
no, ma'am, not at all.
Okay.
No, no.
So it is
I
only
would-
this year that it's been that
It
significant
was only,
amount of
no,
money?
this year was paid correctly. It was only
Yes,
the
the prior year.
It's a closed fiscal year that's completely settled, has nothing to do with this fiscal year at all.
Okay, but one of the things then that I think is important is that our staff understands that an $881,000 mistake was absorbed by the district and was not asked of our teachers. And I understand that it was not a mistake on the teacher's part, but that's a big number for the district to say, we made the error, we're going to absorb it. Because it wouldn't have cost us that much money to have gotten it back, meaning we would have just gone through the payroll. So I think it's important that the communication be presented, that based on this finding, and when I say presented to BTU, I think it's important that so they're aware of it. Sorry, I keep making you stand up, Ms. Marte.
They're very well aware of it, because I had a conversation with the president and actually said it at the collective bargaining table. So they are very well aware, and the members that were all notified, so everyone got a letter saying, in the past, we know we paid you this way, which was which was more money than you should have received, and this is the correct way. And that generated over 400 calls between the payroll office and my office, and emails galore that I answered for days, because they thought we were somehow cheating them. So they knew that they got extra money.
So
Every one
what
of them
in
was
our
notified.
process let's just say, Miss Marte, for whatever reason, you land the lottery and you decide not to come back to us next week.
That would never happen.
What, okay, I'm very happy to hear that.
I don't play.
So with that said, in your absence, what actual district process is in place so that in the future, when these types of payments, not just Best and Brightest, but anything else that comes from the state where it's this type of a payment, how do we have something in place that keeps us from this type of, because benefits seems to get confusing oftentimes when we get into payroll payments. So how does this not happen again in the future without your specific direction or an audit finding?
So, in our current environment today, there's nothing I can do to prevent it.
Okay.
The board, as Mr. Runcie said, has authorized an investment in a re-engineering and redesign of payroll, and I don't want to get too far into the weeds, that will take a system that has many offices doing inputs into the payroll system and uploading payroll to a few what they call power users and a review process built into the system that if I do decide to play a ticket and I win, it won't matter. And that's something that we're going to get done this year. The first phase of it will be 26 weeks after you actually approve the money in July. No, actually the June 25th board item, I hope, because this is very, very important. It's a significant issue. But today, I can't give you any guarantees. We find overpayments on a routine basis.
So in the development then of this, and I don't want to get in the weeds either, but I would ask this, in the development of this, because of this audit finding, I think an appropriate thing to expand the result from the district in terms of our response is that the development of our new payroll system.
It's in there.
Will include, but will include some type of a default where there's a yes, no, or however it's going to, in terms of whether or not benefits comes out of something or if benefits have been acknowledged. In other words, you see what I'm saying?
So
within the system itself,
it'll be built into the business, what they call the business rules.
Yes.
So it's built into the business rule tables that
Correct.
there's no manual intervention.
Yes, that's what I'm asking.
Absolutely.
Okay.
That's going to be the focus and the main body of work to correct the problem.
Perfect. Thank you.
Thank you, Ms. Korn. Any additional comments on items DD 1 through 4? Seeing none, all those in favor of items DD 1 through 4 indicate by saying aye.
Aye.
All those opposed say no.
I'm an aye, Heather.
Thank you. Let the record reflect Ms. Bartleman is on the line. So, out of respect for a couple of staff members who are sitting here waiting for an item that Ms. Bartleman asked to speak on, and apparently she does not need to speak on it anymore, I just want to ask, does anyone else have questions on item EE17? She was the only one that indicated that she had questions.
Not 17. 18.
Anyone? Okay, so would it be okay with you if I go ahead and take, either we take the item or we just tell them they can go, one or the other? All right, so can I have a motion on item EE17?
So moved. Second.
Moved by Ms. Korn, second by Dr. Osgood. Audience input on EE17. Seeing none, board member discussion on EE17. All those in favor of item EE17 indicate by saying aye.
Aye.
All those opposed say no. Item EE17 passes unanimously. Thank you, ladies. Sorry that you had to wait so long. I will take all of the ones that we didn't have comments on. In the
Heather, I'm going to be on the line for my other item.
That's fine. Thank
okay.
you. Thank you, Ms. Bartleman. I'm going to take the E's that we didn't have comments on. No. I guess we better do the E's first. I have a motion and a second on item E1.
So moved.
Oh, you know what? I don't need to do these anymore. I already made my comments. I have a motion on a second on item E1 and E2.
Second.
Moved by Ms. Good, second by Ms. Zaladev.
Is this E1 and E2, Ms.?
Yes. Yes,
okay, I have
it
a
is.
question on E2.
Okay, I didn't have you down, but I do now. Audience input on items E1 and E2. Seeing none. Ms. Bartleman, E2, go ahead.
Yeah, sometimes if I hear somebody else ask, I'll be able to ask. So I just had the question on page 4 or 5 of the outreach program. I see, why would our person go to a Super Bowl luncheon? Like, it just seems that that doesn't seem like a place to get business. It's number, see it on February 22nd, Super Bowl Host Committee Informational Lunch.
Maurice Woods, Chief Strategy and Operations Officer. So this particular event is a committee that's been put together in preparation for the Super Bowl. We're anticipating significant vendor opportunities related to being on the host committee related to that. So we wanted to have representation there in case there were vendors that were interested in hosting or being part of that committee, that we could potentially register to become certified here in the district. So it was kind of like an exposure and an outreach event for us.
And did you sign up anybody at that event?
I would have to defer and follow up with you. I don't know what the return on that investment was or how many people we recruited, or if we're still in the process of actually certifying vendors that we may have met at that event.
Well,
I can follow up.
It says 0%. And then my question is, before you go to an event, there were 215 people there. And you're listening, on all the events you have it listed like this, prospective companies. How do you gather that data at some of these events?
In all honesty, Ms. Bartleman, I would have to defer that question to the manager of SDOP. So I did allow her and other staff members to go home this evening. My apology for that. I can follow up via memo to you and the rest of the board members with a response to that question, if that's appropriate.
So my questions are, number one, I want to make sure I have them for the record since I'm going to get this in writing. Number one, how in a room full of 215 people can the person adequately count how many of those are potential minority business people? I mean, I work rooms all the time, and unless you're going up and specifically asking people. Number two, that would go for all of the items, actually. Some of these make sense, but like a Super Bowl lunch for a host committee, and then you also have, I answered my own question, that it was 0%. And then how much did we pay to attend that? Did we pay? And how much did attending an event like that cost with a 0% outcome? So those are my questions to have in writing. I mean, it already happened. There's nothing we can do about it or change, but I think it's important information for me to have as a board member.
So thank you. I do have an update for you. So the majority of this information on this log is entered in most instances after we attend the event. So the reason or the way that we would know the number of attendees at the event would be that we were participating there. We oftentimes ask for the participant list from the vendor who's sponsoring the event. And as for the cost for this particular event, there is no cost associated with attending.
Okay. All right. I still have questions about how you're sure these numbers are accurate, but okay. Thank you.
Thank you, Ms. Bartleman. Ms. Korn?
Yeah, if I could, just to my colleagues with my other hat on, I can tell you that networking is not something where you walk in a door and you can say, I walked out and I just secured 10 people for my business. If you got to see 215 people and you identified 12 specifically for your need, let alone the other people of the 215 you may have introduced yourself to and may have had some kind of auxiliary exposure then to other companies or things that they may have thought of, the net result isn't always a turnaround of someone just signed up. That isn't how networking, listen, if networking worked that way, everyone would network all the time and no one would question it. Networking is difficult because you have to plug away at it day after day. Oftentimes you have to go to events where you might even be stretching it a little bit to really be able to find those companies, especially in this area, If you're only going to events that specifically say diversity, then you may have a women business-owned company that just doesn't go that avenue, but they look at a lot of different types of ways of being out in the community. It is incumbent on our staff to be networking in many different facets and to be out there as often as possible. And when we're talking about events that especially don't even have a cost to us, all this is a win-win for the district. Because it's not necessarily even just their component that they're pursuing, but it's just the district in general. Every time someone sees a School Board of Broward County employee out there promoting the district, talking about the district, doing positive things for the district, it is a benefit for our district. So I would hope that our school board members, as we look at this list, we look at it through rose-colored glasses. And I don't say that often, but I can tell you in networking, that's what you have to do to ultimately find wins. Because if you go in there with just clear glasses on, you're going to get deflated and you're going to feel as if we're not having a result. You have to go in with a very positive aspect. You have to go in there willing to go into events that may not feel like there's a win every single time, but at the end of the game, there will be some. Thank you.
Dr. Osgood?
And I agree with Ms. Coyne, and I'll just add that when we look at our vendors list, we have a limited number of vendors in a lot of categories when it comes to minority businesses. And being that the Super Bowl is coming to Miami, it's a big wave across Broward, Palm Beach, and Miami-Dade County with vendors and the expectation of vendors that's going to come there to try to secure business, to sell services and products. So it is certainly a place for us to be. And I think until we increase our vendor list where we feel comfortable with what we have as far as vendors that are certified, we have to be everywhere as much as we can. And we can't look at it as though we go somewhere and we don't register a person at that event. We're gonna have some zeros, but I get excited when I see this chart because it's changed drastically from when I first came. I think we were doing like 2 or 3 events a year, trying to recruit. Now we have a couple of pages of activities where staff is out and they're reaching out into the community, trying to do their part and effort in making sure that we have minority and small business owners that are certified to do business with us. So I'm in agreement with you wholeheartedly, Ms. Coyne.
Thank you, Dr. Osgood. Any additional comments from my colleagues? So since my colleagues decided to speak on the items that I said I was going to speak on, I'll just really quickly say, as a follow-up to my comments on the earlier item, if we could just have a sit-down conversation where you can bring the numbers in comparison so that we can talk about what it looks like and what the strategy is moving forward, I would appreciate it. Thank you. Because I've asked twice now, and I don't really understand how the numbers jive, so I'd like to have a sit-down. Thank you. All those in favor of items E1 and E2 indicate by saying aye.
Aye.
All those opposed say no.
Aye.
All those opposed say no. Items E1 and 2 pass unanimously. Let the record reflect Ms. Bartleman is on the line. It has been indicated to me by staff, although I have to wait a minute, never mind. May I have a motion and a second on items E4 and E6?
So moved. Second.
Moved by Ms. Korn, second by Mrs. Aladeff. Audience input on items E4 and E6. Seeing none, colleague input on items E4 and E6. All those in favor of items E4 and E6 indicate by saying aye.
Aye.
All those opposed say no.
I'm an aye.
Thank you. Items E4 and E6 pass unanimously with Ms. Bartleman on the line. Staff has indicated that item EE27, there's someone here from the county. So if we could have a motion on EE27.
So moved. Second.
Moved by Ms. Korn, second by Mrs. Aladeff.
I don't even know what I was going to say.
Audience input on item EE27. You better come up with something good.
I will say something.
Yes, okay, Ms. Levinson has a
Ms.
comment.
Good is looking. I just want to comment on the relationship between the county and the district on this item. This has been invaluable to our students and all the environmental aspects that we've been able to collaborate on, including the P3 awards. I just want to thank the county for this collaboration, and we look forward to it continuing for many years to come. Thank you.
Thank you, Ms. Good.
If I may, through the chair, I'm sorry. I know that this was an item that we sent out a memo to revise. It was revised. The recommendation to approve where on the RF it stated first, it was revised to second, correct?
Yep.
Yes.
And the same thing on the summary of explanation for the requested action. But online, it still stated first. So I just want to make sure that we don't have to ratify that, because online it says, it still states first.
Mr. Moquin and Dr. Neesmith are looking at it now, I believe, online. It says second now. Not the title, but the second paragraph is what they're asking about. Or the first paragraph. They will fix it, is what you said, Mr. Moquin? Thank you. Is good?
Yes.
It shows.
So my questions are, or comments, I guess, are more due to the item and the way it's presented and not the agreement itself. So I appreciate someone being here for it. But again, as Ms. Levinson said, I know the positive outcomes of this collaborative relationship that we have with the county. But what I wanted to understand is, in the item itself, on page 2, it lists costs for the renewal, second, third, and fourth year, and it specifically writes, the item specifically notes costs, but I didn't see those costs reflected in the agreement. So I wasn't understanding why it was shown in the item. Maybe it's in the agreement and I missed it, but when I went in there trying to find these, you see how you have third renewal term, and then there's an amount, and then the fourth renewal term, and there's an amount, an increased amount? I didn't see those depicted in the agreement.
So if I may, just from the information that I have, these are optional renewals.
That's not my question. My question is, first of all, those are renewals that we haven't agreed to, number one. Number two, where does it stipulate that these are the costs for the renewals?
So the table that's in the executive summary, I do not see that as part of the agreement, to your point.
Yeah, I don't see the amounts, and I'll just say that my issue is more with the information that was depicted, because we may decide next year not to renew. I don't want anybody at the county to go crazy, but that's an option this board has. And so when we present information like this in an item, there's the appearance that we are agreeing to all these renewals, and we're not. We're only dealing with the renewal that's before us, which is the Second Amendment. That's how I'm seeing it. So I would ask that these.
No, we've been working it back there. So good evening, Dan Gold, Chief Academic Officer. I have just been informed that it is in the First Amendment.
Okay, where?
That's what I was trying to get a copy. I was looking it up online.
Not in our packet. Nope. They didn't include that.
Good evening, Susie Kantrek, Director of Applied Learning. So the First Amendment was done from December in order to align the county.
Right, it was only for 6 months.
Right.
Right.
And so it should be in that documentation from that 6-month period. And so that's what we're pulling up now.
You're saying that in the First Amendment, it stipulated what all the renewals would cost?
I believe so. That's what.
Well, regardless whether it does or it doesn't, I don't think it should be part of this item because we're not approving it. each year, we have the opportunity to approve a renewal, and that item should speak to that alone.
I agree.
The other thing that I wanted to point out is when you put in this item that you have an increase in spending authority, this is an amendment, and it's essentially a contract term for another year with the county. So to me, it should stand alone. If every time we renew this, we're adding on and saying that it's an increase in spending authority, if somebody reads that, it gives, I think, a wrong perception. That, I mean, ultimately, if we continue to renew these, you're gonna have a contract of spending authority of over $1 million. And I just don't think that that's a fair way to represent it.
I agree.
You know
I
what I'm
agree.
saying?
I do.
So I would just ask if my colleagues agree that when you bring an amendment before us, that it highlight that amendment. And this is, for this contract period, for this amount. You know, unless you're telling me that to date, we haven't spent the current spending authority that we have.
So I'm just trying to bring this to a resolution or through the chair. So your comments are really around what we've included in the
Yes.
executive summary. Since it's not part of the actual contract, can we amend the executive summary and resubmit it? We can still approve the item.
I'm going to approve the item.
Yeah.
All I'm saying is perception matters.
I get it.
And so
I agree.
what I don't want is someone to think that we're increasing this spending authority with the county's agreement, when in fact, we're just renewing this
1 year.
agreement for another year for a specified amount of dollars. So I guess what I was speaking of is you have on here your current spending authority was $222,216. And then you have a second amendment. You have a total here of spending authority of $565,000. So it just begs the question, have we spent it? Where are we at?
Apologize.
No, go ahead.
Yeah. We've spent the 6 months,
Okay,
right?
which was the first amendment.
Which was the First Amendment.
Got
That's what's been spent.
Right, and the
Unused spending.
the First Amendment expires June 30th, correct? So you've spent, so it's confusing. So why are you putting $222,216 there? I know, but that's like gone already. It's like, didn't you spend that already?
I understand that, but I didn't put that part together. So the 114 was what was spent for the 6 months.
Right.
And then the next amount is for the next renewal, the
228,884, right?
Yep.
So my question is, what is that line item that says current spending 222,216?
That's incorrect. That's incorrect. So I'm looking, I'm listening to you, and I'm looking at the financial analysis worksheet. The financial analysis worksheet shows unused authorized spending authority of 222,216. The only thing that has been used, if you look at the document, is $114,000, which was the first 6 months. Therefore, that number should not be there. When you look at the new award bid, it should be the 114,442, which we've actually already spent, plus what we're asking for, which is the 228,884.
No,
Right.
because the 114,442, that was for the First Amendment that ends right now on June 30th.
Yes, but when we do a requested action, it is, the way that we bring the item, we give a total of the entire contract.
Okay, and that's what I'm speaking to, and I'll just make the statement. I think it's very confusing. When you bring an item and it's a renewal, I would ask the superintendent to look at how information's presented, so it's easy to understand. What I don't want there to be a perception is that we continue to increase spending authority with this contract with the county and end up with a $1 million spending authority. It's not the case. We have a contract with 1-year renewals, and each year it stands alone. And it's 220-something thousand, and that's it. And that's all I want to say. I know it's late, and I found it to be very confusing. I'm very supportive of the contract. I'm sorry that the county staff came. And I think it's a great program with wonderful opportunities for our students.
Yes, Ms. Korn?
So this is actually exactly what I spoke to at the last meeting, which was when we get renewals, as we just keep adding to the spend authority, it's very difficult for us to be able to utilize this for the check and balance in which it is intended for. So remember we had that? So this for me is an across the district request. Fair? Thank you.
If I may, just, I want to add that we have been discussing this at APG, Dr. Neesmith, myself, and we agree, as a stranger looking at this document, it gives you the interpretation that that the number is incorrect. So we had discussed, and I have to present a draft to Mr. Woods as to what the new requested action summary should look like, where it clearly says, okay, we're asking you for this amount, but the total contract will eventually, with this addition, will be this, because it gives you the perception, just as you look at it from the public, that it's a different amount. I understand what you're saying, but we would have to change this across the board. I think not only for just renewals, for amendments, but just, we are proposing a change draft, and hopefully we'll be able to implement that shortly. But thank you for the feedback, because we've also identified that, and thank you.
Thank you. Any additional comment from my colleagues on item EE 27? All those in favor of item EE 27 indicate by saying aye.
Aye.
All those opposed say no. Ms. Bartleman, are you on the line?
Yes, I am. I just keep it on mute. I have a delay.
Thank you. Item EE 27 passes unanimously. Thank you for coming. Sorry you had to wait so long. Okay, we are going to go to the EE items. I'm going to take all the EE items that haven't had anyone say they wanted to speak to them. So items EE 3, 4, I'm sorry, thank you. 2, 3, 4, 5. Sorry? Please let me do this. 2, 3, 4, 5, 9, 19. Sorry, I've got them marked for Ms. Rupert. 13 as well. 16, 19, 21, 22, 24, 25, 26, 28, and 29. I'm going to repeat it so that we are all on the same page. Items EE 2, 3, 4, 5, 9, 13, 16, 19, 21, 22, 24, 25, 26, 28, and 29.
So moved.
Moved by Ms. Korn, second by Ms. Good. Audience input on those items? Seeing none. Colleague input on those items? Seeing none. All those in favor of items EE 2, 3, 4, 5, 9, 13, 16, 19, 21, 22, 24, 25, 26, 28, and 29 indicate by saying aye.
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 All those opposed say no. All the items that I'm not going to read off again pass unanimously.
Did you hear me?
Yes, we did, Ms. Bartleman. Thank you.
Okay.
Okay. May I have a motion and a second on item EE1?
So moved. Second.
Moved by Ms. Korn, seconded by Dr. Osgood. Ms. Levinson?
Yes. It's late, so I'm not going to go through all the commending that I usually do about all these grants, but this is a fabulous board meeting for grants, a lot of great opportunities here for our students. There is one I had a question on, which was, let's see, I can find it now. There was one that dealt with charter schools and had nothing to do with traditional schools. There's someone here from grants who knows which one it was.
Can you add me to the list?
I'm sorry, can you repeat the question? I have allowed the grant staff to go home as well.
Here it is. It's grant from the Florida Department of Education, Students Attired for Education Act Incentive Fund, page 12.
And what's the question? I'm sorry.
I'm looking at it being a grant that's exclusively for charter schools, and our grant department process the project applications, is the source for additional information. I've just never seen that before.
If I could just say really quickly, because I had looked at this several times, if you look in the financial impact, it says the source of funds is the Florida Department of Education, Bureau of Family and Community Outreach qualified district or charter schools receive an annual incentive funding award.
That's the point, district or charter schools. There are no district schools, there are all charter schools.
Leslie Brown, Chief Portfolio Services Officer. I'll try to help with this one. From what I understand is this particular grant from the state mandates the wearing of uniforms. And from what I understand is charter schools mandate that schools have to, if they're a uniform school, they mandate it through their governing board. Here in the district schools, there is a vote through the school advisory council for them to wear uniforms. So there's this kind of splitting of whether or not it's mandated or whether or not it's a choice of the school to have uniforms. And the schools, from charter schools that have applied, they actually mandate, so they qualify for, I think it's $10 per student for the uniforms.
Right, we have schools that year after year after year have had uniforms.
I believe, and I could be mistaken, but from what I understand from the law is that it has to be mandated, not by the school, it has to be mandated by some kind of governing board that they have to wear uniforms.
Okay, well, I'd like to get follow-up on that.
Yeah, I'll work with Stephanie to find out how that grant comes down.
Because
okay?
we certainly have a lot of students
We
who
do.
could use the $10.
Yeah, I certainly thought the same thing, so we'll check. Thank you.
Okay.
Thank you.
Thank you. And then, you know, again, just want to mention all the different, we have it from many different areas this time and some exciting opportunities, so thank you.
Thank you, Ms. Levinson. Ms. Korn?
Thank you. When we refer, just to Ms. Levinson's point, when we talk about governing boards, we do actually have a board at each one of our schools, if that happens to meet the criteria. That wouldn't meet the criteria? Okay.
We looked at this bill when it came out a couple years ago, and it's clear that it says that you have to mandate, the governing board has to mandate. It's not a choice by the school.
Okay.
So it really would be as if you mandated uniforms for all of your elementary schools.
Okay.
If you said you had to do it, then we could get the money.
Okay. So what I would ask, this is on page 11 of 18, the Florida Department of Education, Florida Diagnostic and Learning Resources System. Is this a new grant, or is this in other words, will these be more resources, or is this reoccurrence of a prior grant? It's reoccurring, so these aren't additional new resources. I was just excited if we were going to have another $1.4 million we didn't have before.
This is what they call FIPPers?
Yeah,
Yes.
this is the
This is the
renewal of
fiddler.
This is the
existing
renewal of
funding
that.
streams.
Okay.
This is
It
not an
didn't say it
additional
that. It
funding
didn't
stream.
say it that way. It just showed as requested. So, and then my last one, I just have to point out, and I'm not going to go through the whole list like I normally would, but I do have to say the pre-apprenticeship and apprenticeship grant for $263,000, which is going to provide the services for 12 of our students, is extremely exciting. We keep going down this direction of apprenticeships and pre-apprenticeship programs. So kudos to staff for continuing to expand and develop in this area. We went away from it for a long time, and I'm very excited that we're going down this path again and expanding it with every opportunity. I didn't see a lot of information regarding specifically what areas this was supporting. If we could just get a follow-up, I don't need anything here. Just, it's a curiosity for me. I've been trying to track this, and it would be great if you could just let us know a little more detail. Thank you.
Thank you, Ms. Korn. Any additional comment from my colleagues? All those in favor of item EE1 indicate by saying aye.
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 Those opposed say no. Item EE1 passes unanimously. May I have a motion and a second on item EE6, please?
So moved?
Second.
Moved by Ms. Corn, second by Mrs. Aladeff. Audience input on item EE6. I have Ms. Levinson and Mrs.
Yes.
Aladeff.
Just a quick question. I know I've mentioned this to Mr. Bradford before. How are we ensuring that the schools are identifying all the students with need and distributing devices?
Good evening, Matthew Bradford, Task Assigned Chief Information Officer. Tomorrow we're sending out a pivot memo as far as the project or the process is concerned, as far as the application process goes. Then we'll actually have some interaction with the PIO office to communicate to those incoming ninth graders at those schools, high schools, as far as the application process and what that looks like. We'll then go to the actual schools. We'll have posters in cafeterias, and we'll spend time at those schools to actually talk to those individuals that are interested in taking advantage of the program.
Okay, and is that new, some of that, to go out directly to the schools? Because I will tell you that my mentee, who was
Yes.
in ninth grade this year, did not know anything about it
Yes.
until I mentioned it to her.
Exactly. So we're looking to improve our communication process. So we'll work with Dr. Wanza to make sure we do that as well.
Okay, thank you.
Thank you, Mrs. Aladeff.
So, basically also like what Ms. Levinson said, I had the question of how are we ensuring an equitable opportunity for all students, since there's only 12,500 smartphones, tablets, laptops, hotspot devices. So how are we ensuring that it's equitable, that the students are having the opportunity to possibly receive these devices?
Okay. So as far as our communication process is concerned, all those individuals that want to participate in this particular project have not been turned away. So we haven't had anyone turned away since we started this project. This is the third year of the project. The first year we had 2,500 devices allocated to us, but we only had about 1,900 or so individuals take advantage of that particular program. The second year, we had about 800 or so devices allocated to us to cover the actual need. It was less because we had less applications. So we haven't run into a situation where we've had more applications than we've had devices. So we don't necessarily foresee that, but if we do, we'll go back to Sprint as far as that number is concerned.
Okay, so let me rephrase my question. So if students don't know about this, they won't apply for it. So this is for 9th through 12th grade students, are we making sure that we are going to all of the high schools to make sure they have the opportunity to apply for this?
Yes, yes.
Okay, thank you.
Thank you. Any additional comments on item EE6? All those in favor of item EE6 indicate by saying aye.
Aye.
All those opposed say no. Item EE6 passes unanimously. Ms. Bartleman, are you still on the line? May I have a motion and a second on item EE7?
So moved.
Second.
Moved by Ms. Corn, second by Ms. Good. Audience input on EE7. Seeing none, I have Mrs. Alhadeff, Ms. Levinson, and myself. Okay.
So on page 2, 16-120H, district-wide, we are looking to pay $475,000 for bottled water. Who is getting that bottled water? Where is it going?
Good evening again. Mary Coker, Director of Procurement and Warehousing Services. Thank you, Ms. Aldeff, for your question. So I think what you're looking at, and I think you may not be familiar with this document, per policy 3320, the superintendent has the ability to award less than $500,000, or let me not say award, let me say purchase, up to $500,000, which is what this memo is. So this memo was from back 2016, and the reason why we included this memo on the item is because when we bring what we call post-board items that had been previously approved by this post-board memo, we like to show the board how they came to fruition. So this document, which you are referring to, this bottled water contract, for $475,000 really has nothing to do with this item, other than the fact that it was included on that list of all the other contracts that we had purchased for. So I don't know if your question was related to the fans, that is what we're bringing today, or if your question is related to water, I can be more than happy to also respond, because I'm prepared to respond on the water as well, though it's not part of this item.
You can follow up with me, that would be great. I'd like to understand where this water is going.
Okay.
Thank you.
Thank you.
Thank you. Mrs. Levinson?
My question is on the bid page here. I'm looking at a couple of these items, and I see that one has more of a discount than the other. They have A's next to them. I have no idea what those A's mean, and I'm looking to try to figure out, but I don't see any kind of key here anywhere, like item 8 and item 17, for instance.
I guess would be awarded.
They don't have A's.
My guess would be awarded, but that's just my guess.
I'm sorry, Ms. Levinson. I apologize deeply.
Please, guys, please. It's late. Item 8, let's take item 8, okay?
You mean item 8?
Item 8 on the bid sheet, when you go and you look at the various items awarded.
2 of 2.
Item 8. When you look at the discounts, there's a different one awarded than the higher discount.
The A's do refer to the awardee. You can match it on the bid tab.
Mr.
Rick,
Bays,
if I understood your question, my name is
just
Sam
making sure, yeah,
Bays.
making sure you're
I
speaking into the
apologize.
mic. Thank you.
So then is it incorrect on the tabulation page?
No, the A is to the right of it.
I understand.
Oh.
I am
Well, that's
able
the
to read it.
highest
Yes.
discount.
Okay. I'm trying not to get into discussing the vendors here, but when you look at 8 and you look at the A, it's next to a different vendor than on the front of the page where the recommendation tabulation is.
If I could just be helpful and say the numbers in the Excel spreadsheet column 1 through 31 are not the numbers, it's the item number in the next column that you need to look at.
Yes.
The far left column, forgive me, the far left column is not the item number.
So you have the bid tabulation, which is awarded to C. Stewart, and then the awards are items 6, 15, and 17, which are
Confusing.
item 1.
Okay, that doesn't make a lot of sense. I think you need to get rid of the ones on the left-hand side.
Yeah, it's a spreadsheet.
Sorry.
I'm
but-
sorry.
Okay. All right, thank you.
Was that the extent of your comment?
That was the extent of my comments.
Okay,
Thank you.
I have some questions. So, this is a post-board item for contracts less than 500,000. But when the spending authority was increased, then the spend was 745,000 through this contract, is that correct?
That's correct.
Yes.
Okay, so I guess as a board member, I have a question about if we have a post-board item that has an amount that's below 500,000 threshold, but we increase a spend authority that takes the contract over 500,000, I don't know how that's in compliance with policy. And then secondly, on the financial analysis worksheet, where it indicates an awarded vendor and an amount spent, then at the bottom, it has e-card spend, which doesn't delineate with which vendors the spend is being made. So conceivably, one vendor could be getting more than the $500,000 worth of spend, which would be highly problematic.
So I can explain.
Thank you.
So policy allows us, for the superintendent to purchase up to $500,000. And the practice is that if we identify a specific contract that is going to be over the $500,000, we must bring it to the board for approval, which is what we do. So we are bringing this item to request additional spend authority. So that is common practice. Any post board that's brought, and normally we do not allow for post boards to extend. We like to go out to bid, but when we feel that the pricing, in this case from the due diligence that was done and the favorable surveys that we received, we felt that it was in our best interest to continue with these prices because they would not be elevated. So that was one of the reasons, but we have to come to the board, which is why we're here. And to answer your question, that's a great point on the financial analysis worksheet. So indeed, when we capture purchase orders to this vendor that is mentioned here, C. Stewart and Associates, we've issued $167,000 on purchase orders. The remaining, which is $526,000, was on P cards, and I actually requested a list of those, and moving forward, I've asked my staff to ensure that when we do have P card expenses with vendors that are not, that we can't show, that we have that breakdown. I did request it, I have that on my email, and basically it was between the two vendors, and it was basically it was divided amongst the three vendors, basically the same amounts. So it was kind of well balanced, the remainder of the spend. And I can, through the board, through the chair, I can, through follow-up, provide you the detail of those expenses through the P card.
Okay, because I was concerned when I looked at the page 2 of 2 that we were just looking at with Ms. Levinson's question, with all of the awardees in the one column for one entity, I thought it could force the spend to one particular vendor, and we wouldn't be able to see that because it's located just as a P card spend.
So please notice that this financial analysis worksheet is statistics, meaning it's actual spend. If you look at the item, we're bringing forth a renewal, and we're only renewing one of those vendors. Just want to make sure, wait, I'm not confusing it with the next item. No, it's the next item that we're only renewing one of the three. I'm sorry, we're renewing all three. I'm sorry. The next one is similar. We're not renewing all of them. So yes, indeed, I can provide you the backup for the P card expenditures, and you will see the breakdown of the expenses for each vendor.
Okay, so let me just make sure that all of my questions.
So they would not have exceeded, I think your original question was over the 500,000. It would not have exceeded the $500,000 threshold.
No single vendor would have had purchases exceeding 500,000, is what you're saying?
Well, no, the entire ITB, the entire post-board approval of that contract would not have exceeded the $500,000. It's not per vendor, it's per contract.
Say that again?
Okay, so, I'm sorry.
No, take your time.
Okay. This ITB was awarded, the original ITB was awarded for $500,000, or $490. When we came to the board and requested to approve the, hold on. It was originally 450 and we're asking for the 265, yes. Each vendor would not go over the 500,000, I'm sorry. That's the correct answer.
Here's where I'm having difficulty, right? So this is one contract, right? Yes?
Yes, ma'am.
And one service with multiple?
Yes, it's not necessarily one contract because they're different vendors. It's a catalog bid, so it's a commodity. Therefore, under this ITB, we've awarded 3 vendors.
Okay, so I guess the question to Ms. Myrick is, with an ITP that's awarded to 3 different vendors, then how does the policy interface with that with regard to the limit that is allowed to be post-board?
Well, the superintendent can approve up to $500,000 for the spend of, for this example, fans.
For the ITB.
Even though, yeah, the ITB, even though it will go to 3 vendors, it's some division of those.
Right.
I think that what we're looking at that spreadsheet is obviously North American exporters had a lot more types of fans than the other ones did. And
Yeah, but Ms. Coker indicated that the spend was evenly split between the 3 entities. My concern is really that, so we approved, the item was administratively approved by the superintendent through a post-board memo on July 21st, 2016 for 3 years, from July 27th, 2016 through July 30th, 2019, with an award amount of $450,000. This bid was presented at the school board operation meeting of May 8th, 2018 for a request of additional spend authority of $295,000, bringing the total amount to $745,000. That wasn't a renewal
So-
to the contract, that was just
Well-
an additional spend authority.
Well, there's not a contract with ITBs, that's the issue. They're more done through purchase orders and through like P cards. So you were approved after he did the initial spend of $450. They didn't spend any more money than that until they came back to you and got the additional spend for the $250.
Exactly.
So, and now they're coming back to you and asking you for an additional spend of $265 before they do it. He could only do that initial under the $500,000, but now they need more money, so he's not approving, he didn't approve the $295 because it's under $500,000. They had to come back to you on the same ITBs for the $295 and now the $265.
And now we're asking for an additional spend authority as well as the renewal, which also has to be board approved.
Because the renew, you're right, the renewal is, the first one ended on this ends this next month. And so they're asking you for a continuation of what, 1 year? For 1 year.
Through 220.
In advance of the time.
Okay, well, so I'm having difficulty understanding where the $500,000 threshold is gonna come into when we're using ITBs and we're exceeding by adding spend authority and then a renewal of a contract with more spend authority. We've never,
The $500,000 only comes in when the superintendent does that in advance. You approve that $450 after he already spent it. He already
Correct.
made that approval. The other two,
You're approving them.
you're approving in advance. So it is like approving a contract in advance. You approved the $295, and now you're approving the $265 prior to the expenditure.
okay, and before it was only a spend authority, and this time it's a renewal and a spend authority.
Right, this $265 is the spend authority and the renewal for 1 year.
And the reason why they're doing a renewal again is for the favorable pricing.
Okay, so, I guess I would like to have some more conversation about how these ITBs are used and what we do, like for additional spend authority and why we do it, to have a better understanding and to make sure that we're really following policy. And then, I wanna know, when we have those P card purchases, that breakdown, I think, is important for us as a board to be able to see. So we know which entities are receiving the dollars.
For sure, we have the breakdown. Again, it's a little bit of a manual process because we have to obtain the different vendors from the transactions, but it's feasible. It's something that I've discussed with my staff today to make sure that we include it. And going back to the ITBs and further conversation, I've had extensive conversation with Mr. Vignola about how we are going to continue with post memos. And one of the options is moving forward, anything that had come, because see, these are old that we're identifying now after 2, 3, 4 years. They're coming back to the board about not going out, but going out to bid and no longer renewing post-board memos, but going out to bid regardless, just kind of setting some more standardization across post memos. So I'd be more than happy to further speak on the topic
Okay.
through a follow-up or however you wish.
Okay, thank you. Ms. Bartleman, are you on the line? She originally indicated she had a question. Any of my colleagues have a question? Ms. Good.
So just very quick, so is the expectation that we're going to go out for another ITB after this, during this time period, during this renewal?
Yes, for sure.
Before the expiration of this renewal, yes.
Before July 30th, 2020.
Okay, thank you.
Thank you. Any additional questions from my colleagues? All those in favor of item E7 indicate by saying aye.
Aye.
All those opposed say no. I have a motion and a second on item EE8.
So moved.
Moved by Ms. Korn, second by Mrs. Alhadeff. Ms. Levinson, I'm sorry, audience input on EE8? Seeing none, Ms. Levinson?
Yes, this is the one you were talking about, Ms. Coker. This is the one where it's awarded to a vendor, both alternates are no longer pre-qualified and are not considered for renewal.
Yes, that's the comment I
Yes.
made. I confused her with this
So I
item.
have two questions. First is, why do we proceed with what just one vendor? This way, it says, since the start of the contract term, both alternates have not been. The start of this contract term was from July 31st, 2016. So we've been using this one vendor for 3 years, is that correct?
Yes, so part of the process for pre-qualification is when they respond to a bid, they have to be pre-qualified at that time. So if they would have responded to this bid in April of 2016 and they chose not to renew their pre-qualification status.
No, I understand why you did what you did with those two companies, but why did we proceed after 3 years of just having one company now with a renewal with the same company with no checks and balances in there?
Why did we not go back out to rebid?
Hold on. So I have here in my notes, again, part of the due diligence that we did as the staff conducts. There was favorable surveys when discussing this item with the end user. We have them as far as PPO's recommendation. Mr. Bays, I don't know if there's anything specific. Your team is the one that uses these, plus the fact that you're going to get refurbished 2 elevators. Is there a specific reason? I know that we collaborate on needs of the district, but I know that from my staff, the due diligence was on the pricing as well as the favorable surveys. Not sure if there's anything you can add to that, Mr. Baines.
Mrs. Coker, we feel that Expert Elevator provides us good service. My staff is well pleased with the response they get when they contact them. It is a difficult service to procure.
Yeah.
We understand that we do need to continually try the market, and we will go out again, but we would not have been clamoring for a new vendor at this point.
Yeah. And if I can just add.
So I just don't want to get back to using a single vendor again. This was 3 years with the single vendor, and now we're renewing it with the same vendor with no checks and balances.
Your point is well taken, and I think with the certification requirement, we would anticipate that even if we would have gone out to rebid, given that you have to be pre-certified, given that we have limited number of vendors certified in this area, we would have ended up with a small number of responses. So given...
But at least you would have done it.
Right, that's correct.
That's what I'm looking for you to do it.
Okay, I can respect that. And I think just given the survey responses and the pricing, we just made the decision, the business decision to move forward, but your point is well taken. We could have went back out to market and got the limited responses that we would have been anticipating, but at least we would have gone back out.
And if I may, Ms. Levinson, it's important to note that, you know, our team, you know, the procurement and warehousing services staff, you know, always challenges the end users to ensure that we are looking at market trends, that we are going out to bid, that we are considering why do we have to continue to use the same vendor, right? Those are all part of the service that we provide to our to our end users. So it's a collaborative effort. And, you know, as a business decision, this and as some of these other ones that we've decided to renew have made sense. Where it doesn't make sense, you'll see that we've actually gone out to bid and we've rejected bids and then we've renewed, because when we did go out to bid, you know, it wasn't favorable pricing or we didn't receive responses. So that's part of the decision making that we make. And, you know, as subject matter experts, we try to do our very best to ensure that we are doing what's in the best interest of the district. And in this case, I feel that this is the best. But to make you and the board feel more comfortable, all of these that we're bringing to the board with renewals that are going to expire in 2020, we are definitely going to be going out to bid.
And if it comes to fruition, what Mr. Bay says, then it comes to fruition. There's no harm. There's no harm done in putting it out there to see what we can get. So, and I know you've done that a lot, so I just don't want to see us.
And we have a
reverse
specific
it.
campaign. I'm being asked to mention it by my colleagues, but we have a specific campaign related to elevators for pre-qualifications, which are going to allow us to, that when we do go out to bid for pre-qualification certifications, we are targeting campaigns based on trades, and elevators, one that I know that is always brought up with pre-qualification certifications. So this is one that we're targeting closely this year. Therefore, when we come back out to bid, for sure we should have more than 1 or 2 responses.
Thank you. And also, these are large contracts, so when we're talking about sizable amounts like this, thank you.
Thank you. Ms. Good, did you have a comment?
Yeah, maybe I'm a little tired. So on the, when you say when you go out again, is there a reason why you did repair of elevators and wheelchair lifts as one?
They tend to be related services, similar expertise, similar trade skills in the companies that do them.
I gotta believe that you may have more repair of elevators than you would, I mean, don't you think you'd get more vendors if you split it up?
I believe that we have A and B, and you could.
You could bid for either?
Let's look. You could win one and not the other.
Yes, one of them is for repair. The way it's broken down, I'm looking here. Where's the doc?
So you had them split, they could bid for both or bid for one or the other?
Yes.
Okay, thanks.
Thank you. Any additional questions from my colleagues? All those in favor of item EE8 indicate by saying aye.
Hang in there, Ms. Franklin.
All those opposed say no. Item EE8 passes unanimously. May I have a motion and a second on item EE10?
So moved.
Moved by Ms. Korn, second by Mrs. Alhadeff. Audience input on EE10? Seeing none, I have Ms. Korn.
Thank you. So I know that several of our SMART programs included the athletic tracks. So I guess I'm a little confused as to how are these coming to us outside of, like, we identified which tracks needed to be done. Those were in the SMART.
Mm-hmm.
So why are these now coming to us?
I can either allow my colleague, Mr. Sarah, to speak to that, or I can tell you that we had the tracks surveyed. Of the 28 tracks in the district, 12 were done under SMART.
Right.
Of the remaining 16, 14 will need to be resurfaced within the next 5 years. Some are still quite challenged. So we have work to do on tracks.
All right, I'm sorry, say that one more time. So 12 were already done. I saw that in the
12
numbers.
are already done. Of the 16 remaining,
Yeah.
14 do require repair within the next 5 years, including complete resurfacing. Sean, is that an accurate? I got that one.
Right, within the next 5 years. So I
Yes.
guess I'm wondering, why are we doing
I had a
it
comment
now?
on E10.
Okay, Ms. Bartleman, yes, but someone's speaking right
Okay,
now.
so my one comment
Wait.
was just so we have.
Excuse me, Ms.
before-
Ms.
when
Bartleman,
we-
hold on just
yes.
a minute, please. Ms. Bartleman, someone else has the floor.
Oh, I apologize, I couldn't hear, I'm sorry.
Thank you.
So my question is, and this is, I think, probably a bigger picture. So something I had brought forward there are some other improvements, right, for our athletic, such as the screens at baseball fields and softball fields. How does this rise to that level? So I guess I'm looking for leadership to tell me why this is being brought forward. And I'll be honest with you, in our CTASE department, Mr. Bays, we've talked about this, there's a need at a specific school to be able to just finish a $50,000 grant that was brought to us, and PPO in the past would have been able to spend those dollars, and right now it's frozen, so we've got $50,000 of equipment that's just sitting there idle, waiting to be implemented, and PPO doesn't have the opportunity to spend those dollars. Tell me how this project is being identified. If there are 14 tracks that have somewhere in the distance of 5 years to spend, why are these the ones that are coming forward and being recommended? Big picture. So happy you're with us.
Sean Serra, Director of Athletics and Student Activities. The life expectancy of a polyurethane track is anywhere between 8 and 10 years. When we did the original needs assessment back with the Smart Athletics, there were 12 tracks that were identified, and those tracks, as you know, have all been completed.
Yeah.
So most of the tracks that are failing right now were resurfaced in 2011. The specific, I call them the big five in our world, is Piper, we have Coral Springs, we have Nova, Blanche, Ely, and Cooper City. Those are immediate tracks that within the next year or two are going to need complete resurfacing. As far as the vision is concerned, we did an analysis of all 28 or all 29 tracks within the last 6 months. We have a standardized report so we know what we're looking at. And the goal was not to bring a big number to you guys when it comes for an ask for capital dollars to resurface the tracks. We felt like the best approach would be to go as a needs-only basis so that when we know that the track is about 6 months to a year out, that we definitely need to resurface it, we would bring that specific school and track need to the board for approval. And then we also have annual repairs. We have track patching, we have areas that water gets underneath them where they lift. We have holes, we have miscellaneous stuff that happens, and that's where Sam Bays' funding is coming in.
Okay. So I guess what I'm asking, Mr. Runcie, is for a bigger, so I appreciate that. So thank you, Mr. Sarah, that's very helpful. But when we look at our overall needs, is the reason this is coming forward and not some of the other things that are related to athletics is because tracks is the #1 priority in terms of what needs to be taken care of at our district. Do you see what I'm saying? In other words, it would be helpful to know what is the priority in your department from athletics if there's going to be a $1.6 million spend, knowing the 12 most critical have already been replaced, and let's say you tell me that there's 5 more that really are the critical, the top 5 that you just mentioned, then it would make sense to me that those 5 are the ones the board would potentially put money into at this point and not put money aside for all 14, because there might be other things that we could be spending some money on that we would put into PPO that are critical needs now, like maybe those top 5. Does that make sense? I feel like we need to spread the wealth a little bit in terms of what we're accomplishing.
I'd like to interject.
Yeah.
Lots of people want to talk.
I just want to try to help us move along. So this is just the vehicle to procure those services. This is not the approval of those capital projects, from what I hear staff saying. So all this is the vehicle with which to be able to repair tracks, and then through the capital budget process, as we prioritize all of our needs, should we prioritize some track resurfacing, like the ones that Mr. Sarah said may come up in the next year or so, this would be the vehicle. So you're not approving those funds to be allocated, to be spent per se. Just
on the executive summary on the last, before the last paragraph, it states funding for resurfacing of these 14 tracks will need to be requested and approved by the school board on an annual basis as special projects, most likely for 3 tracks per request. So the
I
funds,
read that.
Yeah,
and so I appreciate that. I read that. But for me, again, it's a matter of, well, then why not bring forward something and say we're going to put up new netting at every baseball field if we're not making a commitment to doing it?
So
Why
to
don't you bring us that
your
number?
point, Ms. Korn, I think what There's going to need to be track repairs.
Yes.
That's going to come out regardless of whether we resurface, which is the big ticket item here.
Yeah.
So I think what I hear you saying is, why are you coming with such a large spend authority right now?
Yes.
Why wouldn't you come with a smaller spend authority that would be able to deal with repairs? And should the board allocate funds within the capital budget, then we would need to come back and get the spend authority to then do that resurfacing projects.
Yes, again, that's for me what checks and balances are for between spend authority and the contracts. I don't think there should be gaps, large gaps. I think our spend authority request should be close to what we anticipate the contract to be in a period of time. And I know that we said this would be potentially over 5 years, but in that 5 years, I think there are many other things to tackle. And so if we have a large spend authority for this, I feel like that's making a statement that the district and this board is aligned with the idea that this is the direction we want to go in spend on athletics. And that isn't necessarily, that may be the case, but I would want you all to come to us and explain to us why that's the direction we're going first, rather than some other avenue.
One last fact, just to clarify. What this 1.6 million represents is our best guess at the repair cost of about $10,000 a month that PPO would incur.
I see.
And the sum of what is currently planned in the DEFP going forward, $200,000 a year. FYI, that does not in any way emulate the costs we will incur to do if we were to do those 14 tracks. There would be $4 million more required if we were to do all 14 of those tracks. That money is not included here deliberately because we don't have a means to fund it at all.
But so the 200,000, the way I read that, it doesn't say it's 200,000 per track. It says it's 200.
Per year.
Right, per year. But that would be, and the intention is there would be 3 tracks per request. So there's about 3 tracks for every 200,000?
That's not included in the 200. The 200 comes from the athletics budget, which is being added to this spend authority. So the money is coming out of both PPO and the athletics the athletics department. So there's 2
Okay, I don't want to belabor this. We've been here a long time. Mr. Runcie, what I'm asking is that we get a bigger picture. In athletics, there are a lot of needs. If you could just assist us in being able to see your vision in your department through your senior staff about where we will be focusing our dollars when we spend them there through the spend of PPO. So if this is where you want to go, that's fine. I'm not saying I can't support it. What I'm saying is I would like us to have a vision of what we're doing in this department, and then we can say this is how much, and the spend authority should align with where we see that vision and what we see we're spending in that 5 years. Otherwise, just ask us for a 3-year spend authority, and then tell us where else we're spending that money in those 3 years potentially. I just want things to align a little bit more specifically, and I'd like to see a larger vision around it. I know there's a need here, so I'm not trying to minimize that. I just want a bigger picture. And there are some other items in PPO that I know we need to address, some athletics, some related to other areas. So, thank you.
Thank you, Ms. Korn. Any additional comments from my colleagues?
Yes, I just wanted to ask for the record if the way we bid it and priced it is, we did have an audit about the asphalt repair, and I wanted to make sure that we're complying with all the recommendations in that audit with this new bid.
This is not a new bid, but yes, indeed, this does comply with the conditions in the asphalt audit. There's no conflict at all.
So if I may add to that.
Thank you.
Okay.
Any additional comments from my colleagues? All those in favor of item E10 indicate by saying aye. Aye. All those opposed say no.
Aye. No.
Okay. Let the record reflect that Ms. Bartleman was on the line for the vote. Okay, let's look at what we have here. I don't think we can take them all. I don't know. All right, so we're gonna take them all. Items, may I have a motion and a second on items EE 11, 12, 14, 15, 18, 20, 20, and 23. Moved by Ms. Good, second by Ms. Korn. Audience input on those items that I called, EE 11, 12, 14, 15, 18, 20, 23. No? Any comments from my colleagues? I have lots of marks all over my paper, so if you have something to say, please raise your hand and go ahead and talk to your items. Go, Ms. Levinson.
make it very quick. I'm just gonna, on item EE12, why must it be awarded to the 5 lowest bidders? I've never seen that before. Meaning 5.
Give me 1 second, let me look at my.
All right, I'll go to the next question while you're looking. EE14, this would be Mr. Bay's. Why are these broken down into groups with all 4 types of schools together? Because when you look, there are some vendors that are cheaper in certain types of schools than in other types, like centers and administrative buildings. There are certain vendors that are cheaper there and others in elementary, middle, and high schools. Why do we do it as a group instead of getting the cheapest vendor to bundle a different way?
Mrs. Levinson, the decision to group the vendors, I believe, is based on the desire to be able to manage this effectively. We have never had this broken down by school type. It has always been grouped into the entire area. So I cannot
Okay,
speak to
if we're
trying to
saving
fracture.
money, I would like to have us look at it that way. It's not very difficult to track if one vendor's doing centers and administrative buildings and another's doing elementary, middle, and high. I mean, it's all about us getting the most efficient and effective services.
If I may add to that as well, one of the analysis that we did, not only from a logistical perspective, and administrative as well, from having the same vendor provide the same services or the different services. The idea is to leverage the spend to be able to see some.
That's not leveraging when you see that one vendor is cheaper in certain areas than the vendor that you're contracting with.
Yes, agree. And when we group them overall, the benefit is that indeed the vendor that we've chosen is overall, with a combination of the groups, to be the cheapest and the most effective.
That doesn't make sense, so it doesn't make sense. You don't, if there are parts that you can pull out and are still gonna be cheaper for us to do it that way, we should be looking at it that way.
So then we need to look, and that we need to begin to then consider, and this is an exercise that we do with the user department, is to consider not awarding by group, but maybe awarding by line item, which can.
I don't want to get into every line item, but when you look at certain things, and there are 6 different types of schools, elementary, middle, high, technical schools, centers, and administrative sites. When you look, and maybe a vendor is strongest in 2 of them and another in 4, you pick them that way. That's not something that's really going line by line by line. You have to look at what the individual contract is and what makes the most sense.
And I agree with that, but when you look at the sister districts, because we did this analysis and we looked at our sister districts, Mr. Clementon, we see how our sister districts also have this, and it's grouped the same way. So we're not necessarily doing anything different than by grouping it this way.
That
Again,
doesn't mean they're doing it the smartest way. So
we'll take that
that's all.
feedback and we'll begin to look at how we can ensure.
And I'm
take
not
your
talking
consider-
line by line by line. That would be impossible. That's not what I'm talking about. But if there are savings you can see by grouping a little differently, then perhaps we group them a little differently.
Point well taken.
That was my suggestion.
Thank you.
So if we can, through the chair, if we can go back to EE12, you asked about the 5 vendors
Yes.
being awarded. There were actually 4 bids that were received on this and 2 were rejected. So it was actually awarded to 2 of the vendors. There is a sentence under the procurement method that mentions basically if
That's what I'm asking you about.
if there
that
were
sentence.
more if there were more than the 2 bidders that we awarded to that were responsive and responsible, we would have encouraged them to go up or add vendors in a way to encourage more minority participation on this particular bid. Fortunately, one of the bidders that was awarded this is a minority bidder, so we feel like we met the
Okay,
MBE
so
participation.
that's why
It was an
that's put in
incentive.
there.
That's correct.
Okay. All right, thank you. And the last comment was just on EE 15, on the playground equipment. P-card spend of $240,796. I'm perplexed why we'd have P-card spends on those type of materials instead of contracts.
That would be entirely a matter of the ordering. We went and ordered material, and it was purchased that way.
Why?
Because the vast majority of the purchasing done by the price inventory clerks is done on a P card. They believe we expect that we're recouping a savings. I think P card's encouraged. Mary, you want to?
Yeah, so basically how it works is this request comes in from PPO through the stock room, and the price stock inventory clerks, what they do, and these are called direct outs, normally, depending on the requirement or the need of the item that they're purchasing, P-card is a method of payment, but P-card is used when there may be a need that might take longer for us to purchase through the issuance of a purchase order and a check paid, et cetera. So there are items on this and many other bids that are paid by P-card, and we control that through the bid. That's why we're able to identify the spend.
Ms. Levinson,
So you're
were
saying
you-
it's
were
to
you
our
looking at
advantage?
15?
I'm on 15.
15?
Yes.
11,758?
Yeah, I have the FAW here. It shows $240,000 on P-card spend. Yes.
There's 2 pages, the front and the
Forgive me.
back.
There are two pages.
There's 11,000 and a 240. So indeed, yes, that is a process that is overseen by my department, where we issue we make the orders, and we are paying through P-card.
Okay, and then, to Ms. Brinkworth's point earlier, I'd like to see those spends on here as well. I think that would be good practice to get into putting those on.
That's a great point. Moving forward, I'll have my staff make sure that we do have P-cards. We will include as much information as possible per P-card spend.
Okay,
per
and then my
vendor.
last comment is, I've mentioned to Mr. Girardi with school choice enhancement, we have some playgrounds that are taking a year. They still have not been permitted. If they are companies who are on here that we are continuing to do business with, and it's taking them more than a year to get the permit, I would like for us to look and look at these companies and see about their performance before we continue to put companies on where it's taking that long for the playgrounds to get done. Thank you.
So we'll take that as a follow-up.
Thank you, Ms. Levinson. Mrs. Aladev?
Yes, EE 11. So I just would like to try to understand that, so are we required by the state law to pay almost $2.5 million for private school professional development for teacher safety, security, social, emotional learning?
Good evening, Dr. Cohn, Director of Teacher Professional Learning and Growth. The answer is yes. Statutorily, they receive a proportion of the Title IIA funding, and so their base allocation comes out first before the district gets their allocation. So this portion that you're seeing is their allocation that they get for professional development.
Beth? Okay, EE 18. So again, so we're required by state law to pay $12 million regarding the implementation for Title I services.
Correct. The school district serves a pass-through to the schools that resident children attend, even if they're at a charter school, or private school, excuse me.
And how do we, I mean, I guess, I don't even know if we decide this, but how do we know that they're implementing and delivering these Title I services with the $12 million we're providing them?
We do not know, nor are we expected to know. What we are expected to do is to pass the funds through to the schools.
Okay. Yeah. Okay, EE 20. So we are spending $87,975 to repaint the Casey Wright parking garage.
Yes, ma'am.
And why are we doing that?
We've been actually cited by the city a number of times for the condition of the paint on this building in the parking garage. And it's only been by a lot of professional courtesy that we've been allowed to remain in this condition at this select location. More than that, the preservation of the asset demands that we waterproof it. This is more than just cosmetic. This is the integrity of the structure. And it does include the painted surfaces of this building as well as the garage.
Okay, so are you saying that we will get fined if we don't paint it?
I'm saying that we have been cited. I can't say that we would be fined. But the city has complained about the condition of our building now for years.
And Mrs. Aladeff, I would just add that the funding for that is totally generated from the revenues from the surface lot. So we're not using general fund revenues in order to do this. And as Mr. Bays mentioned, at this point, it's so beyond the cycle, it's really become a preservation of asset. And if we don't waterproof it, the damage, the cost or the investment that the board would need to make in the future could be much greater than repainting it.
Okay, thank you.
Thank you. Ms. Good. EE 23. You're welcome.
Thank you, Madam Chair. So just a couple of comments on these. So I noticed that the agreements aren't signed. Don't we typically get the agreements on these SROs signed from the other side first?
Didn't hear.
It's a SRO thing, not a... Mr. Bays, you can answer the question. Please, feel free.
Craig Kowalski, task assigned Chief Special Investigative Unit. Typically years ago, so over the last 2 years, we have brought these agreements to you unsigned, with the knowledge that the cities are not changing any language. That's why legal has signed off on them. So for example...
So how do we know they're not going to change anything?
I can tell you on like the city of Coral Springs, it already went to their commission on June 5th and approved. Town of Davie went June 5th. City of Lauderhill went June 10th. City
Right,
of
so
Margate,
since
right.
they went already, how come we didn't get them signed?
Just like our process, it takes a while to get the actual documents, the physical documents back.
That's fine. And then my other point was with BSO. So BSO is providing the services for a certain list of municipalities. But the agreements that we get, BSO is the only one that signs it. I don't see any signature for the municipalities. So my question is, and I never noticed it before, so I apologize for bringing it up. But my question is, how do we make sure that the municipalities that are getting the services are aware of the commitment?
The agreement is with the sheriff's office who provides the services.
I understand.
So
I just want to make sure, though. So let's say BSO is providing the service for Cooper City. I think it's really important that we have some kind of link of communication with that municipality so that all those that are within that municipality understand that there's a commitment that's been approved by the school board. I tell you this because information doesn't always get relayed. Sometimes the city officials aren't aware of all the details that we have an agreement with BSO, and BSO in turn is providing. I know this is only for a small summer situation, but I think, and I would say to Mr. Moquin, since I know you deal a lot too with these agreements, I think it's important that the agreements with BSO that are providing a service to another municipality, that there be some kind of acknowledgement from that municipality that that they understand that we're getting the service within this, for the schools within their cities.
So, what,
I know it's
I think
late.
what
Maybe
I-
I'm not explaining.
No, I think
get
I think what you want is for us to send a copy of the agreement to the respective city managers in each of the municipalities, just to let them know we've executed this agreement, so they can align it with what their understanding is.
Right, so that way the
we'll work
respective
to-
municipalities know.
We'll work through our legislative affairs department to identify those individuals and have them send those contracts out to the city
And not just the
managers.
city managers, but the elected, so that they're aware that we've entered into an agreement with BSO to serve, you know, the district's gonna be paying BSO, so in turn, BSO is probably going to send information to those cities. I just wanna make sure the cities get information from us as to what services we're paying for within their municipalities. So they're
Directly
aware,
from
just
us.
like a checks and balances.
Understood.
You know what I mean? Because I'm sure BSO is going to share with them what it is, but I think it'd be nice that it comes from us. So if we can't include the city within the agreements, I'm going to ask that some kind of acknowledgement occur. And I don't know how that takes place, maybe through a memo, like Mr. Runcie said. That's it. Thank you.
Thank you, Ms. Good. My comment will be quick. It was on EE 15, ditto to what Ms. Levinson said with regard to the playgrounds. And also, if we could just get follow-up for the number of playgrounds that we currently have scheduled to deliver through smart school choice enhancement votes that have already occurred, and then the number of school choice enhancement projects that are still waiting to be voted on. You don't have to tell me now. Just a follow-up would be great. Okay, any additional comments on those EE items? Seeing none. All those in favor of items EE 11, 12, 14, 15, 18, 20, and 23 indicate by saying aye.
Aye.
All those opposed, say no. Those items pass unanimously. Ms. Bartleman, are you on the line? Okay. May I have a motion and a second on item F2?
Move.
Moved by Ms. Good, second by Ms. Korn. Audience input on F2. Colleague input on F2. It was pulled by Ms. Rupert. All those in favor of F2 indicate by saying aye.
Aye.
All those opposed say no. May I have a motion and a second on item FF1?
Move.
Moved by Ms.
Second.
Korn, second by Ms. Good. Audience input on FF1. This item was also pulled by Ms. Rupert. Any colleague input on FF1? Seeing none. All those in favor of FF1 indicate by saying aye.
Aye.
All those opposed say no. Item FF1 passes unanimously. May I have a motion and a second on item I1?
So moved. Second.
Moved by Ms. Korn, second by Mrs. Aladeff. Audience input on I1. Seeing none. Ms. Levinson?
Yes. I know it's late, but this is a really serious item. Mr. Runcie, I would like to ask you to take this back and have further discussion and review on this item. This item has to do with sexual harassment. I have zero tolerance for sexual harassment. We have had this discussion as a board. A couple of weeks ago, we had an incident with a teacher. And I know I've had discussions with you, with Chief Kowalski, with Mr. Katz, and with Ms. Myrick about bringing the policy back. And I've been told that, or not bringing it back, but bringing the policies to us to put zero tolerance measures in those policies so that these type of things aren't able to happen. We are about protecting our students, and when we have multiple students come forward about a teacher in a school, we have to take it seriously. And I am for zero tolerance and termination. So when we discuss this, we'll have a more detailed discussion about it, but I want the onus to be on the administrative law judge to tell us that we must take someone back into our system. I don't want to leave employees in the system where we have had multiple students make complaints about sexual harassment. So I am asking you to please take this back and review it and bring it back to us in another fashion. So I'd like to make a motion to do that.
Second.
And that's a motion for Mr. Runcie to take this item and bring it back to us at the June 25th, or is that open-ended?
No, June 25th.
Okay. And it was seconded by,
I just want to check with Barbara. I mean, we'll do it June 25th, but if there's a need to read notice and stuff like that, I'm not familiar with the timeframes and whether that's ample time if there's any kind of a change.
I need to look at that. I think we
Yeah.
have to give 15 days notice. So if we can't bring it back on the 25th, we'll have to bring it back in July. I think the best thing to do is just to ask Mr. Runcie to withdraw this item from the agenda and to bring it back instead of making a motion to forward it, because that way he can bring it back a different item, and it would just be easier that way.
But he can't withdraw it.
unfortunately, he's already given us the agenda, and it's our agenda now.
Okay,
Isn't that the case?
I mean, that's the
Yeah,
way,
that's what I
that's the
thought.
way we've always
Okay.
understood it.
all right.
So,
It's late, sorry.
that's okay. Ms. Levinson has a motion, seconded by Dr. Osgood, that this item be brought back to us after review by the superintendent on June 25th, if possible, and if
If it
not,
can't, we'll provide written notification to the board.
As soon as possible, just bring it back as soon as possible, which
Okay.
we will.
And the only reason it can be that long is because school is not in session right now.
Right.
Yeah, we have to give them.
No,
we
but
would-
I'm talking about if school was in session right now, I would want it handled immediately.
Right, okay, I hear what you're saying.
okay. Any additional comment from any audience input on the motion? Seeing none, any comment from my colleagues? Ms. Good?
I also wanted to get follow-up on situations like this, and when accusations are made, the decision of whether or not an employee remains within the school while the investigation's occurring, especially when it involves students, I think is also a concern. So I would ask that we look at this particular case and also in the future how that's determined. I think it should be very heavily evaluated.
I'm working on a policy or an amendment to a policy for you all to, there's a couple legal things we're looking into, but for you all to give authority to the superintendent to suspend somebody without pay if it comes to before us on like one or two issues, sexual issues, child abuse issues, and drugs. So I'm looking at that, and I'm hoping to have it to come before the board, at least for a first reading this month.
Thank you.
Ms. Levinson?
I was just going to say that, that is, in my discussions with you and with the superintendent, to have it this month so that we can have our 2 readings and have it in place for the start of school next year, so that it's crystal clear what this board wants to do in those situations.
And because of that, and because we're working on this, the policy might come before you at the board meeting instead of a normal workshop, the first reading, but we would still go through all the readings, but it might not come at a workshop, it might come up for the first reading to a board meeting.
Thank you. I concur with you, Ms. Levinson, that it's important that we have that policy in place before the beginning of the school year to set the expectation. So thank you for those comments, and thank you for your motion. Any other comments on the motion? All those in favor of the motion to postpone this to the next meeting that's applicable regarding how much notice we have to have for the item coming before us again, indicate by saying aye.
Aye.
All those opposed say no.
Just point of order. I
Yes.
thought that we actually had to make a statement as to the date of it when we defer it.
We did, and I think we did the 25th, but if
Well, we did,
legally,
But then the chair.
Okay, the next
made
next
another
possible meeting
reference.
is the 25th, and then if we have to do something, then I guess we would do something again.
We
We'd
would
take
have to
another
do
action
something
then on the
again.
25th.
Postpone it again.
Okay.
Thank you.
Is that, everyone understood that was the motion, correct?
Yes.
Okay, thank you. May I have a motion and a second on item I-5?
So moved.
Moved by Ms. Korn, second by Mrs. Aladeff. Audience input on I-5. I had comments and Ms. Bartleman had comments.
I've been advised Ms. Bartleman got her answer, so she no longer has comment on I-5.
Thank you. And that's the right item. Did we already submit this?
Not yet.
Not yet, okay. So there are a couple of Scrivener errors, so I'm going to hand this to you when I'm done with my questions.
Okay. Thank you.
So in reading this, you know, one of the things that, I don't know if it's because I'm a parent of a female athlete, in reading this, I saw a lot of references to some of the things that schools will do to increase participation. And so what assistance do we provide the schools in accomplishing those goals? Because some of them were successful and some of them weren't for last year's goals. And so I'm just wondering what we provide to them in way of assistance to help reach those goals. Because for some schools, it's a matter of finding someone to coach. There are a lot of different things.
Valerie Wanza, sorry, I put a mint in my mouth. Trying to wake up. So, one of the things through the assistance of Mr. Sarah's office, working with Mr. Gillis and Ms. Hamilton, oftentimes, let's say a school is having difficulty securing a coach on campus. So then we will work with neighboring schools, do some advertisements to see if perhaps someone in a neighboring school has interest in coaching a sport. We're also working with the principals as they have freshman orientation. They do open house to really try and advertise and speak to all of the different sports activities, because we certainly, cannot have disparities. But one of the things that we're also cognizant of is in certain communities, certain sports aren't popular, so we are really working. And so Sean, Mr. Sarah is trying to help us with even looking at some of the parks and recs type things where students do participate, to see if perhaps they will bring that interest into the high school setting. I can just tell you, I swam in middle school. I did not swim in high school because I was concerned about my hair in high school. So.
Thank you.
You're
Thank you
welcome.
for sharing. And then the other thing, two other things that I wanted to mention. And so as we all probably realize that for many of our students, the ability to walk onto a high school campus and play a sport is very difficult, given the fact that in some schools, those students are coming with lots of practice through their community, and it's almost like they're club-level athletes playing against students who have never played a sport before. So I think that that's something that we probably have to look at as a district, and the way we schedule our games and our it's not interscholastic play, so that we can provide more opportunity for those programs to grow and not feel so defeated when they're playing those schools that are within their district, quote unquote, that the state sets, but still allows them the opportunity to grow those programs and get to a level where those athletes feel like they're able to compete. And then the last thing that I will say is that coaches matter. And so any opportunity that we have for providing professional development to coaches would be greatly appreciated in helping grow. And if somebody wants to have this, the pages are dog-eared. There's only 2 errors that I found.
We'll come get them.
Okay.
Thank you.
Thank you.
Thank you.
Ms. Partelman, are you on the line? Oh, she got her answer, Mr. Moquin said. Okay. Any other comments or questions on item I-5? All those in favor of item I-5 indicate by saying aye.
Aye.
All those opposed say no. Item I-5 passes unanimously. I didn't check II1. I don't know what I was thinking. All right. May I have a, Mrs. Aladev?
Yes.
Is it okay with you if I pull all, you said pull all of them together, correct? Items J1 through J6.
So moved.
Moved by Ms. Cord, second by Ms. Good. Audience input. Seeing none. Mrs. Aladev.
Yes. Thank you. So on J1 and all the other numbers that I called, I noticed that we are pulling out the fire sprinklers from the scope of work from the SMART bond. So with an abundance of caution, I want to ask Chief May that to make sure that we are following all the Florida rules as far as fire sprinklers and, because I guess we're trying to save money with the SMART bond, and that's why we're pulling them out of the scope of work, that we are making sure that we are following all of the rules.
Hi, Dr. Mary Ann May, Chief Fire Official. Yes, we are following all the code requirements for sprinklers and making sure that whatever we're pulling, we're not required to sprinkler, and those that we are required.
Okay, I remember a few months back, I think it was Marrow Elementary School, you gave a detail, like why, if it had this door. Could you resend that to the board?
Yes, I
As far as
can.
with fire sprinklers?
Yes, I
We
can.
can pull them out. Okay, thank you.
Thank you. Ms. Korn?
Thank you. As these are being pulled out, I had heard some information previously about possibly changing what our fire sprinkler specs are. Is that something that we're entertaining in doing this, other than what we've done in the past?
We have not worked on the specification as of yet, the district spec. Right now, we're strictly doing a code review on those buildings.
Okay, so we're not anticipating changing what our fire sprinkler specs are?
Not at this time.
Okay, thank you.
Any additional comment from my colleagues? All those in favor of items JJ1 through 6 indicate by saying aye.
Aye.
All those
Aye.
opposed say no. Items J1 through 6 pass unanimously. May I have a, well, actually, let me, let's do the L items really quickly, and then we'll do the JJs. May I have a motion and a second on items LL1, 2, and 4?
So moved. Second.
Moved by Ms. Korn, second by Ms. Good. Audience input on LL1, 2, and 4. Colleague input. All those in favor of items LL1, 2, and 4 indicate by saying aye.
Aye. Aye.
All those opposed say no. 1, 2, and 4 pass unanimously. I have a motion and a second on item LL3.
So moved.
Moved by Ms. Korn, second by Mrs. Aladev. Audience input on LL3. Seeing none, Ms. Good?
Yes. So,
All right, I apologize to staff that you were settled there, but I just figured we have to do a closed door and it'd be easier to do this.
Sure, we'll hang out with Ms. Brown.
so I guess, I know it's late, but with the ROCKS program, I guess some of the things that we were gonna be doing is revisiting some of them as the terms ended, whether or not they were still necessary, or maybe that we needed to have them relocated. But what concerned me about this one is that the ROC officer that was there before without an agreement, and he got an agreement with us, and then he went ahead and sold his trailer to this person, and now this agreement's before us, and it starts today. I'm almost positive. I thought it was this one. Let me see. Yep, it starts today. So, I mean, I'm concerned on a multitude of levels. What are we gonna say? Now that if we renew this, and this is only through 2020, which is, I guess, when a bunch of the other ones expire. But it puts us in a real predicament, because now this officer is there, bought the trailer, and now we're caught between a rock and a hard place,
So thank you, Ms. Good, for the question. Through the chair,
if I may. Okay. This has been a process that we have been going through for the past 6 months. We did get notification that the prior ROCS officer was going to leave. We followed the process that we worked on with the board for looking for a replacement officer when somebody was going to leave. So what we did is we worked through SIU. In our process, we actually asked SIU to work with the municipality first to see if there might be an officer that from the jurisdiction that's around the school might be interested in it. It expands out a little bit more to the county to find a ROCS officer for a replacement within that 3-year period that the contract is running. We did get notice, and you'll see on LL2, that is the termination. That's why we brought them together, so that we wouldn't have an overlap or a lapse of the services at the school. We worked with the principal, so we did have a recommendation from SIU for this particular officer before we even allowed any kind of consideration for a sale of a trailer to another ROCS officer. So what we did is we took the candidate that was that had asked as an interest, again, met all the criteria of SIU, actually interviewed with the principal at the school, and we included to make sure that there was a good fit at the school as well as through SIU. We confirmed with Mr. Runcie, again, as the whole process, so that we would not kind of have a gap in those services at the school. And then along with the same time frame that we had with the last time that we brought these, you're absolutely correct. The contracts are up in, I believe, February 17th of 2020. So this contract is only for the period till the end of this particular 3-year contract.
I understand, Ms. Brown. What I'm saying is I thought we had discussed the opportunity to revisit these when an officer was to leave the campus and determined a need to have another one there. So I guess I want to understand, how did that happen? Who had the conversation with who to say that we still needed an officer at this location? I don't know which location it is because it wasn't shared with us.
Sure.
But more of a concern is the transaction to buy the trailer took place and the agreement's before us and it starts today. So really, what other action can this board take today but to approve it? I mean, what?
So one of the opportunities that staff was working on was bringing data on the entire ROCS program back to the board and an opportunity to determine whether or not the ROCS program would continue across the district. That is how we have been proceeding. If we were working with the principal and the data that SIU has been collecting on reports, which come in monthly to SIU, to see if there was a need for a ROCS officer to continue at an individual site. And I can only apologize. We thought that interpretation of an individual was a part of the process that we set up for vetting somebody that could replace a ROCS officer. If the principal at the school found no need for the ROCS officer, SIU also found no need for the ROCS officer at a site, that decision was made for one site already where that agreement was terminated. This one is a transfer from one person to the other, and the intent is to come back to the board on the ROCS officer program overall under the new direction of Chief Katz. We have been discussing this with Chief Katz as far as what his perspective is on having another set of ears and eyes holding a weapon on a school campus. And that's something that we also have been working on together to be able to see the next steps that the board might like us to take with the ROCS officer programs in general.
So these agreements end February of next year. So when is this coming back for review before the board?
Well, we've been working with Mr. Katz again, there's a lot going on right now in that area with him ramping up. What we're doing right now, the real estate team, what we're doing right now is we're working on this agreement and making sure, and not this particular one, but the actual template for the agreement to see if we're going to move forward or not, making recommendations for changes in that template based on findings that we've had over this last agreement, and working with Mr. Katz and SIU on what some of the next steps might be. So I don't have a date specific as to when we'll be coming, but that is part of the process before we come back with any recommendations for, what shall we say, renewing for another 3-year cycle for any of the ROCS officers.
So, Mr. Wincy, we're going to ensure that we have a look at the ROCS program, find out, again, if there's other sites that could benefit from it, if there's some sites that don't benefit from it. I mean, this was part of a larger conversation that we had when these came before. But what would happen if the board voted no today?
We would have to ask the new owner of the trailer to remove the trailer that he now owns. That's a
And
part
he's
of the
already
contract.
but he's already living there.
Doesn't matter.
I'm just saying, to bring this before us today and the agreement starts today really is a disrespect to this board. And I don't think that that's how they should be brought forward. There may be circumstances that cause this to come to us this late of the game, but to have something come before us the same day that it's supposed to be, and something like this, where if we vote no, it has implications to the school site, I don't think it's fair to this board. And I would ask that this not occur. So, thank you.
Through the chair, I apologize. That was not the intent. The intent was, again, hindsight is always 20/20, and I appreciate the respect to the board. It's certainly something I feel very strongly about. Our intent was to make sure that if somebody was terminated, that we brought it together. In the future, we will bring anybody new to the board prior to any termination of a prior SRO. My apologies.
Mrs. Aladeff?
I'm struggling with this. So you're telling me that we have a mobile home on one of our school campuses?
Oh, yeah. No, this is. Can someone
what?
meet with Ms. Aladeff?
We have a what?
We have one at Stoneman Douglas.
We have one in Stoneman Douglas. We have 27 trailers that are owned by officers that we do a ground lease with. This was set up many years ago. We inherited it, and the team has done a really good job in making sure that at least they have leases that will become due on February 17th.
And they live on our school campus with their family?
Yes, they do. It is a ground lease agreement that the board approved in 2017.
And in how many schools is this?
27.
27 schools.
Yes, ma'am.
Someone needs to let
No
me know what it's all about.
Any additional comments? Seeing none, all those in favor, I'm sorry, I lost my page, of item LL3 indicate by saying aye.
Aye.
All those opposed say no.
No.
Item LL3, Mrs. Aladeff said no. Item LL3 passes. Okay. So I think what we'll do is we'll do the JJ items all the way up through JJ10, then we'll have a closed door, and then we'll complete the agenda. Well, let me just check with Mr. Mokran. Is that correct? With that? Okay. Now let me look at who's asking to speak about what. Where's that one out? Where's that one out?
We did all the LLs, right?
We did. Okay, so that only leaves me on items JJ 1 through 9. May I have a motion and a second, please?
So move.
Second.
Moved by Mrs. Korn, second by Mrs. Aladeff. Audience input on JJ's 1 through 9. Seeing none. Hold on one second.
You did.
I did have a question.
2 of them.
JJ,
You had 3, 2 and 7.
JJ 2, oh yes, JJ 2. Okay. Yeah, I marked those people off, they're not here. Okay, so on JJ2, really quick question. So this line item that we have now with the double asterisk, construction miscellaneous, how is that calculated? I was looking at the different, it was on a lot of these, and I was looking at the different amounts.
I'll start and then hand it over to Ashley Carpenter. Frank Girardi, task assigned Executive Director, Capital Program. This chart was put together more or less under using the PFA that we use for budget. And there's line items in the PFA which are off-site improvements, miscellaneous construction. These are all the items that have some dollar amounts in it, but do not really affect what we're talking about on the needed money, on the needed funding. And what I'll do is Ashley has been handling all the PFAs, so I'll let her explain it a little bit better.
Thanks. Ashley Carpenter, Atkins Cost and Program Controls Director. So, yeah, you're not going to see across the board the miscellaneous construction line be the same or be able to really pin it down to a percentage or anything, because it is so dependent on the project. In this particular project, JJ2 Forest Glen Middle School, there is money in there for a PPO work order that has already happened, and it was related, it's smart scope, but it was a chiller that was replaced earlier in the program, and it's been in the BOC reports and all that as well. But so this construction miscellaneous includes utility and permitting, and then some type of sort of contingency, I guess, for other miscellaneous construction going forward. So there might be another FM work order of a small amount that needs to be done at some point, or there might be some miscellaneous contractor that has to come in for some reason. So that's a small.
And if there's any off-site work, that'll be included under this miscellaneous item.
Right.
Okay.
It's really taking all the small little bits and pieces of the PFA and just bundling, telling you what's included.
Okay. And then my other question was on JJ7 and.
Can I make one more comment
Sure,
on
make another
JJ2
comment.
before we move on?
Yep.
During our time this morning going through our items, we found a mistake on JJ2.
Great.
And we'd like to clarify that right now. I don't think it's what you might think it is, but I'm interested.
Okay.
But I'll say mine first. During the process of design, this was one of the projects that a lot of the sprinkler work was removed from the project. Just recently, we found out that building number 2 needed to have sprinkler work. The project was already bid out. We're gonna do that as a separate item, almost like a carve out. We'll just have the sprinkler done by itself through an open-end vendor as a design build. The problem is on the executive summary, it says it's included in this project. It is not included in this project. So we have to make a revision to this executive summary. It was accidentally put in there that it was part of this bid when it was not. It was just added 3 weeks ago. And that's why we want to do this as a separate project. Again, it's a perfect idea, it's a perfect situation for a design build. But Chief May is also looking at this and some other ones to maybe bring something else forward. So I just wanted to correct the executive summary.
Okay. So, okay, Ms. Levinson has a question, I think.
With that comment, mine, JJ2 you said, right?
Yes. Is it JJ2 or is it? Yeah, it is JJ2.
Yes.
Make sure I had the right one.
So what are you saying?
We inadvertently put in the executive summary that the fire sprinklers for Building 2 is part of this bid, and it was not. It wasn't added until after the project was put out to bid, so we have to do that as a separate project. So this does not include the fire sprinklers for Building 2, but it was put in here that Building 2 is included in this.
So how
Which
much
it's
more
not.
is that going to be?
How much more? We were trying to find that out at the last minute.
It's probably in the range of $500,000 to $600,000 is what the architect estimated on this one.
Okay. My comment was not on that. My comment was actually on the fiscal impact. You have here that funds, the difference in the funds is 3,858,800,
Correct.
and it's 3,874,800. So does that need to be?
We will check on that, and yes, if there's a revision needed there, we'll make that as we do the revised executive summary.
I mean, that's the difference between the two numbers here. So. And then the same, and then on JJ1, just the revised budget on the executive summary says 4303, it should be 4306.
We will take a look at that. We apologize for that if we'll take a look.
So do we need to change that? I mean, one of them, Ms. Myrick, is the financial impact. The amount, the funds that are needed, that it will come from the capital projects reserve. It's a difference of $16,000. But it should match, correct? JJ2.
They should match, so we would just make a motion that they, do you know which one's right, which one's wrong?
Ashley, did you check it?
I'll check
Sorry.
it. I will check it. No. Do we need to say it before we vote? Before
Yeah,
you vote?
because I'm going to
Yes.
make a motion right now.
Okay.
The problem is that it says 5173 on the agenda, and it says 5189 on the executive summary. So probably the 3858 is correct now. It should be 5189, which that will not impact what's coming from the capital project reserve. So the 5173 should be 5189.
It should be 5189.
So
Yes,
I
that's
don't,
correct.
probably I don't need to make a motion for that, Ms. Myrick, because the amount that's coming from the capital project reserve is correct. The mistake was in the other number.
You're
So I
correct.
don't need to.
You're correct, right.
Okay.
And with regards to JJ2, we will just submit the revision on the executive summary, the normal way we do that.
Okay. Do you have any additional questions, Ms. Levinson? Nope. Okay, so also on JG2, my question was where it notes that additional square footage of roofing is indicated as not identified. What does that mean? Like the roof was not included, period, in the review, or the roof was not identified as in need of repair?
In the MAPS assessment, it identifies buildings with an appropriate square footage, but when we actually get into doing the design, the building can be significantly larger than what was identified in MAPS. And so on a building-by-building cases, we look at what was originally in MAPS and what's now actually going to be roofed. And on this one, there's a difference of over 28,000 square feet.
Or no, I saw the number. That's incomprehensible to me. That's why I was asking, did I like miss an entire building?
No.
Or they just calculated it wrong?
They calculated it wrong.
Calculated it wrong.
Okay, I have nothing to say about that. On JJ7, I mean, I have lots to say, but I'm not gonna say anything about it right now. JJ7, I have a question. So where it says the fixed limited cost of construction increase resulted in an increase to basic service fees?
Correct.
So is that because we're projecting that it's gonna cost more? Help me understand what that means. If it's quick, if it's not quick, it can
It's
be in a
quick.
follow-up.
It's quick.
It's already gone to
Very
bid. We know that the fixed limit of construction costs went up.
Okay,
That is one of the contracts that the final number is what their percentage is.
okay, okay. Any additional questions on JJ 1 through 9? All in favor of JJ 1 through 9 indicate by saying aye. Aye. All those opposed say no.
Aye.
Oh, let the record reflect, Ms. Bartleman is on the line.
I was able to listen to all the DJ items. Thank you.
So unfortunately, we have come to this place in the meeting where we have to do a closed door before we talk about these items. So we're going to have to clear the room for the closed door for those who are not part of the closed door. That would include the people with Beacon. And how long do we anticipate this is going to take? Mrs. Levinson just said a quick closed door.
It shouldn't be that long.
Okay.
We just want to explain the different,
So we'll say 10 minutes is what we'll say.
10 to 15, I would think would be fine.
Okay,
Let's say 10.
let's say 10. So 10 minutes, and the meeting will reconvene at 9:43. Good evening.
There you go.
This school board meeting is now reconvened. And just for everyone, who's on the line, please?
I am.
And
Robin.
Who's I am?
please state your name so I know who you are.
Robin?
Thank you. Ms. Bartleman is on the line. Ms. Korn, are you on the line?
Not yet.
Give us 1 second and let's see if they're having technical difficulties because they told us Ms. Korn was also on the line.
I am on the line.
Thank you, Ms. Korn. I appreciate that.
Thank you.
Okay. So at this time, I will entertain a motion for item JJ 10,
All three.
11, and 12.
So move. Second.
Moved by Dr. Osgood, second by Ms. Good. Audience input on items JJ 10, 11, and 12. Seeing none. Board member comment on items JJ 10, 11, and 12. All in favor of items JJ 10, 11, and 12, please indicate by saying aye.
Aye. Aye.
All those opposed say no. Items JJ 10, 11, and 12 pass unanimously. Mr. Moquin, I think there is no further business to come before this board. This school board meeting is now adjourned. Thank you all.